Good afternoon. Today is Thursday, February 19th. This is a hearing scheduled for the Judiciary Committee. I'm going to call the first bill, HB 563, Delegates Baylor.
Can I bring up my panel?
Yes, bring your panel. You may start.
Great. Good afternoon, Madam Chair, members of the Judiciary Committee, the best committee in Annapolis. Thank you. For the record, I'm Delegate Dylan Baylor. I represent District 30A right here in Annapolis, and I respectfully request a favorable report of House Bill 563. This legislation would clarify the definitions and penalties for intentionally harassing, interfering with, injuring, killing, or causing serious physical injury to an emergency response animal. Our emergency response animals are critical partners in our state's emergency response work. These animals are highly trained professionals that perform vital tasks like finding missing people, detecting explosives, and protecting officers and civilians when they're in dangerous situations. And because of that, public safety in some cases can depend on them. If such animals are distracted or injured, a missing person may not be found in time, disaster survivors could be missed, or a suspect may escape. Today, you will hear examples regarding the critical nature of their work as law enforcement and search and rescue that these animals provide, and also some specific instances of occurrences that exemplify the need for this bill to provide a more comprehensive approach to their protection. More specifically, to better protect our emergency response animals, this legislation would do a few things. Firstly, it would repeal the current felonious prohibition on the intentional infliction of bodily harm, permanent disability, or death on an animal owned or used by a law enforcement unit, and instead expand the current definition to include not just law enforcement animals, but also search and rescue dogs trained and directed by government to locate individuals. It would also create new misdemeanors for the intentional harassment or interference with an emergency response animal during the course of their duty, for the intentional injuring of an emergency response animal, and for the intentional killing or infliction of serious physical injury to an emergency response animal. And it would create a new misdemeanor if an individual intentionally injures, harasses, or interferes with an emergency response animal during the commission of a crime. Once again, I respectfully request a favorable report of House Bill 563 to provide a more comprehensive approach to the protection of our emergency response animals for the vital partnership and the role that they provide. And on your desks, I gave you some cards from some of the dogs. And we're joined here today by two amazing animals. And with that, I'm happy to turn it over to my panel.
Good afternoon, committee. I'm First Sergeant Brian Gill with the Maryland State Police. I'm the president of State Law Enforcement Officers Labor Alliance, which is the exclusive representative for 1,700 active sworn law enforcement officers in the state of Maryland, which includes the Maryland State Police, Natural Resources Police, fire marshals, Maryland Capitol Police. This House bill defines emergency response, includes search and rescue animals, clarifies penalties and acts against both law enforcement and search and rescue animals. Loyola supports this proposal as its efforts specific to protect the animals that face the same risk that law enforcement officers do and are often the first ones sent into a dangerous situation as they protect their human officer and people of the community they serve. Maryland State Law Enforcement agencies use highly trained dogs for detection of narcotics, explosions, cell phones. They also use them for tracking, apprehending, and locating missing persons. With Maryland State Police and the Maryland Correctional Facilities having significant units employing breeds such as a Belgian Malinois. We have a lab here today with us, Dutch Shepherds. They're all drive and trainable animals. These emergency support animals support state law enforcement, federal agencies, and require specific licensing, serving roles for correctional facilities and roadside interdiction. These are numerous examples that there has been numerous examples of individuals have intentionally tried to harm or interfere emergency response animals. There's been cases with both Maryland State Police and I have Corporal here will explain his a little bit better. Garrett County Sheriff's Office, Montgomery County, Prince George's County, and to finalize, the State Law Enforcement Officers Labor Alliance would like a favorable report on this bill, and I'll turn it over. Thank you for your time.
Thank you.
Good afternoon. My name is Justin Foss. I'm a corporal with the State Police. I'm currently assigned to our Special Operations Division Canine Unit. I've been with the Maryland State Police since 2006 and a canine handler since 2012. I'm currently assigned my 5th and 6th working dogs. Buddy is a 2-year-old Belgian Malinois. He's a narcotics detection canine, currently being cross-trained in patrol and utility work. And I have Colonel here with me today. He's a black lab, trained in explosive detection. I'm here today to testify in support of this bill, House Bill 563. Specifically to him, in December of 2024, while working an assignment at the Baltimore Ravens home game at M&T Bank Stadium, an incident occurred where Canine Colonel and I were deployed on Ravens Walk. Part of his job is to detect trained explosive odor on moving and static targets. While working on Ravens Walk, an extremely intoxicated individual came up behind him and actually smacked him on his rear end. He kind of turned his body, kind of looked at me. We were able to, 2 other uniformed police officers were able to stop the subject. We had him detained for a little bit, but it was ultimately determined that there was really nothing to do, nothing we could do about it. Although no specific significant physical injury did occur to Colonel at the moment, workability for us is always a concern for future deployments. Should Colonel be afraid of people or afraid of crowds, we would have to attempt some remedial training to address that problem. The state of Maryland invests in excess of over $30,000 to procure and train these dogs. And if remedial training fails, that's an extremely valuable resource that we're no longer able to use. Our canine teams across the state work everything from missing persons to bomb threats and every other call in between. It's important that we advocate for our canine partners every way we can, and this bill gives some protection and holds those accountable for those making the decision to interfere or assault a law enforcement canine. For those reasons, we respectfully request a favorable report on House Bill 563.
Thank you. Next.
Good afternoon, Madam Chairwoman and members of the committee. My name is Gregory Miller. I'm an operational canine handler with Scout here with Chesapeake Search Dogs, an all-volunteer, nonprofit search and rescue team based here in Maryland. I'm here today on behalf of the handlers and, more importantly, the dogs who find lost and missing Marylanders. Search dogs do not understand the laws protecting them or why someone would wish them harm. What they understand is training, trust, and a simple task. Find the person who is missing, the person who needs help. When a child goes missing, when an Alzheimer's patient wanders from home, when someone doesn't make it back from the woods, it's these search dogs who are called out by Maryland law enforcement and fire departments to find the missing. The reality is these dogs are asked to work in dangerous areas, in darkness, around unpredictable people and unknown hazards. They work through exhaustion, hazards, and danger because they are driven and trained to complete their tasks. They protect our communities and find the lost, giving families answers and allowing victims a chance to come home. And yet, under the current law, these working dogs are not adequately protected from interference with their duties, deliberate harm, or even intentional killing. Protect the dogs who protect Maryland's lost and missing. That is the heart of this legislation. Interfering with a working search dog doesn't just endanger the animal, it delays rescue, jeopardizes victims, and puts handlers and emergency personnel at risk. Injuring or killing a trained search and rescue dog destroys years of training, thousands of volunteer hours, and a vital resource that cannot be quickly replaced. Strong legal protections tell volunteers that Maryland values their service and that the dogs who stand between life and death are worth defending. This bill sends a clear message. Maryland will not tolerate harm to those who serve the helpless. On behalf of our handlers, our dogs, and the people they rescue, we ask for a favorable report under this bill. Thank you.
Thank you. Colleagues, any questions for this panel? Delegate Moreno.
Thank you. You guys only talked about dogs, but there's also horses in there. Does anybody want to address also, protecting the horses?
So a few years ago, I know there's still Ocean City Police Department still uses them for crowd control and large events. I do know that there was an incident in, I believe it was in Prince George's County during a riot type situation where their horse was actually struck by one of the students that caused some injuries. So we did add other animals besides just the dogs, because there is other animals that work in law enforcement.
Yeah, and Delegate, if I can just add one thing, we will have an amendment coming after working with the search and rescue folks as well. They also use horses in the course of their duty, so we'll have an amendment to expand the search and rescue dog to also include horses there too.
Okay,
We tried to bring a horse in today, but Hunter didn't let us.
Yeah. He doesn't like to let us have fun.
Okay, I have a question.
Yeah.
You're removing the section that accepts self-defense. You want to talk about that?
Yeah, so right now in current law, there is a felony, and that's on page 3 of the bill. So that's except in the case of self-defense, that an individual who intentionally inflicts bodily harm, permanent disability, or the death of an animal owned specifically by a law enforcement unit. So we get rid of that felony. That would fall under the aggravated cruelty to animals penalty. And instead, what we're doing with this bill is we're removing that and we're adding 2 separate misdemeanors, one for the interference of one of these animals, and then 2, the intentional, firstly, the intentional harassment or interference with an emergency response animal, and the intentional killing or serious physical injury to an emergency response animal. Does that answer your question? Sorry.
Are you removing self-defense as a defense to this in your bill?
I don't think so.
Yeah, it looks like you are. Okay.
No, I don't believe so. If there was a drafting error, I'm happy to have that clarified.
Okay,
Yeah,
thank you.
Thank you.
All right. Delegate McComas.
Thank you, Madam Chair. Just a real quick question. You indicated that it costs about $30,000 to train the dogs. Does that include all of the training for each type of dog? You know, the search and rescue is one type of dog, the explosives the other. I mean, does that include the time that it takes for the trainer to train, or is that just? In other words, I just wondered if it included both, the dog, the trainer, and all that.
The number used there is an approximate amount to procure the equipment for the dogs and the man hours to get them trained. Specifically for law enforcement side, it would all be relatively similar. The dogs themselves cost similar amount, and all training classes are between 12 and 18 weeks.
The other quick question is, what if somebody would intentionally harm the dog? Like, you know, let's say it's a really bad hombre and they shoot the dog to get away or whatever. I mean, it seems like, would that be still a misdemeanor?
Under the proposed language of the bill, yeah, it would be. But there is I don't want to use the wrong I'm not a lawyer, but it adds, there's an additional misdemeanor if somebody commits the penalty or commits the crime in the course of conducting a crime. So if they were to intentionally, murder a dog or kill an animal, if they do that during the course of a crime, then it would be, there's an additional misdemeanor in the bill.
Okay, thank you. Thank you.
Thank you. No further questions? Oh, you do. I'm sorry. Delegate Valentine.
Thank you, Madam Chair. And thank you, Delegate, for bringing the bill, and thank you for the entire panel being here. I was trying to get the definition on page 3 of the bill as it pertains to law enforcement, because I was trying to determine if that's considered, and I've just asked counsel as well, if that would include our state's attorney's offices. And the reason I ask that is I know there's at least one prosecutor's office in this state that employs trained dogs that they take out in the field in search warrants and things of that nature for computer crimes and things like that, detection of different devices. And if that is not included in this, would you be agreeable if I were to propose something like that to include our state's attorney's offices that have specially trained dogs that go in the field?
Yeah, absolutely.
Okay, thank you.
Yeah, for sure. Thank you.
Okay, seeing no further questions, this concludes the hearing on HB 563. Thank you, gentlemen, for being here.
Thank you.
Thank you.
Next, we have Delegate Ruff, HB 776.
Good afternoon, Madam Chair. My panel is coming. They're in the hallway.
Oh, great.
And thank you for the courtesy for allowing our panel to appear before this committee. I'm going to go ahead and get started while they are on their way up, if that's all right.
All right, and I see Delegate Senator Carter, Nonette McCray,
Oh, you
Raynard
get the microphone.
Parks.
That's good. We do have our esteemed Senator Emerita from the 41st District in the House today, former Senator Jill P. Carter, and very pleased to have her on my panel. So may I begin?
Yes, you may.
Thank you. Good afternoon, Madam Chair, and to, as I've always said, the hardest working committee in the House of Delegates, the Judiciary. I am Delegate Malcolm Ruff, 41st District in Baltimore City, here to present, along with my panel, House Bill 776, the Nikayla Straughter Memorial Act. I believe you all have heard this bill at least twice, and you all may remember that Nikayla was a precious 15-year-old child in my district, in Emerson Village. She was shot and killed in August of 2022. Such a terrible tragedy, which was made even more tragic by the fact that her killer was a 9-year-old little boy who found a operative firearm that his grandmother owned in his house and took it and unfortunately committed this terrible, terrible incident. And there's no words that can absolutely capture the pain that the Straughter family has experienced and continues to experience to this day because of that incident. You'll hear a bit from Mr. Raynard Parks, who's to my right, later in this hearing. But instead of asking for revenge, they asked for responsibility and reform. They asked for us to fix the gaps that exist in our system under this circumstance. And so the system, when a child of under 13 years old commits an act that results in a death, there's currently too much discretion that permits an officer to not take action and also permits the child to be overlooked and ignored and not treated properly based on the circumstances. It leaves a gap where families are having questions that are unanswered, children that have no support, and communities without assurance for safety. So this bill does two things very clearly. It requires a law enforcement officer who makes a complaint about a child under the age of 13 committing an offense that results in a victim's death, that they must then forward that complaint to the Department of Juvenile Services for what the bill says appropriate action. That appropriate action is the second thing that the bill does, which is it requires the intake officer of the Department of Juvenile Services to file a petition that the child, the assailant, is a child in need of assistance. And so what does that mean? I've had a chance to kind of go through what the SINS process is, but at the base of it, it requires the intake officer to conduct what's called an inquiry, but really it's an evaluation, it's an assessment of the situation for us to take a second and say, does this child need guidance? Does it need treatment? Does the child need rehabilitation? Is the child a danger to themselves or to someone else? And how do we create the wraparound services, the programmatic scheme that would allow that child to move forward powerfully? So just in closing, this is not about punishing a child. This is about preventing these things from happening and also ensuring that everyone on all sides of the incident gets services that they need, especially victim services. Mr. Parks will talk about the lack of victim services that their family received, and also the thoughts that they had about this young man. I would ask respectfully that we owe this to Nikayla, to her memory, to have a favorable report on this bill. And with that, I would pass off to the rest of my panel, and I'll start with Mr. Parks, if you don't mind, Madam Chair. Thank you.
Thank you.
If I may, before y'all start my time, peace everybody. I just want to make a correction for the record that my official name, and a good name is better than gold, is Bolun Zahir Shiamaru. All right. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Bolun Zahir Shiamaru, and I am here today representing the Straughter family. I am here to urge a favorable report on HB 776, which mandates SINS intervention for youth involved in firearm-related tragedies. When my family lost Nakayla, she was killed after a 9-year-old gained access to an unsecured firearm in our neighborhood. That moment did not just take her life, it fractured ours. Her siblings began having nightmares, endless questions, school struggles. Her brother Junior has faced behavioral changes since that day. This all has begun from minor kid issues between children, issues that escalated because a firearm was accessible and reportedly flashed around the neighborhood before Nakayla lost her life, of which I told you all I tried to integrate myself before that happened. While grieving, we were suddenly navigating state's attorneys, elected officials, media coverage, and even encounters with the other family. We were trying to protect our children's mental health and while living through public trauma. There was no automatic structure ensuring evaluation, counseling, or coordinated support. Everything depended on discretion. It got so bad that even the mayor called all parties to the tables because we just weren't getting any help. Mandating SINs ensures that when a child gains access to a firearm and serious harm occurs, there is a structured review. It ensures mental and emotional evaluation. It ensures services and assessments for both families. It ensures there is paper trail and accountability moving forward. These cases should not depend solely on the intake officer discretion. They should be reviewed thoroughly and treated case by case. This bill has already received unanimous support before. It stalled due to politics and not policy. And I'm so glad not to see the person sitting in front of me right now. Nakayla's legacy should not be division. It should be about remedy, about prevention, about making sure that the next family has infrastructure that we did not. As a family member, a youth advocate, and someone who hopes to raise a family one day, I urge a favorable report on HB 776 so that when tragedy strikes, the system responds with mandatory structure, services, and accountability. Thank you for your time.
And Madam Chair, before I pass it to Senator Carter, I did want to just mention one thing that yes, the Senate has passed this bill twice. I think Senator Carter will touch on that. We have to also shout out Donyette McCrae, who was the guardian and aunt, great aunt of Nakayla Straughter. Unfortunately, she was on a flight to come back here to make sure she could be here, and she got stuck on a plane delay and is unfortunately unable to be here, but I know her spirit is permeating through this room on this bill. So thank you, and I'll pass it off to Senator Carter.
Thank you.
Thank you, and good afternoon, Madam Vice Chair and House Judiciary Committee. It's an honor and a privilege and a delight to be before you, especially you, Madam Vice Chair. It's a pleasure to see you in the seat. For those of you that don't know me, for 14 years I sat in the seats where you are in the House Judiciary Committee. Quite an experience in education and also quite a tremendous responsibility that you have. I respect the work that you do and appreciate you all. The only person I think that was here is Delegate McComas and Lauren. Lauren, the forever counsel. So a few things I want to just add to what's already been said. And the House bill, the Nakayla Straughter Memorial Act passed the Senate unanimously twice. It came to the House. The first year, it was stuck in this committee. It didn't get a vote. The second year, it came out, and then it got kind of caught up in some delays on sine die, and it just didn't make it across the finish line. So I don't think there was ever any policy adversity to this bill. To my knowledge, everyone has supported the bill. When Nakayla was killed, I reached out to the family, Ms. McCrae Balone, who is here, and others, his father. And this is a family with very good ideas, and they felt that they wanted to do things to make this significant so that other children would benefit, would not be as traumatized. And when they were traumatized, there were results. And so in the spirit of the late, great Jesse Jackson, I'm gonna rhyme, trauma untreated is trauma repeated. All this bill does is mandate SINs. When a child gets hold of a firearm, and they discharge that firearm and harm results. We've had repeated incidences since Nakayla's tragic death. It hasn't always resulted in death, but it is critically important that we don't only seek to punish the child or the person that's possibly responsible. I promise to be brief and wrap up. But that we treat the child When a child gets a hold of a gun, there's a reason, there's something missing there. And CPS may not pick it up, and SINA may not pick it up, but this would mandate that that child gets the treatment that they need. And so to me, it's a no-brainer. And again, even the colleagues on both sides of the aisle passed it 2 times in the Senate, so I'm asking for a favorable report for not Kayla, but for all of the children in this state that are dealing with trauma and access to firearms and gun violence.
Thank you. Colleagues, questions? Delegate Simmons?
Thank you, Madam Chair. And thank you, Delegate Ruff, for bringing this legislation. Obviously, we know that this is a battle that we continue to fight here in the General Assembly and throughout Maryland. 3 weeks ago in Freetown, my district, a 7-year-old brought a weapon to school and discharged it upon himself, but it could have struck other children as well. So it is an ongoing and serious matter. To our distinguished senator, thank you for coming back and offering up your knowledge, your institutional knowledge to us. Can you talk a little bit more about the Senate process and some of those gaps in services that are taking place that you saw then and continue to see now, and what more that we should be doing to address it?
To the extent I can, yes, and I was touching a little bit about why would this bill be the appropriate bill to fill the gap that exists. And the reason is, when something like this happens, there's generally going to be, to the extent it's public, a CPS investigation or a CPS inquiry, and there may be even a CINA, Child in Need of Assistance inquiry, but that's not a guarantee that anything's going to happen. If the authorities find that the child has not been abused or neglected, then that ends. There's no CINA. But my position and the Strotter family position and Delegate Ruff's position is that when a child gets a hold of a gun and uses it, then there ought to be a mandated intervention with trauma treatment, with education on the power of a firearm, and more further inquiry, mental health services to help that child recover. In a case like this, I don't personally know the 9-year-old in this case or the 7-year-old in your district, but the aftermath of their actions are going to have results on that child. The fact that it's public and the world sort of knows you took this gun to school, you discharged this gun, even though in your situation harmed himself, which happens quite a bit. It's important that we make sure we make that child whole and treat that trauma, because so that they can move on and realize their potential in life and not be stuck where they were with the horrible thing. Kids carry tremendous guilt when they do things, and our goal should be to help them overcome the circumstance and move on to become full adults.
Thank you. Madam Chair, Madam Woman. Yes, ma'am. So, Delegate Ruff, I know you're doing a lot of work around this. Can you speak to any of the data that's related to how bad this problem is, and what are some of the things that you're seeing as well, not only in your district, but throughout the state?
Well, I think we only have to look. I think Senator Carter just showed me an article, and you just told me about an incident that happened in your district, that we're looking at these laws across the board on, number one, how to prevent kids from finding these guns, and from preventing people from, putting them in places where they can be found, but also knowing that this is a serious enough issue that we need to make this change. And I think this same change has been made to this statute around motor vehicle theft for kids of this age. So it's prevalent enough that just like we see, that there is occurrences, not something that's an astronomical number, but I would say that in the hundreds of kids, based on the fiscal note, have been charged under the age of 13 for serious offenses, and a small number of them would then be subject to this process. But we need to ensure that those are the kids that are the most at risk, right, that have been involved, just as Senator Carter said, in something that is extremely traumatic. I mean, imagine how that is imprinted on a child's brain when they take someone's life. either intentionally or haphazardly, or in this case, we're not even sure if this young man understood the gravity of what he was doing. But the gravity of what he did and its permeation to the future is really what we're trying to mitigate, and why I think and why we all are here advocating so strongly for this this augmentation to the statute, so that we can get kids the services that they need. And we should all agree that especially kids of this age, especially a kid of 9 years old, really we need to make sure that they're getting services. That it needs to be our #1 objective. Thank you.
Delegate Phillips.
Thank you, Madam Chair. And thank you, Delegate Ruff. Thank you, Brother Ballone, and thank you, Senator, for being here. I serve on the Commission for Juvenile Justice Commission for Best Practices and Reform. And in that, we keep talking about the different routes for the Juvenile Justice Department to get involved in these matters. And one of the routes that has not been used, in my opinion, often enough is SINS. So I thank you for bringing that. Have you had any discussions with DJS about SINS and the SINS process and how this might work? And maybe, Senator, over the years you've worked on this. Any comments about the department and what they're doing with the SINS process?
So I don't have updates on what the department is doing, but I know that the new secretary, Betsy Fox Tolentino, has sort of a renewed commitment to making SINS effective. But when I put this bill in, I did so after talking to DJS and sort of getting their buy-in that this was a right process for a child in this situation. At the time of this, 2022, we had just passed the Juvenile Reform Act, and even though there were media inquiries about, is this child going to be prosecuted, a child under the law could not be prosecuted. And so the only real avenue to address that child would have been SINS. It did not happen to my knowledge, so this is a child who slipped through the gap. But hopefully we can get more children in the future.
And Delegate, just so you know, I actually have a meeting on the books with the acting secretary next Tuesday, and this is definitely a part of our agenda to discuss this bill.
Well, I thank you for bringing the bill over yet again, and hopefully we will figure out how the House does not hold up the good work of the Senate. So thank you.
Amen.
Thank you for that.
Thank you. Delegate Valentine.
Thank you, Madam Chair. Thank you, Delegate, for bringing the bill. And I'm looking at last year's version from the good senator in SB2 that we voted unanimously out of the House. Is this legislation in the exact same posture as that? Has there been any changes?
There is a slight change. And the only change is that we took the word delinquent out of the bill. You might have noticed that. And it's just because it's redundant, because at the end of the day, we want to force the SINS process, and at the end of the process, at the end of the evaluation, one of the options is this child, there's no service that is necessary or that is capable, and we send them back to the juvenile system for a delinquency petition. So the only change to the bill is the word delinquent has been taken out of the change to the actual statute, and it just says petition for child in need of supervision.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Taylor.
Chair, Delegate Valentine just asked one of my questions, but thank you, Senator, for being here. It's great to see you. Did you say that the 9-year-old that killed Nikayla fell through the cracks?
Well, what I meant by that is we didn't have this in place. And so by all information that I have, and Ballone may have more information, his grandmother was his caretaker. She was prosecuted and convicted. And as a result of that, he was put into the system of Department of Social Services foster care system. But in that course of that, there was no mandate that he ever be treated or put into SINS, child need of supervision services, for what happened. So we don't know what, if any, services he got. I do know that his grandmother has since been released from incarceration, and I don't have knowledge about what their current status is. You may know, Minister Ballone.
So quickly, SINS was something that my family was looking at. My aunt works for DJS, so it was something that we were already looking at, and Senator Carter had brought it to our attention as well. It came to our attention because before the grandmother had even gotten to court, there were multiple kids that were on that porch. Multiple of them are my family members. They had already ran into the little boy again before he was placed with anybody else within that neighborhood. So that kind of goes to show some of the stress we were dealing with, some of the kids. Even the friends that had witnessed her murder, they wanted to speak up with the police, but again, no one gave them the opportunity, and the parents wanted to give them the opportunity to do that. But specifically, I know I can't say his name, but I got so much information because in that neighborhood, he was still around. They still were trying to place him. So I'm not sure if something happened later because victim services with Monty and then the city did get better and they ended up hiring new people. My family never got any new services, but I don't believe his did either, but I know for those first couple months, we even were running into each other still in Emerson Avenue, things of that nature.
That's incredible. Madam Chair, may I have a couple other questions? I'm looking at well, first of all, who initiates a SINS request?
So it's the intake officer. So that's why there's two different pieces to the bill. The first piece requires the officer to refer to DJS. The DJS officer then is required under the Courts and Judicial Procedures article to file a petition for SINS. That's who's responsible for that portion.
Thank you. And I'm looking at the fiscal note, and it says that child in need of supervision cases represented 4.3% of the 24,335 total intake charges received by DJS during fiscal year 2025. I also see there were 466 complaints in fiscal 2025 involving children younger than the age of 13. After you have your meeting with DJS next week, when we pass this bill, what do you think is going to happen? What do we need in place in order for this to be successful?
I think we need to ensure that, number one, the Department of Juvenile Services has the funding to need to temper that. I'm a budget guy, based on kind of what we expect to happen. So those were the numbers I was referring to when I was talking to Delegate Simmons. It's not going to be a large amount of children, but again, those are the ones that we need to recapture the most. And so we need to make a tempered decision on how we fund the wraparound services that are available through the Department of Juvenile Services based on these numbers right here from last year and even more numbers in the more recent past. But I think it's really about ensuring that the funding is there and that we've gotten the supports in place for the department to kind of uptick that 4.3 number to have more kids evaluated into the child in need of supervision program like Delegate Phillips stated.
Yeah. Thank you.
Thank you.
Okay, Delegate McComas.
Thank you, Madam Chair. Just a brief question. I would think that whole situation affected the whole community, not just the child that died or the child that discharged the weapon. So what I'm thinking is it's got a broader impact on the community, and I'm thinking that wraparound services is important, but you need something to help heal the community, that neighborhood, because I think it's like a potential virus that needs to be extinguished.
Well, Delegate, I know you were my seatmate for the past 2 years, so I know you always get great ideas about new bills from other bills, and I think that that's probably something that we can address in a different way. But what I will say about this bill and what it does for what you're bringing up is creates the stability that's necessary so that his family is not running into the offender and creating an even more tense and volatile situation because there's more eyes on the situation. There's actually a supervision process happening. There's actually services being provided to all parties involved so that there is more certainty and not that volatility that you're talking about in the neighborhood. And I'm definitely available to talk about potential solutions for community supports as well.
Well, yeah, because they don't They don't just live, everybody doesn't live in isolation. I mean, it's an environment. It's just really a sad story.
Very, very sad story, very traumatic. You will never be able to quantify or really put a finger on the depth and breadth of what this family has gone through. And that's why we're really here to implore this committee to move this bill forward and to pass it into law so that we can get this on the books.
All right. Seeing no further questions, this concludes this hearing on HB 776. I will note that there's no opposition. Thank you so much, Senator Carter.
In fact, there was support from the State's Attorney's Office for Baltimore City.
Awesome. Thank you.
Thank you.
Appreciate it.
I want to take a moment of personal privilege here. It is Black Liberation Advocacy Day. There are several advocates from the Leaders of a Beautiful Struggle and Black Girls Vote in the audience. Would you just stand for a quick moment? I don't know what your schedule's like and whether you have to leave early or not, but thank you for being here. Advocacy is important. Thank you so much for being here. All right. The next bill is HB 890 with Delegate Crutchfield. You may come forward and bring your panel.
I understand there's another bill, Mayor.
Excuse me?
I believe there's been a change in.
No one told me. Okay, so you're waiting? What's happening?
No. There's been a change in there's another bill that is going to come before my bill. I'm not sure what that number is.
Whose is it?
I'm not sure.
No, he didn't. Okay. Got it. He did mention something. He put it in order. Yes, he did. Very good. Thank you, Delegate Crutchfield. I'd like to call HB 1030, the Office of State Prosecutor.
Thank you, Senator. We'll be quick. Thank you, Madam Vice Chair. And all the honored members here today. It is good to see you again. We will be quick today, I believe, but my name is Brett Wilson. I'm the administrative judge for the Circuit Court of Washington County. I'm here today to ask your favorable consideration of House Bill 1030, which would expand the jurisdiction of the Maryland Office of State Prosecutor to investigate and under certain circumstances to prosecute threats against judges. This idea derives from the work of the Judicial Security Task Force that was created by the Chief Justice of the state after the murder of my colleague, Judge Wilkinson, in 2023. The task force, in addition to investigating the best practices for judicial security across the country and surveying the security status of all judicial facilities in the state, also conducted a threat assessment survey with all personnel with an eye towards possible legislation. In addition to HB 631 that I presented last week concerning the increase in classification and penalty for the crime of threats against judges, the task force also learned of the inherent difficulties in prosecuting these offenses, which primarily consist of, are primarily consistency in prosecution as well as conflict of interest. A state's attorney is a unique elected position with the awesome responsibility of ensuring public safety while also recognizing the right of liberty and due process of those who are charged. And in the end, to answer to the community who elected her or him. This bill does not usurp a state's attorney's authority. However, it does create an option that can alleviate the problems of inconsistent prosecutions and also conflicts that arise when a judge is a victim. Not surprisingly, we found that these cases were handled differently across the several jurisdictions of the state. This bill would help bring consistency to all of the prosecutions. Judges are unique victims. Judges must be very mindful of actual and potential conflicts of interest when hearing cases. When a judge is a victim in a case that is being prosecuted by a particular office, it also brings into question whether that judge may hear any case brought by that office during the time that the case is pending. This bill would greatly reduce the number of conflicts of interest for the judge who has been threatened and allow us to conduct business closer to usual and to make sure that our dockets do not backlog. This is a simple appearing bill that would have a significant effect on these important and difficult cases. I do urge a favorable report.
Thank you. Good afternoon, Madam Chair, members of the Judiciary Committee. My name is Sarah David, and I'm the Deputy State Prosecutor at the Maryland Office of the State Prosecutor, here to ask for a favorable report on HB 1030. This legislation would expand the Office of the State Prosecutor's jurisdiction to address threats against judges. I'm going to talk about why this legislation is necessary and why it'll help address serious threats. The Maryland Office of the State Prosecutor is actually unique in the country. It was established after political scandals in the 1970s in Maryland to create an office to specifically address statewide political corruption cases and other specifically enumerated offenses. The legislation initially was narrowly crafted to ensure the Office of the State Prosecutor could handle complex, sensitive corruption investigations, but not usurp the power of local prosecutors. To do this, the specific offenses the office could prosecute are specified in Criminal Procedure 14107. So our office does not serve as conflict counsel and can't come in on cases even by request of a state's attorney if it's not one of these enumerated offenses. Once we investigate a case, we send a letter to the local state's attorney of the jurisdiction with a report of our findings. At that time, the state's attorney can decide whether to allow our office to prosecute the case or to prosecute the case themselves. This process is outlined in Criminal Procedure 14109. I'll also note that the Maryland States Attorneys Association does support this legislation. Adding investigations of judicial threats to our jurisdiction helps streamline the investigative process for these allegations. We're used to working with law enforcement all across the state and can help direct these investigations to ensure that we're able to put cases in the best position for prosecution. At the end of each investigation, as we always do, we'll report our findings to the local state's attorney who can decide whether to prosecute the case, but it's often a challenge for them because they go in front of the local judges. And so we're hoping to have this legislation to ensure judicial security and urge a favorable report.
Good afternoon, Chair, members of the committee. I am Marisa Trussetti, President of the Maryland State Bar Association, the largest organization of legal professionals representing over 42,000 legal professionals in the state. HB 1030 is part of a broad statewide approach to security for judicial officers. We were here yesterday before you, and we're back again. The statewide approach includes improved digital privacy and physical security measures, authorizing the Office of the State Prosecutor to investigate those who threaten judges and judges-elect brings a new level of examination and accountability for these acts. This bill is needed to confront the escalating attacks and threats directed at the judiciary because of the public nature of the judiciary's work and campaigns for judicial elections. Judges are vulnerable targets as their names are tied to high-profile matters and judicial orders. Easy access to digital tracking tools and online posting has increased anti-court rhetoric and threats that quickly spread beyond local jurisdictions. Threats against the judiciary not only cause individual harm, but also reduce judicial integrity, the recruitment of new judges, and public participation and trust in the justice system. With experts trained in casework involving public officials leading this work at the Office of the State Prosecutor, Maryland will be in a proactive role to protect our judiciary. A state-level independent response to threats will standardize threat investigations and aims to deter future violations. The choice for our members should not be public service or personal safety. We must continue to strengthen protections and safety for judicial officers to protect the administration of justice and judicial integrity. MSBA respectfully requests a favorable report on HB 1030. Thank you.
Thank you. Delegate Simmons?
Thank you, Chair. And once again, Judge, welcome back. You know, had a great time yesterday listening to your testimony. When you talk about the work group, yesterday you got into about the work group and the recommendations now of the Office of the State Prosecutor. Is this in replacement? Yesterday we heard a little testimony from the sheriff about their responsibility. Can you just explain a little further of what would take place now and what was in place or what is in place and what this would be replacing?
Sure. What currently happens when there's a recognized threat against a judge and an identified defendant is if charges are filed, of course, they're brought in the county where it's made. If the judge is also in that county, that state's attorney's office will usually contact a state's attorney from a neighboring jurisdiction and basically have one of their prosecutors specially assigned to handle the case. In the courthouse, what we'll do is have to bring in a judge from a different part of the state to hear the matter so that none of us who could be affected would hear it themselves. What this would do, again, because of every jurisdiction has a different state's attorney, every state's attorney's office works differently, which is certainly perfectly natural. This would at least bring some consistency to all the prosecutions that go to the state's prosecutor's office because they would be doing it the same way each time. Also, as you heard, the state prosecutor's office has a very narrowly defined jurisdiction, very few, very specific types of cases, important cases, where a state's attorney's office has all of the docket, all of the cases in that county, meaning that if a judge is a victim and there's a certain prosecutor's office handling it, any case that prosecutor's office may be handling really should not go before that judge while he or she is a victim, also being represented by the office. So this has the potential to really streamline when one of these happens, allowing us to run our dockets in a normal pattern.
Thank you.
Sure.
Delegate Boucher.
Thank you, Madam Chair, and thank you very much for bringing this forward. Maybe I missed it, but would the state prosecutor try it in the jurisdiction happen, or would it be in Anne Arundel County? Where would the actual trial take place? What jurisdiction?
So it's a great question. The trial would take place in the jurisdiction where the crime occurred.
Okay, it would just have a different prosecution and a different presiding judge.
So yes, it could do that, but also the state's attorney would still have the option. The state's attorney's office could still try the case, just using the investigation led by the office of the state prosecutor. So we engage in what's called vertical prosecution. So our prosecutors are engaged from the moment we get a complaint. So there's a prosecutor engaged in sort of building the case, dealing with all the issues that come with threats, the First Amendment issues, the witness issues. But then we send a letter to the state's attorney, and he or she could decide, you know what, actually, like someone from my office wants to actually prosecute this case, or I'm going to allow the office of the state prosecutor to prosecute.
So the state's attorney would have the option.
Correct.
But there would be no option on the presiding judge. It would have to be from a retired judge, so to speak, that we covered yesterday.
That's the judiciary's policy that they would bring in, or the bench will recuse if the judge is the victim.
And it could be different. If there's a general bomb threat against all the judges, then all the judges, of course, would recuse. If it's specific to one judge, in that case, then another judge's jurisdiction may feel comfortable handling it or may not. And then we can easily bring in a judge either assigned from a different jurisdiction or, like you said, a senior judge.
Right. Thanks for clarifying, because I misinterpreted what you said earlier. Thank you very much.
Thank you.
Positions. So this concludes the hearing on HB 1030. And are you here for 899 also?
No,
No, that's
that group is in the Senate. They should be over short.
Okay.
So thank you very much.
All right. So I guess I'm skipping 899.
Thank you.
And I'm going to Delegate Crutchfield, HB 890. You can bring your panel. Let me take a look. All right. All right, thank you, Delegate Crutchfield. You may proceed.
Thank you. Wow, this is the first time I'm back. And not on the committee, right? So, seven sessions, right? So I am happy to be here, happy to present this bill to you. And for the record, I am Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County. So again, happy to be here. And Madam Chair, definitely happy to see you there. I want to talk to you about a bill that I believe you should vote favorably for, and that's HB 890. This bill, all it really does is it provides notice, okay? And by that, it simply is asking DHS that when they come in contact with a family that there are allegations of child neglect or child abuse, that they make sure they hand out something to that family so that they understand and know what their rights are. Now, what it doesn't do is it doesn't add any rights that don't already exist. It doesn't take away any rights at all. But that is all it does, is simply say, this is what you need to know when you are approached. Now, oftentimes this happens with a police officer and also a defects worker who comes to the door. Most of us, when we see police officers, we immediately react because they are someone that we believe should be trusted and have authority over us. So we back off and we immediately do whatever they request us to do. All this says is, listen, there are some things you don't necessarily have to do, but you should think about doing, okay? That's all it raises. It is not Miranda rights, okay? Miranda rights occur when you are in a criminal situation. This is not about that at all. This is totally a civil situation. So, again, I'm gonna say it again, because you will hear and people will talk about Miranda rights. This is not Miranda rights. Because it doesn't stop anything. Someone can be given notice of what their rights are in this situation, but it doesn't slow anything down. It doesn't stop anything from happening, because things can still happen. And in particular, DHS has the right to take a child or do certain investigatory things, okay? So that's not what this does. So I want you to be clear on that. The other thing to understand is that there is a fiscal note that you probably have seen that talks about several things. One of the things it talks about is that there's a need to increase funding for this, but there isn't. They already hand out a brochure when they enter in interaction with the family. This can be added onto the brochure. I was told that it costs about $18,000 for them to print the brochure every year. There is no added cost with this. So don't believe that. The other thing to understand is that okay, okay.
You can finish your statement.
Thank you very much. The other thing to understand is that, even though there may be this look that, again, in the fiscal note, it talks about, due to there being Miranda-like situation, again, I'm telling you, this is not Miranda rights. It doesn't stop anything. So therefore, there is no need to look at the data that they've presented that tells you that if someone invokes Miranda rights, it stops everything, and now there's a court proceeding, and now it's going to be extra cost to them. That doesn't happen, because that's not what this is. This is not a criminal action. So please understand, civil, all we're doing is handing out a notice, and that is it, and letting people recognize the rights they already constitutionally have.
Okay.
That is it.
Thank you.
Thank you so much, and I hope that you find this favorable. And let me also say it's supported by the Maryland Latino Caucus, as well as the Legislative Black Caucus of Maryland. Thank you.
Thank you. Who wants to go next? Okay.
Good afternoon, Vice Chair Davis and members of the committee. My name is Natasha Calfany. I am the statewide supervisor of the Office of the Public Defender's Better Together program. I'm requesting a favorable report for HB 890. The Better Together program is an early advocacy pre-petition program. We provide legal advocacy and other supports to parents who are under CPS investigation or at risk of a CPS investigation. We have been in existence since September of 2023. Our goal is to help parents keep their families together and avoid court involvement. What I do is important because as part of our legal advocacy, we already educate parents on their rights. This education has never caused a parent to resist or refuse working with the Department of Social Services. Parents being informed of their rights has also not increased the number of cases that resulted in court involvement for the department, which was suggested in their fiscal note. In fact, of the 137 families that we have engaged, only 15 of those cases resulted in court involvement, and in every case, the parents still cooperated with the CPS worker. All of our parents cooperate with DSS because they understand that CPS has the ability to take their children and place them into foster care. This does not change because a parent knows their rights. It is the threat of losing one's child to foster care that always motivates a client to cooperate with DSS. Parents knowing their rights provides a level of accountability to an otherwise unchecked power of a CPS worker and DSS as a whole. Parents knowing their rights makes the process less scary and empowers parents to ask questions about their case and advocate for their children. In closing, I want to stress that this bill is not about parents who have abused or neglected their children. This bill is about all parents. In 2023, 20,000 children were subject to investigations, and only 70% of those cases resulted in no finding of abuse or neglect. Any parent can be subjected to investigation.
Please
and if it
wrap
were
it up.
you should know your rights. Thank you.
Appreciate it. Next.
Good afternoon, Madam Vice Chair and members of the committee. I lead the Parental Defense Division at the Maryland Office of the Public Defender. Every day, my office represents parents whose lives have been turned upside down by that knock on the door by Child Protective Services. I'd like to offer a comparison to explain why Maryland needs HB 890. If I steal a $6 pair of socks and the police come to my house to interrogate me, they have to inform me of my rights. They have to tell me that I have the right to remain silent, the right to a lawyer, and that anything that I say can be used against me. But if someone accuses me of neglecting or abusing my children and the state comes to my house to investigate, CPS does not have to inform me of any of my rights, does not have to give me notice. They don't have to tell me that I can consult with an attorney, and they don't have to tell me that I don't have to let them inside my home unless they have a court order or they think my child is in serious harm, or that I have the right to seek legal advice before signing anything, like an agreement to give custody of my child to someone else. In the sock example, the worst outcome is a misdemeanor. But in the child welfare context, the state can remove my children from our home and place them in foster care with strangers. And yet parents are given less notice than someone who steals a pair of socks. HB 890 does not prevent investigations. It does not shield abuse. It does not restrict emergency action. It simply ensures that when the state initiates an investigation into a family, the parents are informed of their rights so that they understand the process and can make informed decisions about their children. If we require notice when a pair of $6 socks go missing, surely we can require notice when someone's child can be taken away. I respectfully urge a favorable report.
Thank you. Next.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Shanta Trevetti, and I teach and I write about the child welfare system, and I'm the faculty director of the Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore. I've also represented parents who have had their children removed without knowing their rights, and I urge you to issue a favorable report. And I want you to imagine CPS knocks on your door in the middle of the night, and they say that they're going to search your home, look in your fridge, your cabinets. They'll ask questions about your romantic partners, and they'll ask to speak to your children without you being present. They'll inspect their bodies for bruises, whether or not the allegations against you are physical abuse. And before completing their investigation, they might ask you to sign away custody of your children or risk them being put into the foster system. How would you respond? What would you want to know? Would you want to speak to a lawyer? Most people don't know what to do in this situation, particularly if they are economically or otherwise disadvantaged. And many of those who oppose the bill say that it would create new rights, but that simply is not true. Even the department acknowledges that fact in their fiscal note. This bill would just inform families of their constitutional protections that already exist and would allow parents to make informed decisions throughout the process. To date, Connecticut, Texas, Florida, Montana, and Arizona have all passed these laws, and New York and Delaware have introduced similar legislation. And the question is really whether we want to join those states in respecting constitutional rights for all parents or reserve them for the privileged few who already know what they are. Rather than making children less safe, those states that have passed similar laws have found that they keep children safer because parents feel that the agency is being transparent with them and they're more willing to engage with them. Further, the law already provides that law enforcement and DHS are able to enter in emergency provisions, and this bill would not change that. And I know that opponents don't want DHS to be perceived as a policing agency, but unfortunately, people already feel that way because of the intrusive nature of the investigations, the fact that DHS shares information that is obtained without a warrant with the police, and because they know that DHS can take their children away. A fair and just society requires that people know their rights. It's just the bare minimum. And I urge you to issue a favorable report. Thank you.
Thank you. Ms. Amen.
Good afternoon, Madam Vice Chair and members of the committee. For the record, my name is Yanetta Manuel, and I'm the Public Policy Director for the ACLU of Maryland, here in strong support of HB 890. As you've heard, the rights outlined in this bill already exist. The problem is that many parents do not know that they have them. They often don't understand their rights during a child welfare investigation, or that exercising those rights can feel risky when potential consequence is the removal of their child. HB 890 simply ensures that families are informed so that they can navigate this high-stakes process with clarity and fairness. This is especially important given the disparities in our child welfare system. In 2022, Black children made up 52.8% of Maryland's foster care population, despite being only 30.6% of the state's population. That same year, DSS investigated over 17,000 allegations of maltreatment, and in 71% of those cases, the allegations were unsubstantiated or ruled out entirely. National research shows that more than half of Black children will experience a CPS investigation by the age of 18, and Indigenous parents are up to 4 times more likely to have their children removed. Poverty is often conflated with neglect, and Maryland's definitions of neglect are broad and subjective, leaving too much room for inconsistent application. While CPS investigations may be well-intentioned, the stakes for families are enormous. Informing families of their rights does not undermine a child's safety, it strengthens the integrity of the process. Lastly, we're unclear why the state's attorney's office is in opposition to a bill that does not impact their process or practice. The concerns raised reflect a fundamental misunderstanding of the bill's scope and appear to be a thinly veiled attempt to maintain the state's overreach rather than engage with the legislation as written. So for the foregoing reasons, the ACLU of Maryland respectfully urges a favorable report. Thank you.
Thank you. Questions for this panel? Delegate Arkin.
Thank you, Madam Chair. Thank you, guys, and thank you, Delegate, for bringing this bill. I guess I just need maybe a little bit more information. I know we'll hear from the other side, but is there anything that you want to share with us that we've heard in the past? Any response to it? Because I know they're going to talk about the fiscal note, which you've already addressed, but is there anything else that we should know about? Anything else you want to share?
So I'll let you go ahead and share, and then at the end I'll mention it. Is there anything in particular?
I would like to point out that to the extent that there's concern about the inability of the department to investigate legitimate cases of abuse or neglect, the committee should note that parents are not the only source of information that the department can look to for information. And in fact, a thorough investigation would require that the department talks to other people. So an investigation isn't shut down by the fact that a parent, for example, decides to exercise the right to first seek the advice of an attorney before engaging with the Department of Social Services. DSS can and should talk to other family members, the schools, the teachers, other people that the child interacts with. So don't be misled into believing that there's nothing that DSS can do simply because a parent exercises the right to consult with an attorney or to not allow DSS to enter the home to investigate. I also want to point out that DSS can always enter the home if they believe that the child is in imminent danger. This bill does nothing to change that right.
Okay, that actually added a lot. Thank you. My last question is this bill bipartisan?
Yes, it is.
Just one.
And oh, by the way, the co-sponsor is the one asking the questions. So
anyway, isn't that so? Okay, thank you very much, Madam Chair.
If you don't mind, Madam Chair, I think there may be some other comments to your question as well. Is that okay?
I wanted to say a couple of things. One of the things that is constantly stated is this idea that it would delay the safety or somehow prolong the child in a dangerous situation, and that is not the case with this bill. This bill does not take away the department's ability to remove a child who is in immediate risk of harm or who they believe is in immediate risk of harm. The department has 5 days to begin an investigation when it comes to issues of neglect. So these cases, there's already built in a timeline that gives them the time to do the things that they need to do to ensure that a child is safe. 5 days to start the investigation, and they have 60 days to complete the investigation. So allowing a parent to be informed of their rights, and even if you give them a day to consult with an attorney, it does not do anything to delay the investigation. And in the meantime, as Ms. Villamar stated, they can be talking to the schools and talking to other people. The last thing I will say about that is there's nothing that accounts for the idea of when a school-age child is being investigated, because that's one of the things that the opposing side has been saying. They won't have access to the children. If a child is school-age and the department is investigating that child, generally the first thing they will do is go to the school and speak to the child, and they usually do that before they even engage the parent or the parent knows that there is an investigation happening. So especially in the fiscal note, it is important that you understand they have not accounted for the number of school-age children that they have access to before a parent can even consent or even knows that the investigation is happening, and that is very important, and parents cannot stop them from going to schools and seeing children.
Okay, yeah, that very much helps.
Can I just add briefly? I think whenever we hear that CPS is going to intervene, we imagine the worst case scenario. We think of the worst case that you've ever seen on the news and the most horrific case of child abuse that you could possibly envision. And I just want you to know that that is not the majority of cases that CPS is dealing with. Nationwide, almost 75% of the cases that are called in are neglect, not abuse. And a large percentage of those are poverty that is conflated with neglect, and many times it is families dealing with mental health struggles or substance use disorder that are having trouble finding the services that they need within their communities, the kinds of things that the Better Together program connects families to, if they're able to have contact with that family to get them the help that they do need and the support without their children being removed, where they can create a situation that is less traumatic for the child. They can figure out a situation with family that is able to keep the child safe while also ensuring that their family is preserved and there's not a punitive court proceeding. And when you think about this bill, I want you to imagine your friends and family as the people being investigated, and not the worst case that you've ever seen in the news, because it is far more likely that it is your neighbor or your friend than it is the worst person on the news, and that's what the statistics say.
Thank you very much. Thank you, guys.
Thank
Thanks,
you,
Madam Chair.
Delegate Cardin.
Madam Chair, thank you all very much for coming in and for your compelling testimony. I have two questions. The first one is, you spoke about a brochure, and then you also spoke about advice of rights, basically to a right to an attorney. So is this like a long advisory of rights, or is this simply, you can talk to an attorney if you want to, we can't stop you from doing that? That's question number one. And then related is, if, I'll just put it out there, CPS comes to investigate, the parent feels that CPS is not doing the job they need to do, whether, maybe it's the parent who made the allegations, maybe it's the parent who is being investigated, but they want to have the child have an attorney representing them. I know that there are court-appointed child advocate attorneys. How does the parent make sure that that is done expeditiously if this is all happening? Is that part of the advice of rights? Those are two questions.
So, Madam Chair, okay. So let me start with answering your first question about the brochure. So probably, I would say about 3 or 4 years now, I have actually been working with DHS regarding a brochure. When we started the whole process out, they said they had a brochure that they give to all families as they, engage them in the process. We found out that really didn't exist. And so they have been making attempts to create a brochure. And so with that in mind, the request has been to add this language into the brochure, okay? So we've talked about that. We've also talked about just maybe adding a little blur that talks about you have a right to a lawyer, here's who you can contact. We've also talked about adding a video to a website, just anything to at least get this notice to the parents, okay? But so that is still in the works, all right? And I will let part of the panel just go ahead and answer your other question, because that's much more procedural than I deal with.
I'll attempt to answer some of the questions. Here we have a sample notice of rights that would include the rights that are addressed in HB 890. It's literally one sheet of paper. And it would require the department to make Xerox copies. We're not asking for anything fancy. But there are other ways to notify parents, to provide the type of notice that HB 890 is requiring. DSS could do a QR code so that parents can scan it on their phone and have it come up on their phone. They could do instructional videos. It's a one-time video that you make that you can then distribute. You know, social media is so easy to access now. It can appear on YouTube, it can be on Instagram. There are many ways to disseminate the notice that we're asking that parents be notified and make that available to the investigating caseworker. Whether children have the right to an attorney. The advice says you have the right to consult with an attorney. You have the right to, children and parents have the right to an attorney once a petition is filed, and they would be represented, if they're financially eligible, they would be represented by the Public Defender's Office, and the children would be represented by Children's Legal Services. But what the advice of rights says is that you have the right to consult with an attorney at the beginning of an investigation so that you're not doing something that harms your family's interest without the necessary information that you need. I hope that I've answered your question, but if not, please let me know and I'll try again.
No, that was helpful. I'm more concerned about the timing of children. I know that there is a huge backlog for children getting advocates on their behalf, at least in Baltimore County there is. It's very difficult to get an appointed attorney if a parent feels as if the child needs their own representation. I'm just wondering if there can be some kind of, if there should be some notice to make sure that's done quickly.
So what you're talking about is during custody cases where it's parent versus parent. This is more involving cases where the Department of Social Services is intervening because there's an issue. In an investigation where the Department of Social Services is intervening, if they take that to court, if they believe that this child needs the supervision of the court to be safe, that child automatically is assigned an attorney. So this process wouldn't necessarily impact the private custody matters where children are not always provided.
Thank you, that's helpful. The case that I'm thinking about is there is custody issues, but it was a call to CPS of neglect and abuse from one of the parents about the other parent. So while it wasn't directly related to the custody, it was related to this situation, but thank you. Okay, I got it, thank you.
I would also just add that I believe Legal Aid Society, that represents the majority of the kids in these proceedings, supports this bill.
Yes, that is correct.
Okay, Delegate McComas.
Thank you, Madam Chair. Just briefly, I think it's what you're doing is a good idea because basically it sets a nice tone to the parents when you knock on the door. And as opposed to you pound on the door and you say, hey, I'm from Protective Services or whatever, and it freaks everybody out instead of saying, hey, we got a call or whatever, and here are your rights and everything. So I think it puts it on a nicer level so that you're going to get cooperation and you're not going to freak out everybody. So I think it's a good idea. I mean, it can't hurt.
Thank you for that
make it better.
In fact, in Connecticut, where they piloted such a requirement, The DSS in Connecticut reported that there was greater cooperation from the parents and that it resulted in better outcomes for the family.
Delegate Woods.
Madam Chair, I just wanted for clarity, the attorney for the child you're talking about is the GAL. Yes, no?
No, in these cases, it's an attorney that is supposed to represent the child's expressed interest unless the child doesn't have what we call considered judgment, and then they can advocate for the best interest of the child. That's something different than a GAL. In Maryland, we don't have guardian ad litems in these cases.
That gives me clarity, because I was getting real confused here. I'm like, wait a minute, aren't we talking about? So this is something different in Maryland. Okay.
In child in need of assistance cases, and those are the cases where there's been an allegation of abuse or neglect.
Right, okay. So I'm needless to say, as you can tell, I know DC, I don't know Maryland law as well. Okay, so that's something, that's new for me. Thank you.
I also think people use those terms sort of interchangeably when they actually have different meanings in different jurisdictions. And here it is an attorney who represents the child's best interest. You'll also, I believe, hear from CASA, who are court-appointed special advocates, who are not always attorneys, but represent the child's interest in a different way. And I think it is actually important to know the distinctions between who is saying what in a courtroom on behalf of a child.
Right, so my familiarity then was with CASA, which represented the child's interest, but the GAL, which was the question I was getting confused by, because the GAL, the parent has no influence in the District of Columbia, I'll say, with regard to the GAL being assigned to the child. So thank you, you gave me clarity for that.
I don't think you're alone in your confusion.
I'm sorry?
I don't think you're alone in your confusion.
Thank you so much. Thank you, Madam Chair.
I have a question for anyone who wants to answer this. How are these Senate cases, what's the word, established, notified? How are they started?
Sure. These cases are started when somebody makes a report to Child Protective Services, and then it can come from almost anywhere. It can be an anonymous report as well. Yes, and it can be reported by a doctor, by a teacher, by a neighbor, by a relative, by a family friend, anyone. And once CPS gets a report of suspected abuse or neglect, they are required to determine whether they need to do an investigation. And then when they do decide to make an investigation, they have to do so within 5 days. For neglect. If it's an allegation of abuse, it's within 24 hours.
Okay, thank you. All right. Any further questions for this panel? Thank you. Then we'll go to the next panel. All right, the next panel, do we have Joyce McMillan, virtual? And do we have Abigail Stecco, virtual? And Amber Dortch. Amber Dortch should be here. No?
Yes, Amber Dortch is here.
Yes, thank you. Ms. Dortch, you may proceed.
Good afternoon, Madam Chairman, Vice Chair, and members of the committee. My name is Amber Dortch. I'm the social worker with the Maryland Office of the Public Defender. I work directly with families impacted by child welfare investigations and assessments. Today, I appear in my personal capacity as a resident of Maryland and an advocate calling for change. I'm asking for a favorable report on House Bill 890. I strongly support this bill because it ensures parents and legal guardians are fully informed of the allegations against them. That also includes documents they're being asked to sign, service plans, safety plans. It gives the parent the ability to seek legal counsel if and where needed at the start of their investigative period, that's 60 days. House Bill 890 does not prevent investigations. It does not weaken child safety standards. What it does require is transparency and accountability at the beginning of the child welfare investigation with the department. What I have learned as my role is accountability works best when people understand the systems they are being held accountable in. Last year, I took it upon my own self to change my initiative in the way I work with my families, and I decided to hold them accountable of how they show up in their investigations and assessments. I posed them two questions. Do you actually know what the law states around child safety? Because they're just regurgitating information they've learned from their worker. And then I also say, in this moment, how can you show up differently for your children right now in your behavior as well? These questions allow me to have a candid conversation about child safety procedures, human or parental rights, statutes, and DSS policy that they are not aware of, exploring past CPS interactions with them that also have left them in shambles. When parents understand these laws, they are effectively able to identify DSS policy violations, civil rights violations, holding DSS liable to ethical and legal standards to prevent further separations within the family.
Thank you. And there may be some questions, so we'll be able to finish. Thank you. I have Abigail Steckel. You may proceed. Can you hear me? You may proceed.
Can you hear me? Good afternoon, members of the House Judiciary Committee. My name is Abigail Steckel. I'm an investigative fellow at Civil Rights Corps, which is a nonprofit specializing in systemic civil rights reform through litigation, advocacy, and public education. And I'm speaking, of course, in support of HB 890, which would inform parents of the rights they have in a system that's stacked against them, and a system that Civil Rights Corps is trying to help transform. HB 890 would help ensure that poor families targeted by the system are aware of their legal rights. In Maryland, there are thousands of families who face economic neglect and are therefore at increased risk of foster system involvement. Studies have shown that investigated families are often those who are food insecure, have difficulty paying rent and utilities, and experience public benefit shortages. So enacting HB 890 would help equip these families who are most likely to be surveilled with basic information about their legal rights. Federal law consistently affirms the right of family integrity and the reciprocal rights for parents and children to be together, yet families are not afforded the minimal procedural protections when the family regulation system knocks on their doors. HB 890 is an important first step to protect these families, and we hope the Judiciary Committee acts on this opportunity to protect families, and that this bill will help the Maryland legislature shift its focus away from systems that police families and towards systems that materially support them. Thank you.
Thank you. Is Joyce McMillan available?
I am. I'm here.
Oh, please proceed, Ms. McMillan.
Thank you. As a society, we made the short-sighted decision to design our child welfare system after our criminal legal system, but without the same legal protections. Like prisoners, children taken into state custody are separated from everyone and everything they know, love, and are familiar with. They both have set visit times on set visit days. They both have oversight during the visit. They both eat what they are served. They both change homes and cells regularly. They both use garbage bags or pillowcases to change locations. Using the same language, they are both paroled back either to their family or to a community facility. And they both have oversight during that parole period and can be re-separated for a small infraction. A system built to protect children should in no way mimic a prison designed to punish adults. We know that rehabilitation and restoration are too often not the outcome for people who have been incarcerated. The outcome for children who have been in the foster care system is just as bleak. Based on statistics, the only thing the foster system protects children from is success. The foster system operates as another branch of carceral apparatus in this country. Just like the criminal legal system, surveillance and separation are the default instead of support. Let's be honest and acknowledge, if the foster system was a good thing, Black and brown children would not dominate in placement. The Know Before They Knock Family Right to Notice Act is so urgent and necessary at this time. It's a practical, common sense guardrail for families. It does not create new rights. It simply ensures that parents and legal guardians are informed of their existing rights and constitutional rights, at the very beginning of a child welfare investigation. The criminal legal system is far ahead of us, guys. Murderers are advised of their rights, but not families at risk of separation. Ensuring parents and guardians know and understand their rights is reasonable and consistent with our shared responsibility.
Ms.
to
McMillan,
both
could you wrap up,
protect
please?
And uphold constitutional protections. Thank you.
Thank you. Thank you. All right. Any questions for this panel? Delegate Arkin.
Thank you, Madam Chair. Thank you so much for coming in and sharing your story. I really appreciate you sharing how you've changed some of your policies to try and get folks in a better position, a better footing. So here's my question. Do you think if your clients had a CPS worker come to their door and tell them of their rights first, that might have put them in a different posture in their communication, in that maybe they would feel less attacked, maybe they would feel a little bit more on equal footing? Do you know what I mean? Maybe they would feel a little safer to actually proceed with the investigation if they felt like they weren't in a corner already. Do you know what I mean?
Yes, so what you're saying is the family would be psychologically disarmed.
Right, yeah, that's what I was, yeah.
I've gotten a lot of pushback on that term, but because different workers have expressed to me how they do not like that type of language, because they feel as though that when they are entering in, that the parent should automatically be cooperative, and that in some ways they are already thinking that the family is going to be hostile and uncooperative in the same manner. So it depends sometimes on the individual worker. But I have seen firsthand, sat in FTDM meetings, sat in sometimes even shelter hearings, where at the beginning of that relationship, when my parent is properly informed, they are honestly able to make an ethical and logical decision on how to keep their child safe. I have never heard a parent take the information and use it to worsen their situation, or take the education and use it to intentionally hurt their child. Never have I ever heard that. Right. I have heard, okay, how do I become better now that I'm aware and briefed on how I'm supposed to properly and healthily interact with this system, especially when I have been previously traumatized. My children have been removed. I've been shut out of my own cases. Now that they're here again, how do I do this differently? Because I really do want a positive outcome, and I want my children to not be so psychologically damaged after going through these next 60 days. Right. Because of whatever the report says.
Right, and we saw the statistics. I think they had said, I don't know where I wrote it down here, but it's in some communities, it's happening so prolifically that there's going to be some prejudgment, obviously on both sides before going into the interaction. Even if they've never had a CPS worker at their house before, they know someone who has, probably many people, probably a family member. So they're going to already be in a corner emotionally if the person leads with, I just want to let you know about your rights. I'm from DSS. I want to make sure you know about your rights here. That sets a different tone, I think.
Yes, it really does. And it softens also kind of the blow of what are the allegations are about to be reported. Because again, the parent is also preparing for the worst thing to be shared to them. And also they're trying to get out of the narrative of being deemed as a bad parent because CPS has shown up at their door. So it's the shame. It's the shame because everyone can see you in your neighborhood.
Right.
And also too, I recently just also encountered, and this is my last point, I encountered a case where a parent had no finding of abuse or neglect, yet their child was still removed without a court order when they worked with the department. When the child was moved between house placements, parent was never notified. And when the parent began asking what their child's whereabouts were, what's going on with the child, are they going to school, do they have clothes, do they have food, is there something that I can do to assist the situation? I observed, especially when reunification is being talked about and brought onto the table, the department chose to close the case, and the parent is currently trying to locate this child.
So that they can close a case after they've, okay.
Yes, they closed the case.
And so what is her remedy now?
That's what she called me.
Yeah.
That's why she called me, because we're trying to figure out how to do that in a legal manner where she is also protected, and that she's also able to retrieve her son, but then also have services for that child, because that was also something that was asked by the parent, and the department promised that they were going to do those things.
And when you close the case, can they no longer get access to the services?
The services the case is closed.
Wow.
And there's no other further services going to be provided, and the parent should have received a case closing letter, and then that's it.
Wow, thank you.
Silence.
Thank you for sharing your experience.
No, thank you. Thank you for receiving it, and thank you all. It's a privilege to sit before you all on behalf of not just the Black and brown mothers, but also immigrant mothers, white mothers too. They get hit tough. They get hit hard as well. So, and these are also faces that you are all familiar with, people that you stand in line with at the grocery stores, people that your grandchildren hang out with. That could be their parents. It doesn't necessarily have to be persons or individuals in impoverished areas. It can be middle-class families. It can be rich, wealthy families, whatever family's well off. The system does not discriminate on who it chooses to target or who it chooses to interact with. Thank you again for this opportunity.
Thank you. Delegate McComas?
You just said something that kind of got me thinking. So the department closed the case. The parent doesn't know where the child is.
Yes.
There's no case? Is that kind of what you said?
There's no case.
Okay, so is this a kidnapping? I mean, I don't know. I mean, I'm not a criminal lawyer, but it sure smells bad.
Yeah, so I'm not, it feels, what I will say is it feels that way. And it feels like a manhunt on trying to find this child. And it's hard for me to describe, but yes.
Delegate McComas?
Where the child was taken, where the parent lives?
That's what I'm working on legal services so that the parent knows legally what to do now, since the case is closed, to find where the child is.
But what would be helpful is if you know where are you an attorney?
No, I'm a social worker.
Yeah, but still, you got credibility that the parent may not have.
Yes.
I think you should try to talk to the state's attorney in the jurisdiction the child originally was at.
Yes, I'm working all those things out. Okay. Yes, ma'am, I am.
Thank you. Seeing no further questions, this concludes the favorable testimony on this bill. I am going to call the unfavorable testimony now. Thank you so much.
Thank you.
Is Michael Calabrese on the? He is not. Okay. We're going to call Wendy Lane, Allison Del Sandro, Mary Buchanan, Jennifer Stein, and Diana Phillip. Oh, we might as well get Elizabeth D. Targiano also. We might need to bring up another chair. I'm going to do judiciary next. Okay, thanks. Did I call too many? 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6. Okay, why don't we start from this end?
All right, good afternoon, Madam Chair and members of the committee. My name is Wendy Lane, and I am representing the Maryland chapter of the American Academy of Pediatrics. The MDAAP is a statewide association representing more than 1,100 pediatricians and allied pediatric and adolescent health providers in the state of Maryland. We are strong and established advocate to promote the health and safety of all the children we serve. And on behalf of MDAAP, we voice our strong opposition to House Bill 890. Let me start by saying that MDAAP supports letting everybody know their rights. What you haven't heard from any of the proponents of this bill was any discussion about the rights of the child. There was a lot of talk about rights of the parent, but no talk about rights of the child. Our concern is the language of the written notice establishes an adversarial relationship that's focused solely on the rights of the parent while ignoring the rights of the child. Such adversarial language can instill fear in parents and increase likelihood that they will refuse access, assuming that refusal will protect their family. But in fact, that refusal may harm the child. In my role as a pediatrician, I've seen just too many children brought to medical care or to the medical examiner's office with severe abusive injuries, malnourishment, and neglect that might have been prevented or ameliorated had someone from DSS been able to see the child, connect the caregiver with services, and gotten the child to medical care. All children deserve to live in a safe and protective environment. No child wants to be beaten, burned, locked in the room, or denied nourishment. HB 890 has the potential to strip children of the right to safety and protection, and Maryland children deserve better. Thank you.
Thank you. You may proceed.
Thank you. My name is Jennifer Stein. I'm the Executive Director for CASA, Court-Appointed Special Advocates of Baltimore County. I'm a social worker and a mother. And CASA, as you heard earlier, is an organization that advocates for the best interests of children in foster care. And I'm here to urge an unfavorable report on 890, but as Dr. Lane said, I am not opposed to parents knowing their rights. I very much agree with the intent of this bill, and I think in general it is wonderful. I have huge concerns, however, with one particular section, which is E14, which states specifically that the parent does not have to allow the worker to meet with the child. And that, as my colleague said, puts children's safety at risk, and I believe puts the rights of parents above the safety of children. We have heard a lot of talk about that the cases that we see on the news are the worst of the worst, and that is true. However, it is also true that nationwide, 78% of cases that involve a child fatality also involved neglect. And the neglect is what we don't see and what you don't hear about unless the worker has the opportunity to speak with a child and actually hear from them if they feel safe in their home. It's also important to know that Maryland is the second lowest rate of removal in the country. So you actually heard some of the proponents of the bill talk about the high percentage of calls that we get and the low percentage that are determined to be a removal. And that's true, and that's wonderful, and because kids should not be pulled from their homes if it's not necessary. But we don't know that unless there's the ability to assess the safety of the child, which actually is included in the law. And I worry that this provision of the bill will increase child's risk of harm as opposed to protecting their safety. Thank you.
All right. You may proceed.
Thank you for allowing me to speak today. My name is Allison D'Alessandro, and I've worked in the field of child abuse prevention for nearly 25 years. I now work at Center for Hope, which is formerly the Baltimore Child Abuse Center. Center for Hope works every day with children and families impacted by abuse, neglect, exploitation, and violence. We partner closely with child advocacy centers, healthcare providers, law enforcement, and child protective services to ensure that children at risk receive timely, trauma-informed, and coordinated intervention. For these reasons, we oppose House Bill 890. While we support parents understanding their rights, this bill puts children in harm's way. Excuse me. In practice, this will function as an invitation to refuse cooperation at the earliest and most critical stage of an investigation. As written, it tells parents they're not required to allow investigators to interview or even see their child unless a court orders it. Again, this bill permits parents or legal guardians to refuse to let CPS talk to or even look at a child. Even short delays can significantly increase risk. Just 24 hours can make the difference between the life and death of a child. Nationally, nearly 2,000 children die each year from abuse and neglect, many of them infants and toddlers who cannot speak for themselves. Child advocates across Maryland report cases where children are hidden from investigators, isolated, or denied food and medical care. Caseworkers must be able to see children promptly to determine whether they are safe. This bill shifts the balance away from child safety and towards adult procedural rights. It risks more adversarial investigations, more emergency court involvement, and even unnecessary removals simply because investigators cannot promptly assess a child's safety. Children are individuals with their own rights and their own voices. Any change to child protection law must be given with one principle: the child's safety comes first. For these reasons, we respectfully urge an unfavorable report on House Bill 890. Thank you.
Thank you. Who's next?
Good afternoon, Madam Chair, members of the committee. My name is Mary Jo Buchanan. I'm a retired social worker with 45 years of experience in the field, on the front lines and as the executive director of a child serving agency. I'm very concerned about House Bill 890, particularly Section E14, as I really feel it's going to delay laying eyes on a child who may be in danger or in harm's way. I believe the safety of a child is paramount. And I just want to share an example. And yes, it is a worst case example, but it haunts me and I live with it every day. When we, in partnership with our child welfare partners as well as law enforcement in my agency, we received a referral and we were denied access by the parents. When we finally got access to that child, it was a horrific scene. The child was in the basement, confined. The child was malnourished, had no food. The water was in a dog bowl. I mean, it was truly the most horrific scene of abuse that I have ever witnessed. I know it is extreme, but we have to speak up for every child who may be in harm's way. So that haunts me because I'm really concerned about any further delay that might happen in the situation that's covered in the bill. I, too, really respect parental rights. We never know what we're going to find, though, when we knock on that door. So we have to see the child without delay. We never know what we're going to find, and we need to be able to do that in the most timely way. And that's why I respectfully request an unfavorable report. Thank you very much.
Thank you.
Good afternoon, Vice Chair Davis and members of the Judiciary Committee. My name is Elizabeth DiTargiani, founder and president of Legal Guardian Angels at the University of Maryland, a student organization dedicated to serving and advocating for vulnerable children. LGA respectfully urges an unfavorable report on House Bill 890. Between 2010 and 2019, 423 child fatalities reviewed in Maryland were associated with abuse or neglect. In 232 cases, the mother was responsible. In 99, the father was responsible. In most abuse investigations, the alleged perpetrator is a parent or caregiver. HB 890 would require CPS at the very start in an investigation to inform the parent or guardian of all allegations, even if that parent is the alleged abuser. That parent could then refuse entry into the home, refuse to allow the child to be interviewed, decline a safety plan, and delay the process while seeking counsel. This prevents CPS from seeing if the home environment is unsafe or having a genuine conversation with the child. What happens to the child during the delay? It is essential that a CPS employee is able to make prompt assessments and interviews, as injuries can fade and fear can silence a child. As someone who has personally experienced the child abuse investigation process, I know how critical it is for a child to have the opportunity to speak privately with the CPS worker. When the person you depend on and love is also the person causing harm, speaking up is already terrifying. For many children, the first private conversation with the caseworker is the only window of safety they may have. It may be the only moment they feel seen, heard, and believed. Please do not close that window. For these reasons, LGA respectfully urges an unfavorable report for House Bill 890. Thank you for your time.
Thank you. Could you trade seats? I appreciate that. Diana Phillip.
Good afternoon, members of the Judiciary Committee.
It's great to see you again. My name is Diana Phillip. I'm the coordinator for the Coalition to Protect Maryland's Children, which has been a group since 1992, formed of organizations and individuals that are on the front lines of responding to and intervening on and preventing child maltreatment. These are the pediatricians, the foster care providers, the social workers, the lawyers, everybody else that is concerned about maltreatment, physical, sexual abuse, mental injury, neglect. We're in opposition for the bill as it stands right now with House Bill 890, because we believe that when you look at a child welfare bill, child safety is your North Star. And when you look at this bill, the questions arise about what is happening with the child. As been pointed out, the child has a right to be seen, heard, and believed. If you're a young child in a home where no one else can access that child because it's young, it might be an infant that is having thriving problems, medical problems. It could be a young child that's not in school yet, or one that's being homeschooled. The main problem that we see is this interpretation that you're hearing, and you did hear from the proponents of the bill. They are equating it to a criminal investigation. They are equating it to Miranda. But this is about the initial contact by the department to do a safety assessment, which may lead to alternative response, might lead to an investigation. That's what we're concerned about, is blocking when we talk about that delay. And this is not in the bill. Now, we've asked the bill sponsor and we've asked the Office of the Public Defender to actually address these issues. What about the child's safety? The allegations of harm may not actually be from the parent. It may be somebody else that the parent is not aware of that they actually need to protect the child. That hasn't been brought up here. Now, if there are jurisdictions in the state of Maryland where there's caseworkers and supervisors that are violating the law, they're removing children because of poverty or disability, we need to know about that, and that's a training and supervision issue, but don't pass a law that takes out the safety net of an investigator going to see the safety of the child. Thank you.
Thank you. Questions? I'm going to start on my left. Delegate Arkin.
Oh, thank you so much. I was expecting you to start over there. Okay, I've got a couple. So, all right, let me see here. My first question is, and let me pick a responder just because there's a lot of you. How about Ms. Stein? Okay, so you had mentioned you're a court-appointed special advocate for children.
Yes.
So in the BIA-GAL discussion, where do you fit in?
Sure. So we are actually separate from all of it.
Okay.
In Maryland, as we were talking about, Maryland does it differently than some other places, but
Right.
for our... Yes.
Sorry, we're all a little deaf here.
No, that's fine. So we were saying that, Maryland does things differently than in other places. So in Maryland, the CASA programs are independent. We are not parties to the case. We are friends of the court, which means the court appoints, we are in Maryland statute as a tool of the court where our volunteers can be appointed to the case of a child in foster care. We are provided a court order that has that person's name on it that allows them to, with training and supervision and screening and all of those sorts of things, to be able to talk with everyone involved in the child's life and make an assessment of what's in their best interest and then advocate for what they believe is in the best interest of the child. Okay. Now, the one distinction I want to make sure that you're aware of is that we don't get involved until there is a SINA case. So we are not involved in this portion of the case in the early investigative stage.
Okay.
And to answer the other question from earlier, children do not have access to a court-appointed attorney or a CASA or anything at this point of the case.
Okay, that is super helpful. So now I can see much better the picture. Okay, and then, let me see. I've got a couple written down and I want to make sure I throw them to the right folks because I've got a really kind of messy notepad here. We talked about imminent threats and maybe Allison D'Alessandro would be the best one to respond to that. So right now, if there's an imminent threat to the child's safety, like somebody had mentioned the dog bowl case, obviously not feeding a child, right, is, child living in a basement, those seem like that would be an imminent threat. Why is it that is not allowing you to get into those cases that would be the most serious cases? How does that carve out not help?
It is my understanding that the bill reads that a parent from that onset, from the very beginning, could refuse to let let CPS see or examine the child.
Right, well, but that is already the law, though. They can already do that. So in the situation now, let's say you already have a parent today that says, no, I don't want you coming in my house, and no, you cannot see my children. What do you do next? What does the state do next? What's the next step?
I am not CPS. So
okay, does anybody know? Okay, yeah, sure.
Yeah, so I believe that I believe that you're correct that the law currently states that the parent can deny access to the home. That is clearly in section C, I believe.
5709.
In 5709, that's right, sorry, thank you. However, the law does not state explicitly that the parent can deny access to the child themselves, which I think your point earlier was that there are other people that the investigators might talk to. And the reality is they could also, and I think someone else said too, that they could interview the child at school or something like that. However, if the child is not school age, being homeschooled, being hidden away for some reason, and we do know that those cases happen. There's a Rogers Forge case from, they happen not frequently, but enough that we can all name them. Those are the situations where when a worker is not allowed to meet with the child themselves, that's when we have the greatest, most concern of that immediate danger.
So I would say then, okay, let's say you have a situation like that. They have no other access to anybody else in the children's sphere. How does that not rise to the level of an imminent threat towards the child and allow them then to get a warrant to go in?
So what I would say is I suppose it could, but why would we want to create a situation where the worker then has to leave, get a court order, get a police escort, all of the things that are not typical of that initial interaction that both take time and drastically increase both the adversarial nature of the encounter and also the trauma for the child, the parent, for the entire situation. And if it turns out that there was maybe some unknown reason for why they weren't given access to the child and it's not an extreme case of abuse, then we have traumatized that family for no reason.
Yeah, I think, we heard from the earlier panel that the families are kind of starting out traumatized, so.
Which I totally agree. Yeah. Although on the other hand, none of us are arguing not to give that notice. And the argument I heard was that if you start with, hey, I'm here to talk to you about the safety of your children, here are your rights, that's supposed to ameliorate some of that, right? And so I think if you do both, if you start out with the friendly approach where you're presenting their rights, but not including you have the right to deny us access to talk to your child, fine, then the process moves forward.
But then the state can't lie, right? The state shouldn't lie.
But that's what I'm saying is I don't think that it's in current law that they can deny access to the child. To the home, yes, but not the child.
Okay, I'm not sure that distinction has been, maybe there's a court case we can look to see if that's true or not. But to my personal experience from watching some of these cases is that parents absolutely will deny access to their kids sometimes, and a court order is then gone and gotten, and the children are looked at. So at least from the cases I've seen, this already occurs, and there was no penalty that says, oh no, you broke the law because you didn't let them look at your children. That's my understanding from the cases I've actually witnessed. So, okay, I think I have a couple of other questions, but maybe let me give somebody else some airtime and I'll mull about in my head. Thank you, Madam Chair.
Delegate Taylor.
Thank you, Madam Chair. Thank you guys for being here today. Just help me understand, again, I know you touched on it. In section E4, it says the parent or legal guardian is not required to allow the employee of the department or the local department to interview or examine a child unless the interview or examination is ordered by a court.
May I? So there's no court order at that point, though. That's actually not correct in 4.1e. There's a couple of things about 4.1e that are troubling because in talking to the Senate attorneys, there is no court order at this point because there's no case that's open.
Which is interesting right there. So, right, 70% of your cases you don't remove the child, there's no finding. Is that right?
It's 3 to 4% of Maryland kids are actually removed.
3 to 4%.
The second lowest in the nation.
So 97% of the time that you go into a house without giving someone rights, and 53% of all Black children nationwide will have been subject to some interaction with CPS. I'm a mother. You knocked on my door because someone alleged that there's something going on in my house with my kids. I would insist that you have a court order. I would also deny you the right to see, touch, speak to my children, nonetheless search my kids in any way, unless I was ordered by the court to do so. And I know better, but a lot of parents don't. And they're gonna let you in, they're gonna let you see and talk to their children. Their children are gonna be traumatized. You're not gonna find anything. And this is an experience, a traumatic experience that this family or my family will have to deal with for the rest of our lives. Isn't that so?
I would actually counter that the child who's not being, there was no intervention of the abuse or neglect of that child, that might lead to permanent disability and death, that's traumatic. We do have parents that, I think OPD is seeing parents that want to fight for their children and do better, and that's what you're hearing. But there are other parents that are not in that position, where parenting was very unexpected and certainly not what they thought it was going to be. And so you will hear in court cases and protective orders talking to people who have been challenged by child rearing. You know, that boy wouldn't listen, that girl wouldn't shut up, the baby wouldn't stop crying, right? So what we're saying is that we need to have the ability, and this bill has the opportunity, if they so do this, 41E says that the parent or legal guardian is not required except for Section C and K. And Section C is that employee of the department is to see the child and determine the child's safety and of any other safety of the children in the household and interview that parent or legal guardian.
If this isn't Madam Chair.
So it is in the law, ma'am. However, you're kind of misleading by saying they're not required and not that they are required. And that's what we're looking for, that counter. In the brochure, which is, again, already out there, although I don't know how well it's being distributed, it's saying that the department is mandated to do this. And so we need to help clarify to parents and legal guardians how they allow that child to be seen and that safety to be assessed. Because right now, it is creating an adversarial situation, which did influence the fiscal note. Because if you're talking about, I'm being denied the right, let's say it's an employee of the department, I'm being denied the right to see the child, I have this allegation, it might be more serious than we know, or it may be really serious because I'm being denied and I can't collect any other information. So now I'm going to do a petition to removal, get my law enforcement, come in, and I still can't collect information about this, and I still can't see the child. Then we have to remove the child, and then we have a removal proceeding. And that's going to increase the cost. And that's where we are, and we're stuck.
No, I get
we're
it.
stuck. And that's why we can't let this continue.
I understand. I would allege that any interaction with CPS is adversarial.
And that's really unfortunate to hear.
It is. It just is, in my opinion. But let's go back to C and the alleged. The reason why you're there is because you have heard that there's some sexual abuse of a child. Mm-hmm. If that's the case, you come to my home, you say there's sexual abuse, and I say, oh, really? That doesn't make sense. Not in my house. Well, ma'am, we need to see your child. Okay, I'll let you see my child. How do you determine whether there was sexual abuse?
Well, so I'm just going to say that none of us sitting here is a current DSS worker. I was a foster care worker. I was not in investigations, and it was 20-plus years ago. I don't know if
Pediatrician might have something to
Yeah,
say.
so I am the pediatrician at several child advocacy centers, and so I don't go to the home, but I work a lot with the social workers who do the initial response, and what they do is get minimal facts. They get basic information, and then there's a referral to a child advocacy center, which is a multidisciplinary place where kids have the opportunity to talk with an interviewer who is not part of the, who is not an investigator. It is a very, the process is meant to be very non-leading. If the child chooses not to talk, there's no forcing the child to talk. And then the child has the opportunity to have a medical evaluation.
At the time?
So when they come to the Child Advocacy Center, they can either have a medical evaluation that day, or they can come back and have a medical evaluation. So I do those medical evaluations. We never force a child to have a medical evaluation. We never force a parent to let their to have their child be examined. This is not, this is focused on the safety and the well-being of the child.
I understand that. Thank you.
Thank you. Delegate Phillips.
Thank you, Madam Chair, and thank you, panel. I want to, and just one person can answer this question for me. Is this panel suggesting, well, let me start here. Is the panel suggesting that the rights that have been delineated go beyond the rights that a parent has today? Can anyone, just one person? Are you suggesting that the rights that are going into this pamphlet are different than the rights that a parent has today in an interaction with DSS?
There are legal interpretations that, yes, 41E goes a part past,
Okay.
I mean, E14
So
does.
let's look at, I want to read this, E4.
Yes.
The parent or legal guardian is not required to allow the employee of the department or the local department to interview or examine a child unless the interview or examination is ordered by a court or is required under Section C. I'm going to stop there. Under Section C, what is required? Within 24 hours after receiving a report of a suspected physical or sexual abuse of a child, blah, 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 they have to be seen. Or within 5 days after receiving a report of suspected neglect or suspected mental injury. So the parent does not have the right, if you have a report of sexual abuse of a child, to deny access. Wouldn't you interpret, that's how I interpret, that's how I read the law.
So Section C says, see the child and determine the safety of the child. It does not say interview or examine. That goes beyond.
Okay.
And there's
Now,
no,
but is that the
court
right
order.
today? What is the right of the parent today?
They have to be able to see.
The parent is required to allow the employee to see the child. That is a
see the
mandate.
child.
To see the child and determine the safety of the child and any of the
Correct.
children in the
So
household.
this isn't changing anything. This is following the existing rights that parents have with the interaction of their children. So this is my next question. Are you suggesting that the fact that we're saying that we would like parents to know their rights before the interaction, you would prefer that they not know their rights?
No, sir, not at all.
Okay, but these are the rights that they have today, correct?
I think it's an issue of language that,
What I hear you saying is you want us to change the way the rights are today of the parent so you can see and examine, because that's not what it says today.
see and assess the safety.
of the
So sorry, may I say something? So what I would say is the way that the language is written in that section that you were just reading where the worker shall, right? It says shall.
Shall, yep.
See the child and assess the safety. And as a I do not believe that the worker is able to assess the safety without speaking with the child. And therefore, I believe that telling a parent that they can block the worker from speaking with the child is giving them a right that they don't currently have.
But we're not saying that. We're not saying that.
Why not?
Because they're referring back to C, which says they can see and assess.
So I agree with that, but I believe that that means that the way that this bill is written creates a right that actually doesn't exist because of C, right? And so it's saying, here, you can do this, but no, you can't do it because of C.
So it's still saying you can't do that unless that allegation is made. So you can't go in for any other reason other than these allegations.
Well, right, but the allegations are abuse or neglect.
The allegations are physical or sexual abuse. And then in 5 days, suspected neglect or suspected mental injury.
Right.
So it's 24 hours for those, and then
yes, which are the only reasons DSS goes anyway.
Okay. And so my sense is we're debating this. In my interpretation, it's already covered. But that's me. I go back and I appreciate the work that you're doing. I also was a court-appointed attorney under CASA many years ago. It's a whole story to that. It's a whole story. But anyway, so I appreciate the work that you're doing. And I understand the importance of the interest of the child. And I don't, in my interpretation is, I don't say anything that takes away from the interest of the child. I think it's just educating parents and allowing them to make informed decisions. Thank you. Isn't that so?
Isn't that so? Thank you so much. Delegate Simpson.
Okay. Whew, it's a lot. I was a child protector. There's my disclosure. I was a CPS worker. I was both on the continuing side and I was on the intake side for many years. And then I went on to the advocacy side of actually with the Citizens Review Board for Children, the child protection panels. So that's where my background is coming from. And I know we've come a long way since then. So, and this body has a responsibility to everyone involved. And I think often we just we're just picking one or another, the parent, the child, whatever, or the department. And some of the testimony seems to be a little bit more about like the worker and the worker's rights. I've never heard of that one before. So we have a responsibility to, the best parents have good boundaries, right? We are trying to teach good boundaries. Rights are boundaries, right? Saying what is your right as a parent. It is good. I mean, we have been trying to teach, is it correct? We want children to know, that certain people can touch them and where they can touch them and all that other kind of stuff. So shouldn't we also be teaching the parents what is appropriate and what is not appropriate? Yes. Okay? So there does seem to be in this particular, I'm not going to say in the bill, it seems to be in the testimony in the different sides, there's a lot of gray area and maybe some misrepresentation of what it's doing. It's like you're either for it or you're against it, and I don't understand this. Where is the favorable with amendments? Because clearly boundaries and rights are important, right? This comes from a really good, as someone who's done this comes from a really good place. I mean, the whole point I felt, and I know that my colleague who also is, does this, is trying to teach people how to be better parents, help them to be better parents. And for that, what was the percentage of where they're placed? And
3 to 4.
Okay, the 3 to 4 that you come across that where they are harmed, then that's a different story, right? For the stories that we have, that's different. How do we get you to, where's the amendment? I hear there's a problem with the 4 to the 5, right? I hear, is that the question of, I agree that if somebody is saying that the child is hurt, I should be able to see the child. Examine the child may go a little
may go a little further than, and I don't think it's a bad thing for a parent to know that they still have rights to make sure that they protect their children.
There is a question coming, you guys. I promise you. My colleague is going to ask a question in a minute. Can we get to the question?
What are you okay with? What are you okay with? Because they do have a right to boundaries and rights and the safety of their child.
And go ahead.
Okay. Delegate Simpson, for the last 2 years, we have provided amendments to the bill sponsor, and they have not been accepted. So I just want you to know that we have tried, and we have tried with E14, and rewrote it, but it did not make it into this bill. I know Department of Human Services also had language that we were hoping that would get into the bill. So I think that we probably could work with this. This is the part that I think most of the coalition was worried about, was the interpretation that just on its face, I don't have to allow this employee to see my child. And I think if we can make it clear that they are required to do so, and making sure that goes into the brochure and the notice, I do know that the Maryland State Attorneys Association is also opposed, and their interpretation, they're concerned about the interpretation of Section E. And I believe there are Senate attorneys that are concerned about the interpretation of Section E. So I don't think I'm talking out of school. I know that people are looking at this and saying that does not clearly protect children from abuse when the state is mandated simply the initial contact and the safety assessment. That's what we're talking about. But that is such an incredibly important safety net. And if we don't protect it, not only am I concerned that we're going to have the wrong children removed and have more removal proceedings that we should be enduring in the state, but that people are going to stop calling and making reports because they don't think that they're actually diligently investigated. Because neglect is hard to see, right?
To be clear, when I was in Child Protective Services, I thought everybody was going to love me, right? I thought I was doing it, but nobody did. The people that called didn't think I went far enough, and the people I knocked on their door literally hated me. So it was only the people like the folks, the justices and things like that, where we had our own kind of little gang. Nobody gave me a Christmas card of, well, thank you for taking me from my mom. It's an awfully big thing to say all of E, because E is 9 different things. It's 9 things here.
It's the totality of E is the concern.
So when you're writing your written statements, tell us, we're okay with this. These are the things we have issues with. Doesn't that seem fair to say? I hear you say you sent it to the bill sponsor. It's coming to us. So to see
back in November and last year, and it didn't end up in the bill. So that's why we're opposing straight out, is that we've tried for the last couple of years.
If you can send all of us what it is that you are recommending, what you are okay with, because once again, I hear the bill sponsor, and I do think boundaries, as someone who was knocking on that door, I think boundaries and rights and the safety of the child, all of these things are very, very important. We're Child Protective Services, right? Let's not throw out the baby with the bathwater.
Isn't that so? Okay, Delegate Archon.
Bite, Madam Chair, I really appreciate it. Okay, so while this conversation has been going on, I've crafted this idea. I'm trying to run it through, and so you can just give me a yay or nay or whatnot. But I'm imagining maybe a world where we lay it out more clearly for the parent, where we actually have to give them a form, and maybe on the form it uses that language from C, and it says sort of suspected physical or sexual abuse, and there's a checkbox. They have to check which one it is, and then they let them know, today you have a right to deny us access, and then they just quote from the quote straight from the code, and under that it says, but within 24 hours we have to see your child. Just pull it right from the current language so that the parent sees, this is the form we're giving you, here are your rights, we've checked which box is applying in this case, and then give that form to them. Would you guys be opposed to that?
I mean,
As long as it's 8th grade reading level and people can understand it, I think your challenge is going to be DHS's legal counsel, that's all.
Well, we've been dealing with the departments and their legal counsel for a minute over here, so. And they aren't here today for us to bother, so we'll bother them off the record, I guess, but they'll still be bothered. Thank you very much, I appreciate you.
Thank you. And the last question is Delegate Woods. No?
Thank you, Madam Chair. No, I'm sighing because this is very difficult for me, because I am the child who was not interviewed. I am the child who made the allegation. I am the child who was told what happens in this house stays in this house. I am the child who it took years for someone to realize that what I reported was actually going on. So this is very personal for me. And for that reason, I need to know how we come to that medium where, yes, I understand this isn't technically a child welfare bill. I understand that parents absolutely positively should have rights, but somewhere in the middle, somebody's got to get to that child. And my question is, how do we come to that medium? Because somewhere in the middle, we have to get to that child. So that was my question. How do we come to the medium with the understanding and respect that, yes, parents should have rights? My colleague, Delegate Taylor, said, you know, I wouldn't let you talk to my kids. I wouldn't let you, you know, and that's what happened. I made the allegations, but I was considered a child with a big imagination and all of these other types of things. And it wasn't until years later, when the worst could happen, that it all came out. And so I'm asking both sides, what can we do to make this not happen?
I actually think we're going to, oh, I'm sorry, go ahead.
Oh, I just wanted to say thank you for bringing that up, and I'm so sorry that that happened to you. This should not happen to any child. And I agree that we should be able to have a conversation and come to an agreement about what appropriate language is acceptable to both sides.
And I will just add another thank you. And I actually had a story to share from a colleague that is very similar. She couldn't be here, but she wanted me to share. I just ran out of time. But I hear that. And I actually think we are somewhat close. I really do. Because all of us, again, are in agreement with the notice, the brochure, the importance of the parents knowing the rights. We just need to find a way to have this one piece there so that we are sure that the child is not being left out of the equation. And I really think we can get there, but this bill is not there yet. And so that's what we're looking for.
I just have a quick question, Madam Chair. Eloquent speech, colleague. Just wanted to say, I was thinking if we would be violating some of the federal laws where we could lose money as a state, you know, because there are, and I'm going to defer to you, Dr. Lane, because you maybe know a little bit more about the federal financing, but that was just kind of a concern that if let's say we did it the way you don't like it, okay, we make that change, but yet we're not putting the issue of the protection of the child up first. And if this could be a problem with federal monies, not that they like Maryland, but you know what I'm saying. I mean, I think you do have to be concerned about that because, you know, we need money. So anyway, I guess maybe we'll have to ask our folks on appropriations because I honestly don't know.
Yeah, I don't know the answer to that.
So does anyone know the answer on whether or not we would lose any federal funding? No?
We could get back to you.
Okay, thank you. Can you hear her? Members, do we have any other questions? Seeing none, that concludes this panel.
And I believe it concludes.
Thank you.
The testimony, the hearing for House Bill 890.
Ma'am, there's no one on virtual?
I'm sorry?
No one is on virtual right now?
Let me find out for you. Hold on. No one's on virtual.
Thank you.
Thank you. Okay, members, we're going to now go to, I don't see no guys, so the judges. Yeah. We're gonna go with House Bill 899. And this is a bill with the Judicial Conference. We have Judge Diana Smith, Chief Judge Morrissey, I saw you, and Judge Lisa Hall Johnson. Great.
Good afternoon, Madam Chair. For the record, my name is John Morrissey, and I represent the District Court of Maryland. We're here on behalf of H. Bill 899 seeking a favorable report. That bill prohibits a private home detention monitoring agency from soliciting business on the grounds of the courthouse. We think it's a pretty straightforward bill. It simply adds to the list of those prohibited from soliciting business in the courthouse like bail agencies, which already exist in the law. With me to my right is Administrative Judge Lisa Hall Johnson, who's from my home district, District 5 in Prince George's County. She represents that district for the district court. And I have Judge Diana Smith, who's the judge in charge of which courthouse?
Wabash.
Wabash. There's 4 of them in the city. So she represents the city here. I'll defer to these 2 colleagues about the specifics because they live with it day in and day out. But the judiciary is only the payment vehicle. If you remember how this occurred back during COVID, we simply pay the invoices, but we have no regulatory oversight over the private home detention monitoring agencies. There's a licensing authority through the Secretary of Public Safety, but there's a whole gap in between. So we need this regulation because it's been an ongoing problem. We also have worked with members of your committee on the work group. We have one through the Justice Reinvestment Oversight Board that we're looking at all things pretrial, including private home detentions. We hope probably not this year, but next year to come back to you with a more comprehensive solution for regulations of this industry. With that, I would turn it over to Judge Hall Johnson. We are in support. I'd like to go on record as noting that, so.
That's important.
Yes. It is our bill, but I'm not sure I get credit for that, but.
Thank you, Chief. Thank you, Madam Chair. Thank you, distinguished members of this committee. I'm Lisa Hall Johnson. I'm the Administrative Judge of the Prince George's County District Court. I'm here urging your support for this bill. This bill is not radical. It's not even original. It seeks to apply the standards that the General Assembly passed back over 10 years ago in criminal procedure, which now codified in Criminal Procedure 5-210, prohibiting bail bondsmen from soliciting on courthouses and at correctional facilities. And the private home detention industry expanded, as Chief Judge Morrissey mentioned, during the pandemic, but this loophole was never closed, right? And so these agencies are operating within this loophole, and we're simply seeking to close that. They serve the same clientele as the bail bondsmen. Some are really the same corporate entities, different divisions of the same corporate entities. But their clientele are defendants who are incarcerated, who are seeking to be released, or their family members, right? And so these are people who are in court. It's a vulnerable position. It's an emotional moment. We're in the courtroom, right? And they're being approached by these agents. They're being given marketing materials in open court. I can speak to my experience in Prince George's County. I've been approached. My administrative assistants have been given marketing materials. It's been mailed to me. I've had judges, the judges that I'm so honored to supervise in Prince George's County, while they're on the bench in these proceedings, while they're taking a recess, they're approached and given marketing materials. It's also a security concern. As they're engaging in this sort of open air commercial free market competition in the courthouses and the courtrooms, there's tension between them. They're jockeying for position to the point where bailiffs have been called to de-escalate these interactions. And so we're simply asking that there be clear boundaries set in legislation and clear
sanctions for violations. Thank you.
Good afternoon, Madam Chair, members of the committee. I am Judge Diana Smith. I am the judge in charge of Wabash District Court in Baltimore City, speaking in support of House Bill 899. In Baltimore City, you can imagine that families come to the court for circumstances that are already charged issues, relative standing trial. House Bill 899 seeks to establish reasonable parameters of conduct for electronic monitoring companies. Recently, not only have I seen a representative in open court, again, handing out business cards, whether subtly or overtly, soliciting the assistant public defenders to choose their company over another company. But I've also had one representative go so far as to approach the bench and approach the presiding judge, myself, and question me as to why I did not select that particular home monitoring company over others on the docket that day. Speaking in support of House Bill 899, establishing parameters, ensuring that families that come before the court in support of their relatives or for their own matters have a safe space so that their legal issues are resolved without them being solicited for business, without our bailiffs having to resolve fisticuffs nearly with electronic monitoring companies. And for those reasons, we seek a favorable report as to House Bill 899, speaking in support of. Thank you. And if there are any questions.
Thank you, and that's my job. Members, do we have any questions? Delegate Simmons?
Thank you, Madam Chair. And good to see you, Honest. I'm looking here at the fiscal notes, and it talks about a 30-day suspension. Is the suspension for the company or the individual that's soliciting, based on any fines that may be submitted?
I think that would be determined by the situation.
Okay.
I wrote them a letter about this.
Right.
I think sometimes it's more the individual than the company itself, quite frankly, but it's going to be on a situation by situation basis. I have no power. I just wrote them a letter. I referred it to the Department of the Public Safety. They also wrote a letter, but we thought it best to get it inscribed in law so that we have the authority to say you can't do this.
Okay, so would that lead to like a trespass, or what would be the action here? I'm trying to understand the action.
It would be a revocation of their license ultimately.
Okay.
But again, that's with the Department of Public Safety. It could be a misdemeanor if they could be charged with it if they keep doing it.
Sure. Thank you.
So I just have to ask my question because it kind of leads there. I noticed that we're in the business occupations and professions as opposed to the way we did it with the bail bondsman. We put it under the criminal procedure code. Is there a reason for that, or it's just?
Bill drafting?
Okay. Works for
It
me.
wasn't our preference. Our preference was for the other.
Okay. All right. Thank you. Delegate McComas?
I was just thinking about campaigning and, you know, how they say you can't get too close to the election. I was wondering if maybe that might be something where you could put some little signs out and say, you know, once the law's passed and how you do it, to say, hey, you know, you can't solicit.
Thank you for that question. I actually did that, right? I put a sign on the courtroom where I hear these cases, and it continued. I emailed them directly, and I said, please stop. And they responded in my email and said, oh, Your Honor, can we come meet with you and give you our marketing materials? That's when I went to Chief Judge Morrissey and said, please, can you write them a letter? And he did write them a letter. And then I think after that, Judge Smith's incident happened. So this legislation is necessary because we need clear parameters.
Oh, yes. Legislation's not necessary. I'm just saying, you know, because these guys are probably not necessarily going to realize that this law is passed, you know, because there's so many laws that are, and so then you really got to get the word out.
Absolutely.
And I was just thinking of those little signs that, you know, you can't go any more closer to the polling place.
Absolutely. I would say that most.
Because you guys aren't elected. You don't pay
I would say that
attention to
most of
this
these
stuff.
entities are also bond companies, and they know when they're operating as bail bondsmen, they can't do it. They already know it.
Yeah.
I was, Delegate McCombs, I was the board attorney for the election board for Prince George's County prior to becoming a judge, so I'm very familiar with this and had to deal with them on a regular basis.
Thank you. Delegate Cardin?
Thank you, Madam Chair. Thank you all very much. I've been in front of 2 out of the 3 judges, but Judge Morrissey, I've never been in front of you before. So, and thank you guys.
So I'm batting 100% with you so far, right?
So first of all, I noticed there's no opposition to the bill. At least there's no written opposition to the bill, according to what I have here. Are there concerns perhaps that, for example, so I see a lot of drug treatment and assessment folks in the courthouses also there to help. I don't know whether they're soliciting or they're available for people. Is there a concern that they're going to be the next ones? That's question number 1. And question number 2 is, you have the ability, you guys know this better than I do, you have the ability to put home monitoring, but not through a private, but through some sort of governmental or judiciary. Is there any issues with that, the conflict there because you're not allowing these folks to compete?
So I could go on about this for an hour, Delegate, if you wanted me to. No. I won't. I promise I won't. But there are county-based home detention centers. In my own opinion, and I'm pretty sure the opinion of both of my colleagues here, we would much prefer a county-based run through either the detention center or the sheriff's office than private home detention. But this is not every county has adequate, sufficient space to run these, or they don't. We have a committee I'm on the Justice Reinvestment Oversight Board. Judge Kathy Cox, who is a senior judge, formerly Circuit Court Baltimore County, is the chair of that, and Dorothy Lenning staffs it through GoCap. I asked them if we would please use that vehicle to look at all things pretrial, including private home detention and alternatives to it, or regulations, and we're hard at work at it. Judge Carlos Acosta out of Montgomery County Circuit Court is the chair of the Private Home Detention Committee, and we hope to have a series. We're not ready for prime time yet, but next session we hope to have parameters. And my idea is that we set it up very similar to the way justice reinvestment works, so that we know that there's technical violations and non-technical violations. Because the problem is just bigger than just solicitation. It's when are we notified, how are we notified, what type of notification are we getting? Right. And there's a bill that will come before you, I believe it will come before this too, with respect to that, that lessens that. And anyway, I could keep going on. We would much prefer county-based home detention than private home detention, but the attorneys control that. So when I was private counsel or the public defenders, I would set all that up with whatever company my client was going to use, and then I would present it to the judge. That's rather than them coming directly to the judge. It's not proper. It would be the attorney that would proffer and say, Your Honor, I've set this up through X agency. They've agreed to accept the monitoring. It can start tomorrow, and then the judge would make the decision.
That's how I've always seen it being done, especially when you're dealing with DWIs or other, where everything's set up in advance.
Yeah.
You don't do it right there in the courthouse.
And it's the same with substance abuse and things like that.
Okay. Okay.
Great. Delegate Embry.
Thank you. Thank you for bringing this bill. I just want to make sure I understand how the 2 suspension provisions, the first and second offense, interact with the referral for appropriate action. Because I worry that if you specify a time of suspension, then that sort of subsumes the appropriate action mentioned later. But maybe I don't understand.
The powers of suspension are through the Department of Public Safety's. Ultimately, it could lead to that. But what we're faced with right now is is an ongoing event, or has been an ongoing event. We just want it to stop. I don't want to penalize anyone. We just want them to get notice officially under legislation that this is not permitted in the court, and that if they keep doing it, they're going to get charged. We'd refer it over to the state's attorney at that point.
Would it be cleaner not, to not have those, if you can't suspend, I mean, would this legislation authorize the suspension? I think it would, and then I'm just trying to understand, either we refer it for appropriate action or there's a suspension in the.
I would rather have it referred for appropriate action. The suspension process can take a considerable period of time.
Okay.
We've been through that with one monitoring agency that was suspended. And again, I could talk an hour about that. But it ultimately came to the right conclusion, but it required us to move hundreds of cases. It was a very trying time to make sure that people would continue on supervision even if a company was getting their license suspended. So
I appreciate that. Thank you.
Thank you. Delegate Taylor?
Thank you, Madam Chair, and thank you to my constituents for being here.
Thank you for having me.
This seems like the activity has increased recently. Is that the case, or is this an ongoing, persistent issue? And the reason why I'm asking is has this body passed a law, or has there been some new policy that has encouraged this new flurry of activity? I also sit on the home detention monitoring work group.
Right.
And potentially, if there's something else we can be dealing with in that work group, it'd be great to know.
One thing, and then I'll turn it over to these two, is that we hope that the legislative work group will merge with the Justice Reinvestment work group to work together to come up with these solutions. I'll turn it over to these two for their experience. It was funded originally out of COVID monies, out of CARES Act monies, and it took a little while for the industry to mature, I think. But now it's, went from 1 or 2 agencies to now 6 agencies that are licensed in the state. So.
And I would say that's part of the answer, right? There are more agencies that are competing, and so they used to sort of be regional, and now they're sort of coming into each other's territory, and it's causing a bit of an aggressive competition.
That is exactly what I was going to say. It had not ever been the circumstance wherein, as I called my docket, there is literally a representative from a home detention company watching while I'm doing bails, because during the bail review process is where electronic monitoring would ordinarily be ordered. It had never been the case that someone from the different companies would sit and watch, and as soon as the court made an indication that electronic monitoring would be authorized, would someone then appear, or if the family member went into the hallway. So it is, I believe, just the competition and vying for the funds or the human capital, if you will.
Yeah, thank you.
I remember a court case that I had when I was still sitting in Upper Marlboro that it was minor traffic that involved an ice cream truck. Believe it or not, the sound from an ice cream truck can only go so far. There's regulation on it. I had to look that up because I hadn't dealt with it. And then a few cases later in the docket, there was a series of about 15 other ice cream truck citations. And so I asked the police officer what was going on, and they said it was a turf war. And that's the relevance to this. If I made any relevance at all to this, that was the real. And that's one of the beauties of the district court. It's why it keeps it interesting in the district court, because you deal with human nature at that level. It's great.
Right.
It's a wonderful job.
And don't worry, we don't object in this committee. Not often, anyway. Okay. So members, do we have any other questions? I see none, so that concludes our testimony and our bill hearing for House Bill 899. We're going to move on to we're going to go to Delegate Schindler. I think I saw a Delegate Schindler. Yes, I did. Okay. House Bill 834. And Delegate Schindler, I have a favorable with amendment. Caitlin Snodgrass, are you all in agreement? Do you want to? Okay.
Yes, ma'am, if that would be okay.
Okay. Come on in and have a seat. And whenever you're ready, we'll start the bill hearing for House Bill 834.
Thank you, Madam Chair. Madam Vice Chair, honorable members of the Judiciary Committee, for the record, I'm Delegate Matthew J. Schindler, and I'm here to present House Bill 843. House Bill 843 would alter the definition of child neglect to I'm sorry, yes, I believe so. My apologies. This would alter the definition of child neglect to include the failure or refusal to provide a child with an education as required by law. This bill is to ensure that a child's right to education is upheld and that services and interventions can be introduced to families who require them. Access to education is a fundamental right and is a critical component to the long-term physical and mental health and development in adolescence. When our caregivers neglect to properly enroll, provide, or facilitate a child's access to education, the harm can be irreversible. Students who miss weeks, months, or even grades entirely are at risk of being unable to perform basic reading, writing, and mathematics skills. Additionally, a child's mental health can be negatively impacted by the inability to socialize and learn with their peers. The deprivation of education carries lifelong implications that include limited literacy, reduced job opportunities, and general instability through life. As we've made a commitment to education in this state, most of you know that the only stability many of our students get is the warmth and meals and guidance provided to them during the school day. Many states through the United States have recognized educational neglect as a needed specification within child welfare law. 24 states have explicit educational neglect statutes, including New York, New Hampshire, Delaware, West Virginia, and Oklahoma. These states have recognized the need to categorize this type of neglect and ensure that there is a legal way for the educational neglect of a child to be identified and triaged with solutions. Without the statutory clarification, children who are never enrolled or perhaps unenrolled for long enough fall through the cracks and never receive the help that they need. Our bill clearly defines a child's right to education. Tragically, in our district in the year of 2023, a 6-year-old child starved to death in his home. This child was never enrolled in school. This bill could have saved his life. I've heard some concern from DHS, not on the merits of an educational neglect, but on the capacity to deal with what they fear would be an untenable amount of increased neglect cases. I unfortunately am very frustrated by that. We have received a favorable with amendments from our local Board of Education. This would narrow the definition of educational neglect that I think would help in DHS's unfavorable. We want to allow school truancy officers to do their jobs, but we've seen that children who may have moved to another state or never started school or missed school long enough they've been unenrolled or simply never got enrolled in the first place. Many of these children are unhoused, and we're seeking a way to provide help for these forgotten children. Attached, I also have some data that we have for children who have been Code 50 unenrolled. And with that, I'd like to ask for a favorable report on House Bill 843. Thank you. 834.
Thank you. Are you ready? Do you have any testimony you want to provide?
Yes, ma'am.
Okay, you're next. Thank you.
My name is Caitlin Snodgrass. I live in Hagerstown, Maryland, and I support this bill. School is the most effective social safety net to prevent child maltreatment. Maryland has an astoundingly high number of unaccounted children in the public school system. I became aware of this issue after advocating for a homeless boy who became Code 50 for the second time in his life at only 7 years old and proceeded to miss the next 3 consecutive years of school. I tracked him through 3 states for 2.5 years by myself. At one point, I found him in a drug house and I paid a drug addict $50 to let me take him for a day. Maryland DSS refused to assist during this time because missing 3 years of school is just truancy. That's all we define. And truancy is not neglect, so DSS will not get involved. I eventually succeeded in having him taken into state custody in Maryland, where he remains to this day. Keep in mind, he was not removed for truancy. When young kids When children, especially young children, don't have access to education, they're likely experiencing other forms of neglect and abuse. Make no mistake, Code 50 is a crisis of epic proportion, yet the public is completely aware, and even most politicians are completely unaware of the Code 50 crisis because Maryland State Department of Education hides over half of the data from the taxpayers. They refuse to include kindergarten through 6th grade in their yearly attendance report, and I find that incredibly unsettling. So I made 7 public records requests in 7 different districts, and I've found thousands of elementary children who are becoming Code 50. Maryland has designed a system that allows kids to fall off the radar of public schools with minimal effort to return them. Schools are burdened with all investigational obligations surrounding Code 50 children. They don't get assistance from law enforcement or from DSS. I support this bill with an amendment to the Maryland Student Record Systems Manual, which is the guidelines for how schools intake and exit children. I would like to see schools required to employ the assistance of law enforcement to locate Code 50 children whose welfare cannot be confirmed.
Did you get a chance to finish, Ms. Snodgrass?
I'm sorry?
Did you get a chance to finish?
No, ma'am.
Okay, go ahead and finish what you were saying.
An amendment to the Maryland Student Record Systems Manual requiring schools to employ the assistance of law enforcement to locate Code 50 children whose welfare cannot be confirmed. Please note the data that has been provided to you. Please take a look at 2019 to 2020 school year. 18 elementary children became Code 50 that year. Only 4 of them have returned to this day to school, and 6 years later. School can save children's lives. 6 states require shelter for dogs. 0 states require shelter for children. The bar is set incredibly low. If all we can do is guarantee a child 8 hours of normalcy at school, then we really need to be trying harder. Thank you.
Thank you. Delegate Schindler, why on earth did this have a $338 million fiscal note? Can you explain that?
Yeah, that was the same reaction I had, Delegate. Thank you, Madam Chair. So the Department of Human Services estimates, when we spoke to them, they said that there's something to the effect of 20% of children are chronically truant, and they base their numbers of additional staffing needed based on the fact that they think that they would have to investigate 20% of the enrolled school children in our school system right now.
Okay. Delegate Ericon.
Thank you, Madam Chair. Thank you for bringing this bill. It seems like it's a really big issue, obviously with a bizarre fiscal note, but I can actually see there is a high truancy rate, and so if they did feel the obligation to investigate all of that, is it maybe possible that instead of putting this here, we could put something in another location? Instead of adding to like the neglect statute, could we change what the Code 50 response policy in the school system is or something like that?
An amendment to the Maryland Student Record Systems Manual?
Yeah,
Yes.
like something like that, because I can see how this bill could have, maybe not that big of a fiscal note, but a big fiscal note, because it's a lot of kids. We had a lot of ghost kids that just vanished during COVID and never came back. Where did they go? By the way, I would love to know what happened to the little boy that you were following. Did you find him? And
He's still in Maryland State custody, yes.
Okay.
He goes to school every day now. He sees a doctor. He's in foster care.
Okay, and you still have some access to him, or does he still get to talk to you ever?
No.
No? Oh, that's a shame. It's always nice when they can have the person that has been invested stay close. But, okay, there may be a way to accomplish what you want without triggering so much insanity. So the only problem I'm thinking in my head is this bill wouldn't be the vehicle for it because it's in the wrong part of the code. So you may actually need to go through ways and means to fix it. But yeah, I see what you're trying to get at, and maybe we'll talk offline and figure out.
I appreciate it, Delegate.
Yeah,
Thank
there's
you.
a solution, yeah.
If I'm able to add one thing, some of these children have never been enrolled ever. So an amendment to the Maryland Student Record Systems Manual would only handle Code 50 children. The highest risk children are those who have never been enrolled ever, like the little boy who starved to death in Hagerstown, Maryland in 2023. Starvation takes a very long time. The lady was pulled over in Baltimore in 2021, and they found 2 dead children in her trunk, 5 years old and 7 years old. Neither of those child even had a missing persons report placed for them. A lot of these kids are dead right now, and nobody knows. So an amendment to the Maryland Student Record Systems Manual by itself will not cover children who have never, ever been enrolled. And I'm not exactly sure how to gauge that, but I'm so happy that this conversation is being had.
Yeah, we appreciate your advocacy. Thanks for following that little boy. He
Thank
had
you.
an angel.
Mhm.
Members, do we have any other questions? Seeing none, that concludes the favorable with amendment testimony for House Bill 834. And now we're going to hear our unfavorable testimony from Haley Lichterman. Whenever you're ready.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Haley Lichterman, and I'm the Deputy Chief of the Parental Defense Division at the Maryland Office of the Public Defender. And today I'm here to ask for an unfavorable report of HB 834. Current law in Maryland already covers educational neglect. And so Maryland is one of the states that already does have a cause of action for neglect when a child is not going to school. We at OPD see these cases daily, both in the context of SINA and truancy court. In 2023, in Maryland, 67.7% of screened-in reports were unsubstantiated or ruled out for neglect and abuse. That amounted to over 15,000 children that were investigated with no finding of wrongdoing. In Maryland, we have an over-reporting problem, not an under-reporting problem. Nationally, educators are among the highest reporters, but their reports statistically are also the least likely to be substantiated. Educators with their own limited resources tend, with good intentions, to report issues that simply cannot be solved by DSS. Over-reporting is harmful as it drains resources from an already burdened system, and for all of those reasons, I would oppose HB 834.
Thank you for your testimony. Delegate Ericon.
Thank you, Madam Chair. Thanks for being here and for staying. So obviously, you heard the conversation we had before. Like, is there a way for us to take it out of this neglect code and sort of maybe, I don't know if you guys even touch on these policies inside the school system at all. Would you have an opinion if we did something with Code 50 students where there was kind of some kind of educational follow-up or that it was inside the school system? Would you have any opposition to that?
OPD wouldn't have an opposition to that. Actually, I thought your question was good because the issue that we have with the bill is changing the definition of neglect.
Right.
We see cases all the time that involve educational neglect. And
Yeah.
the story that the woman told, I don't think this bill would have solved that problem, unfortunately. And so I don't see why we would change the definition of neglect to add a cause of action specifically that talks about educational neglect. This is an important issue, and I think that kids going to school is important. They should go to school, but I don't think this is the way to do it.
Yeah, my only other question is she had mentioned how there's just kids that are never enrolled in anything. So there's like kind of almost no tracking of them whatsoever. They're not enrolled in a homeschool program, no private school, no public school. Is there any way, how in the world could the state ever have any, how do we fix that? Do you have any ideas?
I wish
I know.
I wish I had a better suggestion of what to do, but the reality is if you have a kid that's never enrolled in school and never going to school, such as the 5 and 7-year-old who died of starvation, which is terrible, who would have called this report in? It wouldn't have been the school. They're not going to school. And so I think that the concern and really the fiscal note is demonstrating that there's going to be a huge over-reporting of situations that are not what is intended by this bill, and it's going to affect families where the situation is not one of a child who's just not being seen by any system.
Okay, so, I see what you're saying. Your worry if it goes into this part of the code is that what it will actually cause is you guys to be so overwhelmed with cases that the cases that are severe and serious are going to be lumped in with a lot of these kids not showing up for school because they joined a gang, they moved to their dad's house in a different county, something like that. Okay, I see what you're saying. Okay.
And we've seen this, if you work in the system long enough, you see this happen. Unfortunately, when there is a fatality of a child, a lot of times the response of the department agencies is to pull more kids out of the home for there be more reporting. But the result that you see is that it ends up draining resources for CPS, because if a case is called in and it's screened in, they have to go investigate it. And so there are only so many CPS workers. And so the problem is DSS actually doesn't have the resources to address what this bill is concerned about.
Right, and that leads to it's almost like a new department. They're essentially saying, okay. All right, thank you so much, I appreciate it.
Thank you.
Thank you. Delegate Cardin, no longer question? Okay. Members, do you have any other questions? Seeing none, thank you. That concludes our bill testimony and hearing for House Bill 834. We're going to move on to Delegate Martinez, House Bill 566. I saw Ms. Chaudry earlier. Is she still here?
I'm not sure if she's still physically here. I think at some point my office requested that she get a link to Zoom. I know she had to leave for another obligation.
Okay. Do we have anybody in? Okay, so I have Mr. Samad and Mr. Kamal and Samad.
This is for
Talib?
566?
This is for 566.
Yes, Grady over here.
Okay, you're favorable with amendment, so if you can just hold on 1 second, okay? You can just have a seat on the next row, on that row, yep.
Okay.
And then, so do I have Mr. Samad? Okay.
Present.
And then I don't have Youssef Kamal. And there's Ms. Chaudry. I knew if I just kept talking, she'd appear. Okay, great. Delegate, whenever you're ready.
Thank you so much, Madam Chair and members of the Judiciary Committee. For the record, I'm Delegate Ashanti Martinez, here to present House Bill 566, Criminal Law, Distribution of Students' Personal Information Prohibition. The aim of this bill is to establish a penalty for any student who is doxed or distributes a student's private personal information, such as their name, address, or place of employment. At its core, this bill addresses the fundamental issue of privacy, safety, and protection from targeted harassment. In our current digital age, doxing has become a powerful tool of intimidation, often leading to real-world consequences, including threats, severe harassment, and in some cases, even assault or, unfortunately, murder. Other states have addressed this modern-day issue by passing similar laws in order to protect their residents against doxing. Both California and Illinois have enacted laws that establish both civil and criminal penalties for anyone who engages in doxing. Doxing is incredibly dangerous as it makes someone's personal life public and a difficult to regulate medium such as the internet. A good way to think about this is if you've ever heard the phrase, the internet is forever, or nothing ever gets deleted off of the internet. Doxing makes it where someone's privacy is forever violated on this medium. Despite the severe outcomes, current law still provides no direct penalty for an individual responsible for disseminating a victim's personal information. An unacceptable gap that House Bill 566 seeks to close. Existing laws of harassment and stalking often fail to address the role of an individual who intentionally distributed the personal information, leaving victims vulnerable while perpetrators are able to go even if they have malice intent or reckless disregard, and they evade all consequences. Importantly, this bill does not criminalize free speech or public accountability. Rather, it ensures that individuals who weaponize personal information for the purpose of harassment, intimidation, or harm are held accountable for their actions. For these reasons, I strongly urge a favorable report on House Bill 566.
Thank you so much, Chair Bartlett, members of the committee. My name is Zainab Chaudhry. I'm the director for CARE's office in Maryland. CARE is a council on American Islamic Relations. We want to express our deep appreciation to Delegate Martinez for his leadership on this issue. This is an issue that doesn't just affect one community. Over the last few years, my office has handled cases from Jewish, Muslim, Christian, immigrant, Latino students who have been impacted by doxing, and for various reasons. And unfortunately, the way that our laws currently are structured in the Maryland General Assembly, we we currently do not have protections for students in higher education. We do have Grace's Law, which does afford protections for students in elementary and secondary education. But however, according to our conversations with campus police at University of Maryland, we have been told, despite the severity of some of the complaints that have come into our office, including students who have received death threats, who have, in some severe cases, faced suicidal ideation, unfortunately, there's nothing that campus police can do because there simply are no protections on the books for students when it comes to doxing in higher education. As Delegate Martinez mentioned, this bill simply builds on existing laws in the state of Maryland to make sure that all of our children, regardless of race, religion, ethnicity, have the basic safety and mechanisms in place through statute to help protect them from any sort of consequence where the malicious targeting of students unfortunately puts them in a situation where they are fearful of their safety. In many cases, we have heard cases where students have been afraid to go to class, where they have refused or declined on-campus housing because of online attacks. Again, you have my testimony before you, which is much more long-winded, but we would urge you to take action on this issue and just help protect all of our students and make sure that they have the mechanism in place through our General Assembly and through our state that they don't have to suffer the mental, emotional, physical trauma that many students face. Unfortunately, it's something that's avoidable. And we passed Grace's Law back in 2003, I believe it was, after a student tragically took her life. And I hope that it doesn't take another tragedy for our assembly to take action now. Thank you so much for your consideration.
Dear Chair Bartlett and members of the House Judiciary Committee, my name is Imam Talib Abdul Samad, and I serve on CARE's Maryland Advisory Board, and also as an imam and faith leader in Maryland. Every week I counsel students, parents, and families. I sit with young people who are trying to find their place in this world, who want to learn, grow, speak their minds, and contribute positively to society. Doxing is not a debate or a protest. It is the representation of someone's home address, phone number, or personal photos to intimidate or silence them. It has caused students to not be able to sleep after receiving death threats. In some cases, they stop attending class or withdraw from leadership roles. In at least 2 cases, young people confided with CARE that they had thoughts of ending their lives because of the harassment that followed being doxxed. No student, regardless of religion, race, or political views, should fear that a roommate, a classmate, or anonymous online stranger can expose their personal information and destroy their sense of safety. Right now, there's a gap in our law. In cases at the University of Maryland, students were doxxed and threatened, and police said their hands were tied because no specific law addressed this harm. In this digital age, House Bill 566 closes that gap. It does not criminalize protests, punish criticism, or silence political speech. It narrowly targets the malicious release of a student's private identifying information when done with the intent to cause harm or reckless disregard for harm. That distinction matters constitutionally and morally. As both a faith leader and a community advocate, I believe human dignity is sacred. Disagreement is part of our democracy, but weaponizing someone's private data crosses the line. Maryland laws are outdated, and we cannot afford another tragedy before we take action. You have the opportunity to help tens of thousands of our people from all backgrounds by passing this bill. Protecting students from doxing protects their ability to speak, organize, and participate in public life without fear. I respectfully urge a favorable report on HB 566. Thank you very much for your time and your commitment to protecting our students.
Thank you. Members, do we have any questions? Delegate Cardin.
Thank you, Madam Chair. Thank you very much, Delegate, for bringing the bill and for your compelling testimony of your witnesses. I was very involved as the lead sponsor of Grace's Law back in 2003. No, I think it was actually a little later. And then back in 2017, thank you, we did Grace's Law 2.0. The effort there was to prohibit somebody or criminalize somebody's act that was intent to harass or harm or psychologically impact somebody. Doxing could be simply providing information. Now, I understand that it's with intent to or reckless disregard of the risk to the personal, to providing personal identifying information. But how do you see if you are, I'm looking at an example on a college campus. If somebody is trying to promote X, Y, and Z or get votes for the change in the Student Government Association, that they're trying to change something, change one of the bylaws. And somebody puts out there, contact so-and-so, here's her email address, tell her don't do this, or do this, or whatever. And then all of a sudden, 3,000 people from the University of Maryland are emailing this person. That's a doxing event. I think that's protected by the First Amendment. It says this can't in any way impact their freedom of press. But I'm just wondering where we're getting into the intent to harass. It's just even though this could really psychologically hurt this person, right?
I think the basis of your question answers it, right? It's advocacy. They have a particular position that they're talking about because of your scenario, it's student government. That's very different from saying, hey, here's this person's number and intimidate them. Hey, here's just how you reach this person and this is why you should reach them because we disagree with all of these different things and it's not in an organized fashion on how you were to reach out and how are you to discuss this in a civil manner. That is very different than what is happening right now in the real world, the scenario that you presented.
Right, but I'm still concerned that the impact may be just as bad, terrifying, agonizing to the victim if they're getting 3,000 emails. Even they're in the intent. And the intent may be to stop them in their tracks by intimidating them with all these emails, even though it looks as if everything is being done above board. So how is this? I'm looking at it and seeing that it's not nearly as black and white as I'd like it to be.
Thank you for that question, Delegate. The reality is our Constitution protects free speech. It does not protect cyberstalking, harassment, violating personal safety and security. And the way that the bill is framed, the Delegate Martinez has presented, it contains carve-outs specifically for First Amendment free speech rights. We want to make sure CARE as a civil rights organization strongly defends and prioritizes free speech, First Amendment rights, and this is a reason why we haven't taken up this issue for many years, despite the fact that it's been a recurring issue over the past decade or so. The extent to which students have been impacted by recent attacks of doxing, again, students from diverse walks of life, who have diverse backgrounds, it really is chilling to us that students are not protected at all by our laws. Currently, the way that our statutes are written, they do not afford any protections to students in higher education and colleges and universities who are being targeted by online doxing attacks that lead to real-life consequences and harm. In some cases, students have reported being followed on campus. They have reported that the real-life impact of the stalking and harassment has led to them, missing classroom instruction, not going to class, or not participating in activities on campus because there's been real psychological
But the
damage.
doxing, is separate from the stalking.
So the impact, again, the intent and the burden to prove impact is still within the bill. The way the bill is framed, the victim still has to show that there has been demonstrable impact and they are being adversely affected in a way that there is real life harm to them. So there are First Amendment carve-outs for that. We are open to, of course, suggestions and amendments, and there is a cross-file from the Senate that I know Senator Henson is also considering language to amend it to make it stronger to protect free speech. But I would urge the committee to take into consideration the fact that currently, as our statutes are, there are no protections for students who are being affected by this. And the Attorney General, the National Association of Attorneys General, issued a report in August 2025 that's linked in within our testimony that really goes into detail of how this has become a serious issue. And we're proud to have the support of our Attorney General, Anthony Brown, who has submitted testimony in favor of of this. I think that obviously our laws are behind. We haven't caught up to the digital consequences of these kind of harms, but the committee has an opportunity with this bill to provide suggested recommendations on how we can strengthen it to make sure students feel safe.
And just to make sure I'm clear, this is not just though for college campuses. This would be for all adults.
Well, no, this is for students in higher education, I believe.
Only for students in higher
Only for students. So basically, the way that this bill was structured, it was structured as an extension of Grace's Law. Because obviously with Grace's Law, it stops at high school, when students graduate from high school, only for minors. It doesn't extend to higher education. If the General Assembly would like to consider bills that extend to the broader public, and this came up in the Senate committee as well, that if this is an issue, why are we not protecting all people from these attacks, then absolutely we'd be open to considering legislation for next session. But for now, our priority based on cases that we've received and with the support of Delegate Martinez and our friends and allies in the legislature, we want to make sure that students particularly who are vulnerable are protected.
Interesting. Okay, interesting. Thank you.
Thank you.
By the way, I'm just thinking, what if you just extended the age on Grace's Law 2.0 to 25 or something like that?
That came up in the Senate committee hearing as well, and Senator Henson's been working with other members of the JPR committee to work on amendments.
We'll talk, thank you. Thank you.
Thank you.
Delegate. Yep.
Yeah, that might be the way to do it. Okay, Delegate McComas, and then, well, Delegate Woods first, and then I'll go to Delegate McComas.
Thank you, Madam Chair. I kind of have two questions.
You get one. No, I'm just joking. Go ahead. You can ask both.
You're not on HGO anymore.
Thank you. Thank you so much for this bill. Just want to get some clarity. There is a formal definition for doxing, correct? Not under Maryland law, but under what? There is a formal definition.
The National Association of Attorneys General, in their August 2025 report, they do provide a definition for doxing. That's linked in my testimony, and I'm happy to also share that with the committee as well. Again.
So with that in mind, I guess my question is, what harm would it do to not actually include it in your bill? Define it, include it, use the wording.
Yeah, no, I don't think there is any harm. If the committee's will is to create a definition, then so be it. I'm fine with that. Yeah.
All right, thank you, Madam Chair. That's
So those were your two? That was what you
those were my two, and I actually asked three. You missed it.
Well, this is Judiciary. We don't plan.
Delegate McComas, do you still have a question? Can you turn your mic?
Yes, sort of, but I think it's just a little backup. I know that Attorney General Brown had a seminar that was kind of going around about hate crimes and everything, and I attended that. So I was wondering, has he been helpful to try to deal with this issue for you all?
So I think more recently this has come on the radar for the AG's office, and so they have submitted testimony in favor of this. And I'm happy to share a copy of that as well with the members of the committee. The reality is that I think that because of the fast nature of the way that communications electronically, digital communications are changing and evolving, our laws have just not caught up. And so we're in a situation where especially many elected leaders who are in powers of authority and position, they may not be aware of what's happening on the ground. And that's part of why we wanted to bring this bill forward with Delegate Martinez's support, is because we want to help make you aware of the fact that students are suffering these harms and there need to be stronger laws related to this. And yeah.
Was the person that was doxxed, did they have any idea who started it?
In some cases, yes, and in some cases, no. In some cases, the doxing happens behind anonymous online accounts, and so there's no one individual who can be pointed to that they're the reason why these individuals are.
So there's no way to electronically track it back to
Not
where
always.
it started?
Not always, no.
All right. Yeah, that would be very helpful if you could provide that, because it's a bad situation, because I mean it's just it's harassment. So, okay, thank you.
Thank you.
Thank you. Members, do we have any other questions? Seeing none, that concludes this panel. We're going to move on to Mr. Arrear. Favorable with amendment? And sir, you will have 2 minutes when you begin. so that we can hear your testimony.
Thank you.
Thank you.
Thank you, Madam Vice Chair and members of the committee. My name is Grady O'Rear. I'm a Maryland resident. I'm here in support of House Bill 5666. I'm in favor of amending it to provide for civil rather than criminal penalties. The bill matters because it protects student safety without undermining free speech. Students should never have to choose between participating in civic life and fearing that their home address, phone number, or personal images will be weaponized against them. This bill targets harmful conduct, not viewpoints, not peaceful protests, not criticism of government, and not constitutionally protected debate. I speak from experience. Many years ago, as a student at the University of Maryland, I and many other students across the country protested the war in Vietnam and the bombing of Cambodia and Laos. Those protests were instrumental in helping to stop the carnage and to confront actions widely viewed as unlawful and immoral. History shows that organized, lawful public dissent is often essential to correcting government wrongdoing. When the federal government acts in ways that violate international and/or domestic law, it is especially important that residents, citizens, and local and state governments can stand in solidarity openly and safely. Doxing is a form of intimidation designed to silence participation. I urge you to support it with amendments and use every lawful lever you have to rein in federal overreach and restore accountability, including coordinated action through the National Conference of State Legislatures. Thank you.
Thank you. Members, do we have any questions? Seeing none, that concludes our favorable with amendment panel. We're going to move now to our unfavorable panel. Gail Martin. Hi, Ms. Martin, and you'll have 2 minutes for your testimony.
Yes, indeed. Thank you very much. Good afternoon, Madam Chair, members of the committee. Delegate Cardin, who represents me. My name is Gail Martin. I am here representing the National Association of Social Workers Maryland chapter. Doxing is bullying on steroids, and it's a terrible collision between the changes we've had in technology as well as our current political climate. No one should ever be the target of that. And people who initiate it should face consequences without question. I am a retired school social worker in the public schools, and I'm the legislative liaison at NASW Maryland to their legislative committee. I'm not hearing that doxing is happening in our public schools, and I thank Delegate Cardin for giving us the remedy that we do have in our public schools under Grace's law to take that kind of legal action should it be indicated. As school social workers, we're called on not only to look out for the interests of our victims, but also for the interests of those who are the perpetrators, because all of those students involve access to a full public education. I know that all of you are familiar with the term school-to-prison pipeline. We don't need another inlet on the school-to-prison pipeline. We don't have that much of the behavior happening that would be defined as doxing. We see what we have as being covered by Grace's law, and we don't need a new on-ramp to get students headed toward the juvenile justice system. For this reason, we ask for an unfavorable report on this law as written. I heard the one of the witnesses say that this covers college students, but it doesn't. It covers 13 to 17-year-olds, or no, 11 to 17-year-olds, 6th to 12th grade, and we don't need it covering our public school students. Thank you.
Thank you. Don't go anywhere.
Well,
let me just.
I'm sorry. I knew that.
Sorry about that. I just wanted to make sure the members had time to ask any questions, but if you could stay there just 1 second. I have one more person who's unfavorable, and I'd like to hear her testimony. Ms. Lauren Dollar.
Good afternoon, Madam Chair. Shall I start?
Yes, please.
Thank you. Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Lauren Dollar. I'm an attorney with the Office of the Public Defender. I'm testifying today to urge this committee to issue an unfavorable report on HB 566. I've said it before, the goal of this bill is noble. Doxing hurts people. But pinning down how to draft a criminal anti-doxing law is a huge challenge. Every crime has two pieces, the actus reus and the mens rea. The actus reus is what did you do, and the mens rea is why did you do it. The problem is that this bill, as currently drafted, only requires a person to post a student's name or photo online to be charged, or post a kid's picture without their parents' permission, or distribute a student club contact list with student names and numbers, or any number of very basic acts that people do all the time, and it applies to children and students who are posting as well. When the conduct, the thing that you have to do to break a law is very easy to do, the statute will almost certainly end up criminalizing innocent conduct. Having a legal intent or a right to post it, for example, under the First Amendment, only gets raised after you're charged. And by the way, what is currently criminalized in this law is the intent to harm or recklessness that an act could cause harm. As it's drafted under the plain language right now, harm does not even have to occur. This bill could be easily turned against the very students who we are trying to protect with this bill. And so, as I suggested in my written testimony, Grace's law could be amended to include secondary and post-secondary students, which was mentioned earlier as well. Another option also earlier mentioned was that we could add a civil action or create a civil action, which would allow students to sue groups who post these posts online, which is more likely to be more effective, considering, as discussed earlier, it's very difficult sometimes to figure out who actually posted the post. Because this bill exposes innocent and protected conduct to prosecution, I urge an unfavorable report.
Members, do we have any questions? Sure, Delegate Cardin, the author of Grace's Law and
Thank you,
2.0.
Madam Chair, and thank you both very much for coming and testifying. I guess this is really for Ms. Dollar. If we just expanded Grace's Law, which has those safeguards that there has to be both the mens rea and the actus reus, and it goes through an investigation with the State's Attorney's Office, and there has to be an intent to harm or an act, a stream of acts that demonstrate harm. We just expanded it to age, say, 21 or something like that. Would you still be opposed?
Well, that's my suggestion in the written testimony, is that Grace's Law could be expanded. I think that part of the concern is that the people who are advocating for this bill are interested in graduate students also getting protection. So I think that it might be more loyal to the intent of this bill to expand it to secondary and post-secondary students instead of having an age limit. And I also think that I think it stays more loyal to the intent of the bill than to have it be an age limit.
So
but I do think
a 50-year-old PhD student would be protected, but a 24-year-old plumber would not.
Right. I mean, unless the plumber's still in school. And so I think in terms of how this bill is currently written and the things that people have said as to why it's limited in the ways that it is, it would make more sense to just mirror that. But yes, an alternative could be to expand the age range for Grace's Law. But as you said, Delegate, I read a lot of the testimony that happened during Grace's Law. I think that there was effort put in to make sure that the actus reus was really thought through in terms of, making sure that it wasn't a runaway law. And so that's why that's my suggestion.
Okay, thank you.
Thank you. Members, do we have any other questions? Seeing none, thank you, Ms. Martin. Thank you, Ms. Dollar. That concludes our testimony and bill hearing for House Bill 566. We're going to now move to House Bill 626. Delegate Acevedo. And Delegate Osavero, if you could have a chance to check your email, I sent you an email a little bit ago.
Okay.
Okay, thank you.
Appreciate it. Yes.
So we're going to have Evelyn Walker, Heather Warnken. I see Frank Pinella, and online, do we have Aubrey Edwards-Luce? Okay, great. All right, so Delegate, whenever you're ready, you'll have 3 minutes. All your witnesses will have 2.
All right, thank you, Madam Chair and members of the committee. For the record, Delegate Gabriel Acevera here to present House Bill 626, the Exonerated 5 Act, which is named in recognition of the 5 Black and Latino then young men who were wrongfully convicted after being subjected to coercive and deceptive interrogation practices. Their cases remind us all that when children are questioned in custody, the risk of injustice is real as well as lasting. This legislation reflects a fundamental truth that we all recognize. Children are uniquely different than adults, and our laws should acknowledge that minors require heightened protections due to their developmental stage, their vulnerability to authority, and their limited ability to understand or assess long-term consequences. House Bill 626 establishes a rebuttal presumption that a statement made by a minor during a custodial interrogation is involuntary and inadmissible when a law enforcement officer intentionally uses information known to be false or to elicit that statement from the minor. Importantly, this is not an automatic exclusion. The state may rebut the presumption with clear and convincing evidence that the statement was voluntary and not the result of deception. This balanced approach preserves judicial discretion while ensuring that statements used in court are reliable and fairly obtained. Developmental research helps us understand why adolescents are more susceptible to suggestion, more likely to comply with figures in authority, and more focused on immediate relief from stressful situations rather than long-term consequences. When knowingly false information is introduced to a minor during questioning, the risk of an unreliable confession increases dramatically. False confessions do not merely harm the child involved, they undermine the integrity of our criminal legal system. It diverts resources from identifying the true perpetrator, and it erodes public trust in law enforcement as well as our courts. HB 626 does not prevent law enforcement from investigating serious crimes. It simply ensures that when deception is used against a child, again, I will say a child, that courts apply heightened scrutiny to protect that child from any sort of injustice. House Bill 626 is about protecting minors from practices that research has shown produce unreliable outcomes. It's also about strengthening the legitimacy of our system, as well as finishing the work that we all started with the Child Interrogation Protection Act, but now strengthening that legislation to ensure that no law enforcement officer in our state is able to lie or to use deceptive tactics on children during interrogations or custodial interrogations, so that child's rights are protected, in addition to the parent being informed and the law enforcement officer being able to do their jobs. HB 626, the Exonerated 5 Act, is about ensuring that Maryland is a state that leads, particularly in protecting our kids and ending the frequency and legality with which law enforcement are able to lie to our kids, and then those statements being used in a juvenile or criminal proceedings. It is for those reasons I ask for a favorable report, and I thank you, Madam Chair and members of this committee, for the opportunity to testify in support of this bill.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Frank Patinella, Senior Policy Advocate for the ACLU of Maryland, and we strongly support House Bill 626. I want to give credit to this committee for making some good youth justice reforms in recent years, but even so, Maryland still ranks near the bottom in terms of how we treat our children in our legal system, which disproportionately impacts Black and brown children. This bill is an opportunity to take another step towards reform. During the interrogation of the exonerated 5 teenagers who were Black and Latino between the ages of 14 and 16, prosecutors falsely stated that they had matched their fingerprints and hair samples to the crime scene. They were deprived of food, water, and sleep, and some were interrogated over the course of weeks for nearly 30 hours in total. Then they were told that they could go home if they confessed. This heavily influenced the jurors on the case despite significant conflicting evidence presented by the defense. The outcome was catastrophic for these boys. It cost them their childhood, and it also denied justice for the victim. Not to mention the blow to the integrity of the state's legal system, accompanied with a price tag of $41 million in a payout to the boys who were then men when exonerated. This may be an extreme case, but all interrogations are high stakes and extremely stressful for children. And we know that children are 3 times more likely to falsely confess than adults in these situations. In 2021, Illinois became the first state to mitigate deceptive tactics used by law enforcement. Shortly thereafter, 7 other states, Oregon, California, Utah, Delaware, Colorado, and Indiana followed suit. We're asking this committee to help make us the 9th state. And as adults, we should embody the values that we expect to instill in our children. They are watching us. Let's model integrity and fairness rather than deception and unfairness. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Evelyn Walker, and I am an attorney with the Maryland Office of the Public Defender in the Juvenile Division here in Annapolis. The Maryland Office of the Public Defender respectfully requests that this committee issue a favorable report on House Bill 626. In the state of Maryland currently, police officers are legally allowed to use deceptive interrogation tactics on vulnerable young people. As the law stands, police are not prohibited from lying about evidence in order to get a confession from a child. These tactics can pressure innocent children into falsely confessing to crimes that they did not commit, and this policy is at odds with everything that we know about juvenile development. Not only are children more likely to falsely confess just by the nature of being children, research shows that children and teens are more likely to take responsibility for wrongdoings that they haven't committed when false evidence is presented to them. Youth are more vulnerable to deceptive interrogation practices because their brains and reasoning abilities are still developing. Unlike adults, they are more emotional, more susceptible to social influence, and have a greater difficulty evaluating reward and risk, and importantly, can be placed in high-stress situations which exacerbate these differences. The indisputable and fundamental differences between children and adults justify treating children differently than we do adults. Even with the protections under SIPA, children can and do choose to speak to the police. The use of deceptive interrogation practices must be discouraged to protect the due process rights of children and ensure the integrity of both the criminal and juvenile legal system, and therefore the Maryland Office of the Public Defender respectfully requests that this committee issue a favorable report. Thank you.
Good afternoon, members of the committee. Heather Warnken. I serve as Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. We submitted written testimony in collaboration with our partners at the Center for Families, Children, and the Courts, who you'll hear from in a moment. I want to emphasize just a couple of the key themes about why this bill is so important. We've learned a lot in recent years about what the science has to say about the harms of police lying to kids, and the research is clear that it does more harm than good. You've already heard a lot of these takeaways from the research, so I won't repeat them. I will just transition to the fact that these false confessions that we know are caused by these deceptive tactics carry enormous financial and public safety consequences. For example, the cost of settlements that stem from wrongful convictions, the fiscal and moral costs of unnecessary incarceration of individuals who are innocent, and when these injustices are unearthed due to the vital and under-resourced work of initiatives like our law school's Innocence Project Clinic, public defenders, conviction integrity units, and others, there are costs of reopening cases which seek to identify and prosecute actual perpetrators. But often these injustices are not unearthed, and that should really alarm us. These practices increase the risk that actual perpetrators remain in the community with the ability to commit more harm. They also take an enormous toll on the legitimacy of our criminal justice system. Wrongful convictions, and in particular deceptive practices used on children, impede the ability of police to build trust with their communities. Deceit and betrayal by purported systems of justice reverberate. They often lead to community members not cooperating with law enforcement during investigations, even as victims of crime. Thankfully, better, more effective strategies exist, and we urge a favorable report.
Thank you. Ms. Edwards-Luce?
Good afternoon, Chairperson Bartlett, Vice Chair Davis, and members of the House Judiciary Committee. My name is Aubrey Edwards-Luce. I live in Prince George's County. I am the Executive Director at the Sarah Neil Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. As mentioned by Director Warnken, we did submit joint testimony, and I won't, rehash so much of what we've heard today. I think you've been kind of diluted with all of the neuroscience and brain science that goes to why this is a good policy to support. But I want to share a little bit about what I see from the work that we do. Our center, we operate a program that works with young people who are in Baltimore City schools every year. And we are working very hard to make sure that we're helping them to stay in school, address any issues they have with chronic absenteeism, because we know that it helps keep them out of our legal system. And so we're in proximity so that we can hear about the perception of injustice that our young people have about our legal system. We know that there is a lot of concern that our system doesn't work. And the fact that our system continues to allow our law enforcement to lie to young people is part of the reason we have this perception problem. So we are asking for you to really support and make a favorable report on this bill, because it's a crucial step towards protecting young people's due process and really achieving equity. It's also going to allow us to talk to young people about the way that their legislators see that are concerned about the injustice that they experience, and that lying is wrong, and that we're ready to make sure that we hold police to make sure that statements they make are truly voluntary, if they are in fact using deceptive tactics during interrogations. Thank you.
Thank you. So I have a question for Ms. Walker. I am looking at the Maryland State's Attorney Association testimony, and what they are saying is that children are not talking to investigators anyway, therefore, why do we need this bill? Can you please address that?
Yes.
Can you also bring a microphone to you?
Thank you so much. So, of course, with SIPA and having children consult with an attorney, to be very clear, because I'm on SIPA, I'm on the hotline that OPD has a lot, children have a choice. We advise them of their rights, and they have a choice whether or not they would like to invoke their right to remain silent. There are children that have chosen not to invoke their right to remain silent, even after consultation with an attorney. We've also had children that decide to sit with an attorney and be presented evidence by the police so that they can make a decision about whether or not they're going to speak. So it is not to say that just because children are able to be advised by attorneys that they don't make statements to the police. There are also exigent circumstance exceptions that come with SIPA as well. And theoretically, if they're asking questions, even with an exigent circumstance, they could lie with the way that the law currently stands. So just because somebody is advised of their rights by an attorney does not mean they're not speaking.
Thank you. Let me just ask you one other piece, and that is, I'm looking at the chiefs and sheriff's testimony, and they state that it would be an obstruction of justice if they lied to children. Either Delegate Acevera or Ms. Walker, would you like to respond to that? Or anyone, actually, whoever is so moved to respond to that question.
I mean, just the idea that it would obstruct justice to say you are not allowed to lie to a child. It is baffling. We have children as young as 12 that are being interrogated by police in this state without a parent or guardian present, sometimes even after an advisement without a lawyer present because a child may choose to not go forward with a lawyer. Police have other investigation tactics that they can utilize outside of just speaking to and lying to a child.
And Mr. Patinella, sorry, I'm sorry I butchered your name. What does the Supreme Court say about lying to a suspect?
There is precedence, but I'm going to defer to Heather.
No, let me tell you what.
Yes.
Oh, okay, to Ms. Walker or Ms. Warnken.
Either.
Because what I'm getting at is, aren't we just opposing? Doesn't the Supreme Court say that you can lie to a suspect? So for them to say that this is an obstruction of justice, does that line up? That's where I'm going.
No, I don't think that lines up. And again, the arguments that you've heard today are about what we understand about the reality of these situations. And it's not only not good for the child, it's not good for public safety and for these investigations. We have a proliferating body of research that are connecting the dots directly to these deceptive tactics, false confessions, and then wrongful convictions, which come at this huge cost. So I think legally it is not a problem. And then practically, it's a big problem that we need to correct.
Thank you. Members, do we have any further questions? Delegate Cardin.
Thank you, Madam Chair. Thank you very much, Delegate Acevedo, for bringing the bill and for your compelling testimony of your entire panel. I think this is a question for Ms. Workin or for, are you a student or are you one of the professors with Ms. Workin who's on, but perhaps this is for you. If you use false statements or lying to gain information that then provides corroboration. Example would be you say to the kid, I know you had a gun, or I know you had a knife. I know you had a knife. And we know we have the knife. I didn't have a knife. I had a hammer, right? I used the hammer to break the glass. And the hammer is so-and-so and so-and-so, and they go and they find the hammer. Now they have the hammer. Is that a fruit of the poisonous tree? Can they not use the hammer? Or because they have the corroborating evidence, now it doesn't matter whether they lied to them to get that information? I don't know.
I mean, I would argue that it's fruit of a poisonous tree, but the state's attorney may argue against that. And so while there are motions to suppress that defense attorneys can file when we think that something untoward has happened when it comes to an interrogation or an investigation, that's something that we have to litigate, and it's something that we have to put in front of the court. And so we want to kind of stop that at the forefront to say, let's, again, not lie to children so that we don't get into this type of situation. So let's extend the protections that SIPA have already started to provide children in this state.
Okay. And I also just want to reiterate that we have effective ways to pursue an investigation, to find the hammer. I mean, part of what we talk about in our testimony is that respectful, rapport-based interviewing also leads to information and more truthful information. And I just think there are other ways to get where we're trying to go besides lying to kids, especially given the cost.
Thank you.
Thank you. Members, any other questions? Seeing none, that concludes this panel. We're going to move on to our unfavorable panel, and I should have online Chaz Ball and Lauren Lipscomb should be in person. Do we have Mr. Ball? Okay. Hi, Ms. Lipscomb. Whenever you're ready, you will have 2 minutes.
Yes, thank you. Good evening, Madam Chair, and members of the committee. My name is Lauren Lipscomb, and I'm the Chief of the Conviction Integrity Unit in the Baltimore City State's Attorney's Office. I am also the Chair of the Post-Trial Subcommittee of the Maryland State's Attorneys Association. I am here testifying today on behalf of the Maryland State's Attorneys Association in urging an unfavorable report on House Bill 626. I've been a criminal prosecutor for over 20 years. In my professional capacity, I've overseen the conviction integrity, factual innocence reviews of hundreds of cases, directed the investigations into dozens of factual innocence claims, and factually exonerated 14 men convicted of murders not committed. For years, I have served as a trainer and presenter on conviction integrity matters to prosecutors across the country. No prosecutor wants to convict an innocent person, and we support effective safeguards to prevent same. There is no one cause of historical wrongful convictions. Rather, there are contributing factors, many of which become obsolete over time with improved investigatory and trial safeguards. The CP5 exoneration is similar to any exoneration in that there were myriad, not just one, contributing factors which caused the catastrophic outcome, and we would agree that that was a catastrophic outcome. Not the least of which was that the incident and trials occurred within the criminal justice system as it was in 1989 and in New York City. A case subject to the laws, police and prosecution policies, public policy, and the political landscape of 1989 in New York should not serve as the basis to create 2026 Maryland law. The Child Interrogation Act, most impactfully, obligates consultation with an attorney prior to a custodial interrogation. As well, these interrogations are video and audio recorded. HB 626 provides no benefit while needlessly inhibiting police ability to investigate crimes which puts the public at risk. Thank you for permitting my testimony.
Thank you. Mr. Ball?
Hi, good afternoon. Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Chaz Ball, and I'm here representing the State Fraternal Order of Police. Obviously, the State Fraternal Order of Police represents an advocacy group for the bargaining of police officers. It represents a group for the due process of law enforcement officers and their employment rights. But at the end of the day, we're representative of law enforcement all over the state. And what the Maryland State Police and the Fraternal Order of Police care about is being able to effectively provide safety for the cities, the counties, and the entirety of the state. The ability to use subterfuge, as it's defined by the Supreme Court, is just one of the many tools in the bags of law enforcement officers in order to resolve cases, in order to successfully solve information, in order to keep the members of this state safe. Realistically, in every single case, the only way for a statement to be admissible, to be utilized by whether it be a minor or an adult, is if that statement is voluntary. It can be challenged by way of a motion to suppress, and it can also, in the terms of the trial itself, every single juror in a case in which there is a statement given by a defendant or is told, the state must prove beyond a reasonable doubt that the statement was voluntarily made. That's part of the Maryland pattern jury instructions that every juror is told, that the statement itself must be voluntary. This, the ability to use subterfuge, the ability to say, a Ring camera caught you picking something up off of someone's porch. The ability to use that type of subterfuge when that might lead a minor or to give additional information is part of the many, many tools. But at the end of the day, the statement must be voluntary. And just because subterfuge is used does not make the statement non-voluntary. Thank you.
Thank you. Members, do we have any questions? Delegate Cardin?
Thank you very much, both of you, for coming to testify. Ms. Lipscomb, welcome from the 11th District, by the way.
Yes.
You obviously deal in exonerations. You run that department for Baltimore City. How many exonerations have we had in Maryland, and how many exonerations were based on using subterfuge, as the FOP suggests?
Thank you for your question. The National Registry of Exonerations is actually the kind of the national body that does collect that kind of data. Our office doesn't specifically, but that National Registry of Exonerations is kind of universally recognized as being the data keeper of exonerations across the country. And within that data, and we actually, as prosecutors, don't always agree with the definition that they've used necessarily as what an exoneration would necessarily mean, because our definition just varies a little bit differently than what they consider to be an exoneration. But according to them, 58 in the state of Maryland. Now, according to them also, there are only 2 in the state of Maryland that had as a contributing factor coerced or forced confessions. 2 in the state of Maryland. One of them was from 1991 in Calvert County, and the second one was from 1989 in Anne Arundel County. In the Calvert County case, apparently that individual was exonerated in 1999. In the Anne Arundel County case, apparently that individual was exonerated in 1994. So even under the exoneration definition that is utilized by that group, which is, again, a lot more generous in terms of what they would define as being an exoneration, even with that definition, that entity has determined that Maryland has had 2 cases that resulted in exonerations in which there was a contributing factor, which would be a coerced or forced confession, because of course, obviously, any exoneration is not just one factor, there is a totality of.
So so my understanding then is that even if you're using subterfuge, the State Attorneys Association is basically saying that we get it right, or we choose not to prosecute, or the case winds up with an outcome that is appropriate for the person who may have been lied to. Is that fair to say?
That's what it would seem. Yes. As to the data that we've got, I also would say, in my experience, none of my exonerations have involved a coerced confession either. Again, it's a contributing factor, but I would say that even on a national landscape, when I talk to prosecutors in other jurisdictions, in other states, in other jurisdictions, that is something that is a lot more prominent of a contributing factor than anyone here in the state of Maryland would say it is here in the state of Maryland, and certainly not in Baltimore City.
Thank you.
Thank you. The Vice Chair.
Thank you. I want to go back to the statistics that you just talked about.
Sure.
The question was, did your statistics point to cases where subterfuge was being used? And you gave us results of coerced statements. Would you agree that they're different things?
Oh, they're slightly different, but they're certainly related.
Is there a way to detect or keep a record of whether subterfuge was used?
I'm sure that there probably is, but I think that even when we're talking about the panel that just spoke in support of the bill, that panel was certainly drilling down very heavily on the Central Park 5 case and the juxtapositioning of the Central Park 5 case as it pertains here to Maryland law, and that this bill somehow was going to prevent wrongful convictions. And so my responsiveness is really to that connection in particular.
Okay, and one last question, please. I'm glad you support all the protections that we're giving children with the child interrogation bill, but isn't that only limited to custodial interrogations?
Custodial interrogations of suspects.
Yes. Okay. Thank you.
Yep.
Thank you. Members,
thank you so much.
Have any other questions? I see none. Thank you. And that concludes our bill hearing for House Bill 165. Sorry, that's not the bill number. That was last year's bill number. My apologies. 626. All right, we're going to move on to Delegate Embry. Delegate Embry's bill is House Bill 722. And
Thank you, Madam Chair. And we have a number of witnesses here I think can all fit. And would you mind if we had Professor Kathy Hope, who is online as part of the first panel?
sure, could we have Professor Kathy Hope? Thank you. So I have Robert Jenner, Emily Malarkey, Teresa Lancaster, David Chappelli. We're going to start with this panel.
If you don't mind, thank you.
Okay.
And, oh, there's Professor Hope. Thank you.
Whenever you're ready.
Thank you, Madam Chair, Madam Vice Chair, and my colleagues. So I'm bringing you another relic of Maryland law, much like contributory negligence the other day. This is the charitable immunity doctrine. So we passed, as you all know, the Child Victims Act in 2023, which was decades of hard work by many of the people at this table. An incredible, incredible success. What we did not focus on, I certainly didn't, and I suspect many, if not all of you, didn't realize, is that the charitable immunity doctrine, which still exists in Maryland, one of a small minority of states, gives protection for all torts, including child sex abuse claims, to charities. This is a common law doctrine from the 1800s. Again, most states have either abandoned, well, most states have abandoned it, and then those that still have it have limited it substantially. And it is derived from a time when charities were much smaller, less complex, and very different from how they are today. We are not proposing abandoning the doctrine. It's an affirmative defense. We are proposing only that we would eliminate it as a defense when the allegations are child sexual abuse. I would argue that for the Child Victims Act to be meaningful, we do need to pass this bill. We have people here who are experts on the law. We have people here who have been involved in this fight for so many years, countless years, and so I will defer to them to speak about the impact. But I just want to address some of the concerns raised by the opposition. One assertion is that this is unconstitutional to apply retroactively. That is not the case, and we have an opinion letter which I can share from the Attorney General's office. An affirmative defense is not recognized as a constitutional right under Maryland law. Additionally, there is the concern that it will be harmful to nonprofits. Yes, I mean, that is the policy consideration. It's what we consider with the Child Victims Act. It is a matter of weighing the importance of victims of child sexual abuse to have their day in court, to seek redress, and to have accountability. And yes, that does mean that does expose organizations that have allowed that to occur to be held liable potentially. So I just want to address those two concerns. And with that, I will turn it over to my panel, and I thank you all for listening.
Might we start with Professor Hope?
Yes, would that be all right?
You want to start with Professor Holt? Hoke, okay, are you ready? I can tell you're nodding, so whenever you're ready to begin, you'll have 2 minutes.
Good afternoon, Madam Chair, members of the committee. Can you hear me? Yeah,
yes,
awesome.
We can hear you.
Thank you. Always just want to make sure when I'm testifying virtually. Sorry, I can't be there today due to a conflict. I'm Kathy Hoke. I'm a professor at the University of Maryland Carey School of Law, here today in support of House Bill 722, as Delegate Embry indicated, would narrowly eliminate the doctrine of charitable immunity with respect to claims of child sexual abuse. This would really allow this body to fully realize the intent behind the Child Victims Act, which was to open the courtroom doors to generations who suffered from child sexual abuse as children. And unfortunately, the doctrine has closed the courtroom doors to many. And you're going to hear about the public policy reasons behind it from others. I wanted to talk about the constitutional issues on the retroactivity, which I did for years for you on the Child Victims Act and was validated by the Supreme Court of Maryland. So if that gives me any credibility, I'll take it. But first, the doctrine is court created. And that means that this body has the power to eliminate it, to take parts of it away. And so no question about your authority to do this. And the Maryland Supreme Court has made that clear for a long time. The retroactive impact I see falling into 3 buckets. First, cases that are that have not yet been filed. And I think we can clearly say, based on Maryland Supreme Court doctrine or cases, specifically the elimination of an affirmative defense does not hinder, eliminate, or modify a substantive right, and thus a statute or rule that eliminates an affirmative defense can be applied retroactively. State versus Smith from 2015. Clearly, for cases that have not been filed, the retroactive impact is not a problem. For cases that have already gone to final judgment, I do think there might be vested rights here, conclusive rights that cannot be violated. But the real issue is cases that are pending. And the best analysis that I have, just like with the Child Victims Act cases, that is not a vested right, that is warrants constitutional protection, and that this body does have the ability to revoke it without interfering with constitutional rights. And there I just do want to cite both the Archbishop versus Washington versus Doe and the Smith case that I cited earlier that actually is about a case that was filed after an affirmative or was pending when affirmative defense was removed. And the court said, no, that's okay. That affirmative defense can be removed retroactively. Happy to answer questions after the panel or at any time.
Thank you. Whoever would like to be next?
Good afternoon, Madam Chair and members of the committee. My name is Teresa Lancaster. I'm an attorney, a survivor, an activist, and an advocate. I support House Bill 722 to hold charitable organizations accountable for the sexual abuse of minors. The charitable immunity doctrine shields charity from liability. But in Maryland, it has become a safe haven for organizations that fail to take sexual misconduct seriously. The church in particular has repeatedly enabled predators and now seeks to hide behind this outdated law. Most states have limited or abolished this doctrine, but Maryland is still one of the only 9 states that have it. I urge you not to dismantle the Child Victims Act, which gives survivors the chance to seek justice. Too many of us, including myself, have endured unimaginable abuse and still cannot find justice. We fought tirelessly to get here, but too many survivors have been lost along the way, many unable to confront the trauma that they endured. Please don't undo the progress we fought so hard for. When I was 16, I was sexually abused by Father Maskell at Archbishop Keough High School. I endured horrors in his office, his rectory, and in his car that no child should ever face. The church enabled Maskell knowing he was a predator before sending him to Keough. This fact was confirmed in the Netflix documentary, The Keepers, and in the Attorney General's report released in the spring of 2023. The church has had a long history of protecting predators and avoiding accountability. The Maryland General Assembly effectively abolished the charitable immunity by passing the Child Victims Act. But many are still waiting for justice. I respectfully ask for favorable vote for House Bill 722 to ensure accountability and justice for survivors. Thank you.
Good afternoon, Madam Chair, members of the Judiciary Committee. My name is David Chappelle. It's an honor and privilege to speak with you today. I thank you for your time and for your attention. I'm here today in strong support and ask for your favorable review of House Bill 0722. I want to begin by recognizing this body for your role in passing the Child Victims Act. As a survivor of child sex abuse, I know that that legislation was courageous and historic. It acknowledged that survivors of child sexual abuse need time to understand what happened to them, time to process the trauma, and time to come forward. It opened courthouse doors that had been closed for far too long. But opening the door is not enough if survivors can still be turned away once they get stepped inside. I brought a case against the Archdiocese of Washington, D.C. My abuser was a known pedophile who abused others in Montgomery County and in other states. He was convicted, incarcerated, and he died in prison. My case against the Archdiocese was dismissed after it claimed it was immune under something called the doctrine of a charitable immunity. It was not dismissed because it lacked merit. It was not dismissed because the harm wasn't real. What happened to me was real. The institution prevailed by asserting a legal technicality. Survivors already face fear, shame, and enormous power imbalances. The law should not add another barrier. Charitable immunity was created to protect good works, but there is no charity in sexually abusing children. There should be no immunity for institutions that enable it, conceal it, or fail to prevent it. This bill strengthens the Child Victims Act. It makes clear that its promise cannot be undermined by an outdated legal doctrine. Please pass this bill so that no survivor is told that while what happened to them was wrong, the institution responsible is immune. There should be no immunity for child sexual abuse. Thank you.
Thank you, Madam Chair, members of the committee. My name is Robert Jenner. I'm an attorney. I have a small practice in Baltimore City, and I represent survivors of childhood sexual abuse throughout the state.
Can you move that microphone over just a little bit?
Certainly.
Perfect, thank you.
I'm Mr. Chappelle's attorney and was part of the team that argued the charitable immunity doctrine in Montgomery County and had the ruling that tossed Mr. Chappelle's action against the Archdiocese of Washington out. I was honored to stand with many of my clients and when we argued for the Child Victims Act. I'm not going to pretend to recount the horrors that they went through. They are here. There are people in the audience here. They can do that much better than I can. But what I can tell you is that all of my clients received one thing when you passed the Child Victims Act. They received hope. And this is hope that they've never had before. And you gave them a voice. And you gave them a voice that they never had before. But as we watch TV these days and we see what's going on in this country and we see what's going on internationally, we recognize now that a voice is not enough. You need something beyond a voice. You need power. And if you don't have power, then all the voices in the world won't change anything. The power that we have that you gave them with the Child Victims Act, that the Maryland Supreme Court gave them by holding the constitutionality of the Child Victims Act, was the power to seek redress, to get compensation, to make a difference, to tell the defendants, you cannot do this to any other child. It is the Maryland public policy to protect children against sexual abuse. And when you take away the remedies that you gave them with the Child Victims Act, you take away not just a voice, but you take away their power. For these reasons, Your Honor, I urge a favorable report from this committee on House Bill 722 as it applies to survivors of childhood sexual abuse to remove the charitable immunity affirmative defense. Thank you.
Yes, Mr. Jenner has just given you a promotion to your honor, Madam Chairwoman. But good afternoon, evening by now. My name is Emily Malarkey. I am the legislative chair for the Maryland Association for Justice. I happen to also work with Mr. Jenner, not for Mr. Jenner, with Mr. Jenner, also representing many victims of childhood sexual abuse following this body's brave work in 2023. And I'm also facing motions in my cases to dismiss for charitable immunity purposes. I want to say a lot of me too of what those who have gone before me have said, but I will repeat one thing verbatim, and that is this body opened the courthouse doors and provided hope, and what we're seeing in our court system since that time is the door is getting slammed shut in their face and hope is getting lost. As you heard yesterday with respect to an argument about punitive damages, Maryland continues to remain in the minority when it comes to many laws relating to accountability for unreasonably unsafe, grossly negligent, and purposefully harmful conduct. Yet another example of our continued adherence is our continued adherence to the doctrine of charitable immunity, which is a court-created law that you absolutely have the power to eliminate. The Maryland Association for Justice strongly opposes any limits on the rights of injured Marylanders to seek redress in the courts, including immunities of every kind. No institution should be able to hide behind a charitable status to avoid responsibility for grave, pervasive, and knowledgeable wrongdoing, and no charity exists to permit, enable, or cover up child sexual abuse. But that is precisely what is happening in our courts. On behalf of the Maryland Association for Justice and all of our survivor clients, we urge this committee to report favorably on HB 722 providing a narrow exception to the doctrine of charitable immunity for survivors of childhood sexual abuse.
Thank you. Members, do we have any questions? Delegate McComas, thank you.
I'm going to make this real short. The church filed bankruptcy, and what's going on with that, and how would it affect or not affect what we do with this charitable immunity bill?
That's a great question. So the Archdiocese of Baltimore filed for charitable immunity. The Archdiocese of Washington, D.C., which includes Prince George's, Montgomery, and other counties where Mr. Chappelle's case was pending, did not file for bankruptcy. So the Archdiocese of Washington cases are making their way through the court systems and are subject to legal motions, including this one. Many cases are in PG County, many are in Montgomery. The Archdiocese of Baltimore filed for bankruptcy. What's happening with that is it takes a really long time. It's still going on, and it probably will be for a very long time. The Catholic Church in the Archdiocese of Baltimore bankruptcy, however, did assert a defense of charitable immunity. And the survivors who have claims pending in that bankruptcy had to fight it for a very long time. We had to start, and I represent many people in that bankruptcy. The committee that represents the survivors in that, which is a bankruptcy attorneys, had to file an adversary proceeding, which is like an adjunct to a bankruptcy, and I'm not a bankruptcy lawyer, to litigate whether the Archdiocese could try to minimize its responsibility by claiming this doctrine. Ultimately, a settlement agreement was reached, and the Archdiocese of Baltimore relented, so it's not an issue in the bankruptcy, but if the Archdiocese of Baltimore bankruptcy is not successfully resolved in bankruptcy court and the bankruptcy is dismissed for any number of legal reasons, every single one of the many hundreds of litigants in that bankruptcy proceeding will then be entitled to go to court and file their lawsuit, and this will come up.
Well, just a follow-up question, if you can answer. I mean, how much is on the table potentially that the church would lose?
In the
with the number of victims versus the number of cases in the.
There are multiple hundreds of claims that have been filed in the Archdiocese of Baltimore bankruptcy proceeding. Many of them are being subject right now as we speak to challenges by the Archdiocese of Baltimore. They're saying for a variety of different reasons this claim isn't valid, and so the ultimate number we don't know yet. But if all of those cases get filed in court, they would all be subject to the same $1.5 million per incident cap that this body enacted in 2023. And the Archdiocese of Baltimore is a wealthy institution. And I say that as a lifelong Catholic and product of 12 years of Catholic school. They have the money to pay.
So when you say per incident, so let's say, because some of these priests are dead, okay, so they can't testify, but I assume that the claimant can still claim against what was done to them. So how are, and I would assume that a lot of the victims wouldn't really remember, or, you know what I'm saying, keep tab of how many incidents, as opposed to just, that they were abused. So how's that going to work?
It's an open question.
Yeah, I agree with Mr. Jenner. You want to talk?
It's an open question. It's unclear. The question is, is each incident an event that brings forward another cap, or is it all encompassed under the cap that is general for the entire recovery? We don't know the answer to that yet. It hasn't been ruled upon. Hasn't even been. There's no motion before any court to resolve that. That said, these survivors, some of them remember the number of incidents with great specificity, and others, you're correct, are just like, I know it happened during this year.
This body did, I would just add, address some of the multiple cap issue last year in the amendments that were pushed through at the end of last year's legislative session.
And I have just one other question. The fact that the incidents happened during the charitable immunity, and now you're coming in just to overturn the charitable immunity, when the charitable immunity, when these incidents occurred, was in statute, okay, is that going to create another complication? Because, you know, basically these are continuing litigation, and so you're trying to take something out of it that, in other words, it harms one of the parties to the case, it helps the other parties to the case. I'm just saying, as far as you're changing the law, it's kind of like moving the goalposts in a negotiation. I'm just asking if that's legal.
So that's why we led off, I mean, and why I wanted Professor Hope to address you, because to give this committee some comfort that that is not unconstitutional. It's not a vested right. It's an affirmative defense that isn't triggered until a lawsuit is filed. So,
okay.
But whether it will be litigated, of course, I don't know, and it may be. But that is why I wanted to make sure you had the testimony, and also, again, we have an AG opinion letter.
Well, it's just really complicated.
And just, you said in statute, but it's not in statute, the charitable immunity doctrine. It's a common law.
Common law.
Court made.
So that's going to makes a big difference. Then,
and the courts have said, and I'm sorry, these lawyers may know the case name, but the courts have specified that this can be changed by statute, that it should be in the hands of the General Assembly to change.
Thank you all. Thank you.
The Vice Chair.
Thank you, Madam Chair. Could someone please address the relationship between the charitable immunity defense and liability insurance? That's a good one, huh?
Yeah, I can start, and you can correct me if I'm wrong. So Maryland has adjusted the charitable immunity doctrine, and one of the things that is, if there is insurance, then the liability attaches to whatever the insurance covers. So the charitable immunity doctrine kicks in when there's no insurance.
And so the charity could purchase insurance?
Absolutely, and many do, yes.
I can give you some examples of how this is coming up. So we have cases, say, from the 1970s, and I might represent one gentleman who was abused in 1976, and another in 77, and another in 78. And we're seeing people come forward and say, I was able to find my insurance policy for 1975, and I was able to find it from 1977, but I can't find a policy for 1976. So we didn't have insurance, and so we're immune. And I've got 3 clients in the same situation, 2 of whom have insurance coverage to cover their claim, and 1 of whom doesn't. Or there's something called a wasting insurance policy, which is an insurance policy where for every amount of money that's paid off of whatever the coverage is, it goes down to 0. So if my client is the last in line and the $1 million or whatever was the coverage has already been paid out to other people, they're out of luck. Charitable immunity. Those are just a couple of examples of how it's coming up.
So under this doctrine, there's no incentive to purchase insurance?
That's correct.
Okay, thank you.
That's an excellent point,
Yeah.
Thank you.
Thank you.
Delegate Phillips.
Okay. Can anyone tell me what is the purpose? Why did we go with this concept of charitable immunity?
I think, you mean back in the day? Because it has been since the day, okay?
Back in the day.
I think the purpose behind the doctrine was that we want charities to be able to do good work, and we don't want money that people donate to charities being used to settle lawsuits, okay? But that was back in the day, and that's just not the way the world operates anymore.
So you say that was back in the day, and that's going to take me to my point. So when you have institutions, and I got to be a little more specific because I'm seeing this happen in really small institutions who are now somewhat caught up in this, where no one intended for the reserves of, let's say, a small church that's been in existence for 150 years, who now has one of these cases that came up from 1960, right? There's no insurance and no way for them to defend themselves outside of charitable immunity. Has there been any thought for scenarios like that? They're not the Catholic Church. They're not a conference. What is your thought on that?
My personal thought on that is that the reason why this bill was written the way it's written is not to get rid of the doctrine entirely. It's not to say there's no charitable immunity for anything. we're trying to say there shouldn't be any immunity for child sexual abuse, okay, that particular thing. So the charity would still have its immunity for everything else under the sun, but for abusing children, which we worked really hard to get here, that is an exception.
And I'm trying to balance that. If the intention of charitable immunity was to do what you said, right, was to ensure that an entity, that those persons who put their tithes in every Sunday with an understanding that it would be used for that purpose of charitable purpose. But there's now this claim, and they've got 100 years of history with, you know, grandmothers who've been putting their money in, and that thing goes away. And there are, I understand, many, many, many small organizations like that caught up in this. I just get concerned about how do you handle that? Because I can't have, you know, 50 churches on 50 corners in Baltimore City and Baltimore County closed. I think that would be a travesty. And so I've got to balance those two.
I think your point is very well taken. It is a legitimate concern. However, remember, the person who's bringing the claim still has to prove it. So they still have to prove that the institution is responsible. And in order to do that, they have to show that the institution knew or should have known that a particular person was a bad guy or woman and failed to act to protect, and that led to a child being abused. They still have to prove that, or no money will be paid.
I understand.
And they're paying their defense lawyers.
And that's the challenge. There you go. If I look at the average church in Baltimore City I'm just thinking about my jurisdiction, just the legal fees alone could shut them down. So I'm just thinking about how we manage through something like this.
Yeah, I think it's a difficult question. And I think it has to come down to, if someone can prove that an institution acted in a way that allowed a child to be sexually abused, are we going to protect the institution, or are we going to make it right for the child?
I think that's why we have charitable immunity, because the concept is we don't want to shut down those institutions who have had a significant impact on their communities. That's why we have the concept, right? And so I think we're protecting those institutions. Now, I understand may be different from the Catholic Church or many other institutions. I'm just thinking about those. And I'm finding out that that's a significant part of the thing. What about this? It's my understanding that the AG is now making another claim to protect the state of Maryland that says everything before we accepted our tort reform for sovereign immunity would not be a claim that you could bring. I think that's one of the arguments that the state is making. Is that correct?
I'm not familiar enough with that, but.
So I do believe that that's part of their argument. And so everything before like 1982, they're going to argue, right? That was before we had our sovereign immunity.
There's many legal issues that have arisen in the courts with respect to these cases. I mean, this body got rid of the statute of limitations, which is a statutory time period. There's an equitable doctrine called the doctrine of latches. And we're seeing that even though this body said you can now come forward and bring your claim 40 years later, we're getting motions to dismiss because the doctrine of latches. So it's, I mean, yes, there's all kinds of creative things happening.
Okay. And the idea, so if I had this little church, 100 years old, but they had insurance, then the plaintiff would have an opportunity. But if I have that same entity and they have no idea what that insurance is, they would be fully open to complete liability.
If this bill is passed for child sexual abuse only.
Okay. All right. Thank you.
Thank you. Delegate Taylor.
Thank you, Madam Chair, and thank you, Delegate Embry, for this bill. I was reading over some of the testimony, and I know in one, it said, and you may have mentioned this, and I had to walk out for a sec, but you may have mentioned that Maryland is one of the few states that haven't abandoned this idea altogether. Who are the other states, do you know, who still
I was
have
looking at
it?
it earlier. I don't know if anyone has the list.
Well, I mean,
I'm
a
sorry,
few,
but-
meaning is it 2 or 3 or
9,
just
we're one of 9.
about 9?
And again, yeah, I'm sorry.
No worries. I mean, that's not as important as, you
And
know,
again,
kind of.
those 9 have limited in various ways, but they do have, but those are the 9.
That was going to be my question. So have they abandoned it altogether or they've just limited?
So 41, I believe, have abandoned it altogether.
Have abandoned
and
it altogether.
9, like Maryland, including Maryland, have kept some vestige of it.
Why wouldn't we abandon it altogether?
Well, as Delegate Phillips, I think, expressed beautifully the reasons that, well, all I'll say is all this bill is focused on is this narrow piece of what we think are, you know, just about the worst thing that an organization could be responsible for, knowingly allowing a child to be sexually.
I'm not sure in the other states because I don't know who they are and I don't know what the situations are, but if they have abandoned it altogether, I'm sure they figured out a way potentially for the small churches, for other, you know, charitable organizations to continue to exist, even though you no longer have charitable immunity. And there's no question in that except, isn't it so, potentially?
If I could add, and I'm sorry, this is semi-responsive, but I just wanted to make sure it was acknowledged, and the fiscal note references that we do have statutory protections for we do have statutory protections for volunteers of charities and also for directors and officers. So I just want to add, we have looked out for people who are giving their time. We don't want to hold them responsible for acts of the organization. So this is limited to the entities themselves that would be, have to be found to have known and allowed this to happen.
Thank you.
Delegate Mangione?
Thank you, Madam Chair, and thank you all for being here. And I'm probably making a mistake even trying to challenge all you attorneys because you probably know a lot more than this than I ever could. But I do find it interesting that, you know, a statute of limitations is really just starting the clock, so to speak, on a timeline of when something may have occurred. As horrible as it is something that occurred, and now you're just saying, let's get rid of the timeline. But by retroactively doing this, instead of starting now going forward, you're basically saying, and you attorneys are going to make a lot of money off this, it's a fact, let's go back and change the rules of the law that they were applying at the time, not the timeline, which the statute of limitations would do. I agree wholeheartedly with this bill going forward. It just, for me, I have to be convinced as to why we're going to just change what was legal at the time or a legal defense, unless I'm totally misunderstanding. I just want to hear what you, if I'm way off because I'm not an attorney, but explain this to me.
I think that Professor Hoke probably could answer your question better than us.
Okay, thank you.
Thank you, Delegate Mangione. And what I would say is that the question is whether it's constitutional for you to do that in the first instance. And I think the answer is yes. If you review the AG letter in the file, that for pending cases, and for cases that haven't been filed, you can retroactively eliminate an affirmative defense, because that's not a vested right that gets constitutional protection. And again, in my testimony and in the AG letter, they cite the cases that support that. And that's just very similar to the statute of limitations, which functions like an affirmative defense. You can be sued outside the statute of limitations and choose not to raise that as a defense. It is an affirmative defense that you get to raise. No different here. A charity may choose to raise the doctrine of charitable immunity as an affirmative defense or not. And in fact, you heard that in the bankruptcy proceeding, the Catholic Church has agreed not to, or the Archdiocese of Baltimore, I should be clear, has decided not to. And so it actually is very similar legally, the statute of limitations and the affirmative defense of charitable immunity.
And thank you, Professor. And I think that does make sense, and I agree. My concern would be if we applied this same standard every day in this 90-day session to previous laws, and then had people try to change the law, which we understand, that's why we're here, but to then apply that retroactively across the board, it would almost defeat the purpose of why we're here, or it would cause total chaos in terms of a civilized way of governing is, I guess, my concern. And it doesn't necessarily mean I'm against this bill, because the actions that occurred are heinous, obviously, But I do agree with Delegate Phillips, and I have to disagree with the Catholic Church, for example, and maybe I'm wrong, I don't know their numbers in terms of the Archdiocese, but my understanding is they've been consolidating churches and schools because of the cost of so much, so I'm not sure that they have an abundance of money, and I'd hate to see a lot of these churches and nonprofits really suffer for things that happened a long time ago. They may not be necessarily the same people involved, but with that said, people need to pay for the actions that happen. So I appreciate the expert testimony, and I'm just really learning, as I keep saying in this committee, a lot about the legal ways these things happen, so thank you.
I think the Catholic Church has made it clear that what's happening in Baltimore with the consolidation of churches and everything is not related at all to the declaration of bankruptcy.
No, I agree with that, but I'm saying when you see some of these local archdioceses shutting down in some of the small Catholic churches, I think that a lot of that is financial, not the Catholic Church in general, obviously the Vatican and whatnot, but in terms of the archdiocese, and I don't know their books, but I'd have to assume that a lot of those I know the St. Leo's Church in Little Italy is a historic church, was on the chopping block, and I can't imagine that was because they were flush with money. But either way, fascinating conversation.
I'll send you some articles.
So I just wanted to, since we're having this discussion, I wanted to see, and I couldn't find the testimony, and I think perhaps, I don't know if Professor Hoke is the person to answer this question. I think so. So how much, without going into all of the history as to why an affirmative defense can be one, you've explained to us an affirmative offense is not vested until there is a claim. But with that concept, it almost seems to me that what I'm also hearing is that there is an equitable doctrine with respect to the doctrine of unclean hands, meaning that you have committed X and now you want to get the benefit of the charitable immunity. Does any of that play into any of this, or am I just going too far into jurisprudence?
No, I think, Madam Chair, you're right. I think if we can frame it as the policy decision that this body has before it on that question, right? And so if I've convinced you that constitutionally you can do this, and you say, well, where does the equity lie? I think that's been a lot of the question here. And that does go back to the concept of charitable immunity in the first place, created in the 1800s when there were tiny, charities that didn't have, fulsome bank accounts. And they were actually providing, by and large, public services like housing supports, food supports, and healthcare supports to people in our community because we didn't have public benefits. And so the purpose was to protect, charitable dollars that people gave to help people have a home, to have food. And now we're really in, obviously 2026 in a totally different place. And so those charities that want to assert charitable immunity for having for decades willfully ignored and allowed to continue sexual violence against children don't come in with clean hands. And so if it's constitutional to apply this retroactively, those are the organizations that don't deserve the benefit of the doubt on charitable immunity. And only those organizations would be subject to liability here, those who permitted the continuation of child sexual violence.
Thank you. Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. I was wondering, were sexual abuse claims part of the original concept of charitable immunity? Does anybody know?
They are not related to one another.
They're not related to one another.
Correct.
Thank you very much.
Members, do we have any other questions? All right, seeing none, that concludes this particular panel. And we're going to move on to, did Teresa Lancaster? Yes. Okay, that's what I thought. Thank you, Ms. Lancaster.
Thank you.
Francis Schindler, are you here? Francis? Yes. Okay. Let's go ahead and bring in Jessica Shinbo. So this is our second, and also David Lawrence, if he's available online. Okay, So this will be our second favorable panel. Mr. Schindler, we'll start with you, and then we'll hear from Ms. Schindler.
Thank you, Madam Chairman.
We're going to start with our in-person. And Ms. Schindler, you'll need to turn off your YouTube. Thank you so much.
Thank you, Madam Chairman and members of the committee. My name is Francis Schindler, and I am a survivor of child sexual abuse at the hands of a Roman Catholic priest. Abuse that took place over 20 times when I was 5 years old in an office adjacent to my kindergarten class. I testified before this committee and the Senate Judicial Proceedings Committee numerous times in support of the passage of the Child Victims Act. I'm here today to strongly support HB 722, which will help ensure no organization classified as charitable or any member of such an organization can evade being held completely responsible and accountable for the sexual abuse of children. The overwhelming passage of the CVA clearly demonstrated the intent of the Maryland State Legislature as representatives of the people of Maryland to provide justice for all survivors of child sexual abuse, no matter the source or perpetrator of that abuse. The defense of charitable immunity undermines and defies that intent. The passage of the CVA after so many years of struggle was celebrated by survivors who were finally told they had been heard and believed. Personally, I reacted with a considerable amount of disgust, but with no degree of surprise when the Catholic Church invoked the doctrine of charitable immunity to claim they were exempt from liability for the heinous actions committed by hundreds of priests and covered up by a string of bishops. As a survivor, I can attest that hearing the Roman Catholic Church attempting to escape responsibility for their actions through the hypocrisy of defending those actions by placing child sexual abuse in the context of their charitable mission was devastating and re-traumatizing for all survivors. Once again, the Church was turning its back on those they harmed and ignoring the lifelong pain and trauma they inflicted, this time under the auspices of being charitable. No one, no matter what type of collar they wear or what organization they might be part of, should be allowed to escape being held accountable for the criminal action of sexually violating a child. Perhaps people have different definitions of charitable. In my opinion, raping a child is not a charitable act. I urge the committee to act favorably on HB 772, and thank you very much.
Thank you for your testimony. Ms. Schindler? Ms. Schindler, we can't hear you. I think you're still muted.
Can you hear me now?
Yes, we can. Thank you.
Sure. Good evening, Madam Chair and members of the committee. My name is Jessica Shidlow, and I am the Senior Policy Analyst and Legislative Counsel for the Children's Justice Campaign at Enough Abuse. And I just wanted to speak briefly about the national perspective on HB 722. In 2023, Maryland took the historic action of passing the Child Victims Act, which made it one of the 33 states and territories that have enacted some form of revival law for child sex abuse claims. But Maryland now stands as an outlier in one critical respect, and that is that it is one of the only states that has allowed charitable immunity to block institutional accountability. So approximately 80% of states have eliminated charitable immunity entirely, and nearly all of those did so several decades ago. Only 9 states other than Maryland retain any form of the doctrine, and Maryland applies it more broadly than almost any of them. Notably, of the 22 states and territories that have enacted revival windows, not one has preserved charitable immunity. Courts in these window states simply apply ordinary negligence principles, and the institutions have adapted to that by, increasing insurance, by changing governance systems, and adopting child safety policies. Unfortunately, Maryland courts have created a 2-tiered system where Survivors of abuse at for-profit institutions can seek justice while those abused at charitable organizations cannot, not because they lack evidence or their harm was less severe, but because of this 19th century judge-made doctrine. By passing HB 722, the General Assembly would bring Maryland in line with the overwhelming national consensus that charitable status does not and should not shield institutions from accountability when they enable the sexual abuse of children. So I respectfully urge a favorable report. Thank you.
Thank you. Members, do we have any questions? Delegate Cardin?
Thank you, Madam Chair. Thank you very much for your compelling testimony. We really appreciate it. This is a question for Ms. Shinlow. Of the 9 other states that still have some degree of charitable immunity, have any of them tried to narrow it in the way that Maryland's trying to do it, that Delegate Embry's trying to do it, just for the child abuse or the
Yes.
Child Victims Act type thing?
Yes. So I think New Jersey is instructive. When they passed their CVA in 2019. It simultaneously amended its Charitable Immunity Act to permit claims against nonprofits. They did so explicitly, but abrogation of the doctrine does not actually need to be explicit. And many of the states that have passed those revival windows, their language has not explicitly stated the words, charitable immunity shall not apply, and yet courts have found that that affirmative defense is not applicable in cases of child sexual abuse.
Thank you.
Thank you. Members, do we have any other questions? All right, seeing none, thank you. Thank you both for your testimony. We are going to, and you said that you do not have Jessica, I'm sorry, you do, okay. For unfavorable, we have Thomas. Thank you, Mr. Thomas. I did you a favor and didn't try to pronounce your last name, but come on down.
It's Shetlick, 2 syllables, easier than it looks.
Thank you, Shetlick, got it. We also have online, I believe, Jocelyn Shamanowski?
Yes.
Okay, and Edward O'Mealy. Okay, Mr. Shetlick, whenever you are ready, whoever wants to go first.
Thank you. Good evening, Madam Chair and members of the committee. My name is Edmund O'Mealy. I'm an attorney in Towson. I'm here today on behalf of the Maryland Defense Council. On behalf of the private schools and other charitable organizations that we represent, we are urging this committee to issue an unfavorable report. Charitable immunity has been a time-honored doctrine in Maryland since at least 150 years. It only applies to charitable organizations that have assets that are held in trust for those charitable purposes and have no insurance. There were a lot of questions about the application of insurance, and let me give you a couple of examples. Some of the private independent schools, non-sectarian schools that I represent, never had insurance because of reliance upon the charitable immunity doctrine. But other of the private schools that I represent had insurance at one point, have insurance now, but the insurance that they had at the time of the alleged abuse in the 1970s and in the 1980s, those insurance companies went into receivership and they are no longer in existence. What do you do? Under the known loss doctrine, you can't purchase insurance retroactively. You can purchase insurance prospectively, but the policy that we have now does not cover the claims that arose in the 1970s and the 1980s, and those carriers are out of business, and we are bare without insurance. For a small private school, for a small church, for a small charitable organization, that means that that organization that is trying to defend a decades-old claim must do so out of its own resources derived from the patrons who have donated the money for that church or for that private school to pay for the defense costs, and it's an incredible burden on those institutions. I'll defer to Mr. Shetlick, but I'd be happy to answer any questions that you have.
Thank you.
Madam Chair and members of the committee, thank you for the opportunity to speak with you. My name is Thomas Shetlick, and for more than 30 years, I have worked as an attorney representing churches and other Christian ministries throughout this state. Both Baltimore City and this General Assembly have graciously recognized and honored my work in citizenship awards. My position on this bill is unfavorable, and I speak here for the churches that I serve, many of which I have met with over the last few days. These include churches in Baltimore City that serve largely African-American congregations like Mount Pleasant Church and Bishop Clifford Johnson and Genesis Bible Fellowship, to churches in Baltimore County like Perry Hall Baptist Church and Lock Hill Ecclesia, to Hope Bible Church in Columbia, to Antioch up in Harford County, to Mariners Church here in Annapolis, all of which have asked me to specifically mention their names, and I could say many, many others, but I want to give a sense of the geographic scope of this. These churches all care deeply about protecting children from sexual abuse. They all now have policies and procedures in place that guard against abuse, but they have also known and relied on the doctrine of charitable immunity in ordering their affairs. And I want to say that the doctrine of charitable immunity was judge-made back in 1853 when it began. But the Maryland Supreme Court, what used to be the Maryland Court of Appeals, has said over and over and over again that charitable immunity is legislative. That the General Assembly passed and the governor signed the bill that said that you don't get charitable immunity to the extent of insurance. And the Maryland Supreme Court has said repeatedly that that makes this legislative and that it is far more than an affirmative defense. It is far more. It is a legislative right. And what this bill is seeking to do is to go back retroactively and take away a legislative right, and no case in Maryland has ever done that, and I submit that it would be clearly unconstitutional. I would like to be able to continue and comment on some of the other things that I have heard, but I heard the gong.
Thank you. Ms. Simonowski?
Good evening, Matt Simonowski. Yes, thank you. Good evening, Madam Chair and members of the committee. My name is Jocelyn Simonowski. I'm an attorney, and a significant portion of my practice has involved the representation of religious schools and religious camps throughout Maryland. My position on House Bill 722 is unfavorable. I'm here to speak for the religious schools and camps. In coordination with my colleague, Thomas Shetlick, we have held meetings with many religious schools and camps concerning the impact of this bill. I have met with non-denominational religious camps and Christian schools in both Harford County and Baltimore County. I speak here today on behalf of Perry Hall Christian School, who has given me the authority to include their name in my testimony. Religious schools and camps place the protection of children from sexual abuse as a primary importance. They share the call for justice for the survivors and a pathway towards recovery. Over the years, I have worked with many schools and camps in drafting and implementing policies to safeguard children and to prescribe action steps in the event of an allegation. Religious schools and camps have calculated their budgets, planned their donative campaigns with the support of charitable immunity to safeguard their operations today and in the future. It is too late for them to purchase liability insurance for claims that may have occurred decades ago. Many of the schools and camps I represent were formed in the 60s and 70s. Perry Hall Christian School was formed in the 1950s. The Maryland Child Victims Act has revived potential claims dating back to the founding of these organizations, a time from which their current operations are far removed in their practices with children. As this committee is no doubt aware, it is often impossible for organizations to defend themselves in these claims revived by the Act. Alleged perpetrators are deceased, documents and evidence are lost over the decades, and the donors to these schools and camps, many of whom are your own constituents, have given their support to the religious-driven work of the organizations, not for what House Bill 722 proposes. And for this, I urge this committee to find this unfavorable. Thank you.
Thank you. Members, Delegate Conaway.
Thank you, Chair. Thank you, panel, for coming in to testify. One, I would like to know, can a nonprofit, I guess, purchase child sexual abuse claim insurance?
Prospectively, not for a known claim.
Can you currently?
Going forward, yes.
Yes. Are there policies that are available? Theoretically, yes.
What do you mean theoretically? What's that mean?
Because for many of the smaller churches, and those are the ones often that I represent that have 100 members, 200 members, financially, they can't do it. Financially, they cannot afford to purchase that. And as a result, yes, theoretically they are available, but if they were to do that, then they would stop doing the things that you heard about in the prior testimony that churches still do. Feed the hungry, shelter the poor, provide counsel within the community.
Okay. And what's the difference between legislative right versus the intent of the legislation? Because I believe you spoke about the legislative right, but I don't think that the intent of the legislation that we're discussing was to shield an entity from sexual abuse claims. I don't think.
Well, what the Maryland Supreme Court has said repeatedly was that charitable immunity was originally a court-made doctrine. It's based on the principle that money that is held in trust. Every church is in fact a religious corporation which holds all assets in trust, and all of the officers are in fact trustees. That's Maryland law. Then the time came when the law was passed that to the extent that you have insurance, you cannot claim charitable immunity, that an insurance company defending cannot claim charitable immunity. And the Maryland Supreme Court has said at least 3 times, 4 times, that was the legislative enactment of a compromise on charitable immunity, that you get charitable immunity except to the extent that you have insurance. Just like when this body said that if hospitals have insurance, they can't claim charitable immunity. They said the same thing about churches. And so what the Maryland Supreme Court said was that was the legislature's enactment of charitable immunity. And they have said that expressly. It is far more than an affirmative defense. You would be taking away a legislative right. And in terms of what was the intent of the law back when it was made, the only thing I can do is look at the words of the statute. And the words of the statute grant that immunity and put a stop on it at the point of insurance. And so when most churches have insurance, if a claim is made, then the insurance responds to it. If there isn't insurance, then the assets that are held in trust for the charitable purposes cannot be taken away, especially on a retroactive basis.
And would you say that because there's no named exclusion, that the sexual abuse claims can come under the insurance because it's not excluded?
If there is not an exclusion in the policy, yes, the sexual abuse claims can be, there often are, and this is one of the problems, and Ms. Simonowski spoke to this. We're sometimes trying to find policies. One of the attorneys up here in the prior, we're trying to find policies. And if you can't find the policy, then you're just saying, well, then you guys are out of luck.
Okay, Chair, one last question.
Yes, sir.
Suppose if the entity is not a corporation, but they're just doing business, or they're doing their charitable work, could the liability possibly be passed through to the trustees?
No, I don't. No, I don't think the liability. Assuming that the trustee himself or herself did not do the heinous act, can it be passed through to the individuals? No, I don't think so.
Don't think so. Okay.
I don't think so, sir.
Thank you very much.
Thank you. Delegate Cardin.
Thank you, Madam Chair. Thank you all very much for coming and your testimony. Tom, it's great to see you. We haven't seen you since we both had a lot more hair back then. Okay.
That was then we haven't seen one another in a long time.
So this legislative right, so quick question for you, that you believe that it may be unconstitutional. Have there been discussions about challenging this as a constitutional violation? That's question number one. And the other question for the gentleman, I forgot your name, I apologize, to your right.
Evan O'Mealy.
Mr. O'Neely. You talked about folks that had insurance, but the insurance company went defunct.
Yeah.
So they don't qualify for the immunity.
Well,
Should we be treating those institutions differently? If we pass this bill, should we be treating those institutions differently than we do ones who choose not to because either they can't afford it or because they chose to use qualified immunity as an insurance policy?
Well, in the case of the institutions that had insurance at a point in time, that those insurance carriers went into receivership and are no longer in existence. And then decades later, we have a child sex abuse claim. And so the same situation would apply as if we never had insurance in the first place.
Should we treat, because they actually went out of their way to get insurance that should have covered them, the question is, should they be treated differently than somebody who chose not to have, an entity that chose not to have insurance because they're using the immunity as their insurance policy?
No, I point that out as just an evidence for some organizations that acted in good faith in an attempt to mitigate risks, whereas others, because of their size and because of the prohibitive costs, may have chosen to rely upon the doctrine of charitable immunity, not purchase insurance in the first place, as the law allowed.
Okay, thank you.
Delegate Phillips. Were you finished? Delegate Cardin?
That's fine. I'm good.
Okay. Delegate Phillips.
Thank you, Madam Chair. Mr. Shetlick, can you talk about how these cases, my sense is you are already defending some of these cases.
We are defending, yes, we are defending cases. We are usually defending the cases when people don't have insurance or the carrier can't. It is very common.
Can't find.
It's just very common that carriers just deny coverage. They just deny coverage because nobody can find what it was back in the 70s and 80s.
So can you talk to us about the difference between having charitable immunity as a defense versus not, particularly for cases that have occurred in the 70s or the 60s, or you may even have some that date back to the 50s, as I understand.
Yeah.
How do you defend against that?
It's extremely difficult. I mean, as Ms. Simonowski said, the perpetrator is deceased, can't deny, can't say what they did. The whole generation of leadership of the church has turned over. You're talking about a generation now that's in the church, and they don't even know the people that that did this back however long ago it was. And they are trying to move forward, and they're being responsible. Churches today have policies and procedures, and what you would be doing would be punishing the generation that's trying to do the right thing. This bill would devastate. This bill would devastate small churches and small ministries. It would devastate them. They would not be able to survive. I know of one ministry that, when it was, for some technical reasons, going to lose charitable immunity because a national organization said you had to go under the law of another state that didn't have it, they just shut the ministry. They just shut it because they said, we're not going to take the chance. They just shut it. And that's not a theoretical maybe, might be. One of the people who testified before said, and said rightly, I consider the Catholic Church to be a wealthy organization. I know that there are many, many very good things that are done by those in the Catholic churches. But I'm speaking for those people who are not wealthy, and who are just going to be shut down by this. And you said churches are going to shut down on every corner, and they will. The small churches, the churches close to home. And if I can say this correctly, on the Protestant side, if you will, there is not a national group to fall back on. You're independent, you're on your own, and if they don't have the insurance or they can't find it, or if the insurance is only $100,000, they're going to shut down. They're not going to have any choice. They're going to start taking church buildings.
Thank you.
Thank you, sir.
Members, do we have any other questions? Delegate McComas.
I'll try to make this very brief. My concern is, okay, sexual abuse, when charitable immunity went into effect, was a non-existent. Okay, I mean, it probably happened, but there's nobody around that can say, hey, I was sexually abused, okay, when charitable. So my question to you is, how can then, in other words, how did we get to this point that now we're saying, well, they don't have any policies, but they did have the charitable immunity, and yet it was never thought that this was going to be an issue. I mean, this is basically a crime, okay? And this is it's intentional, and it's in other words, the perpetrators aren't around, and yet it's whoever's got some coin that's going to be responsible for it when they really weren't responsible. So it's like I have trouble trying to justify. You've got the survivors, and I know some folks that their children had. So I asked, how are they doing? And they said they don't know, and they already won an award, and it's like they worry every time they get the late night phone call, because of the abuse, because money's not going to solve it. In other words, it's them changing something inside to say, okay, I'm done with it, I forgive, I'm moving on. And that's they may make it or they may not. But I guess what I'm worried about is the fact that we're trying to deal with something that happened a long, long time ago, and there's no witnesses, and it's just. Anyway, I just don't see how this is working real well. And the other thing I think is we're going to destroy a lot of communities that are, that have the small churches and everything. It's a mess, and I don't think we know what the population is that, would be entitled to the funds. So it's like we're working in gauze. I don't know. I mean, I don't know how you do it.
I don't know if you want me to respond to that or one of the other witnesses.
Isn't that so? Yeah, I was going to say, you got to make a question out of it. Do we have a response? If not, I have a question.
Well, I would just say that I agree with the concerns that you have raised. and that it is a point was made, it's going to be a balancing. I do not think respectfully that you can go back. I think that that will be unconstitutional. I think as far as going forward with a balancing, I think that there are common sense steps that are short of the total abrogation of the doctrine, of putting limits, putting further limits on the doctrine that would work in an intelligent way, and just a total abrogation of the doctrine would not be the way to go. It doesn't. It does not try to balance the issue. It just comes down on one side.
So I have a question, and my question is, was there at the time of any of these allegations a statute of limitations for sexual assault, for felony sexual assault or felony rape?
At the time that the events happened?
Yes.
Yes, ma'am.
There were a statute of limitations?
Yes, ma'am.
And what was the statute of limitations?
Well, the statute of limitations, the general statute of limitations in Maryland was 3 years, and then it was.
You're talking about the claim. I'm talking about the criminal charge.
Oh, I don't know. I can't speak to the criminal charge.
There probably wasn't, because there isn't one now, and I don't think we've ever had a statute of limitations on the crime. So my second question is, at any time, did members of any of the charitable organizations, and I'm going to speak specifically to the Catholic Church now, when parishioners, if there is any link to any time that the parishioners might have said that they were sexually assaulted in any way, wouldn't they be protected under the criminal portion of sexual assault or rape at that particular time?
I'm sorry, I don't know who they are. Would they?
They meaning the victim. Wouldn't the victim be protected under the non-existent statute of limitations for rape or sexual assault?
For bringing a criminal, for filing a criminal claim, yes.
Yes.
They would still be able to do that because there's
Right.
no statute of limitations on a felony.
Exactly. And so is this a brand new concept that children were getting sexually assaulted and raped in charitable organizations?
I don't think so. I think terribly no.
Terribly no. So why wouldn't they have insurance? Would they not have insurance because they want to be able to rely on the doctrine of charitable immunity? Could that be a possibility?
That is a possibility, but I have spoken with churches, with many churches, and we all say you got to buy insurance. The idea of you cannot fold your arms and say, if someone slips on my sidewalk or someone, to say, I'm sorry, depart in peace, be warmed and filled. That's not right. That's not being part of the community. And so the overwhelming number have insurance. It's just that it's not enough and nobody can find it and the carriers deny it.
I'm sorry. I'm very sorry that happens. But if I, in my home, who I'm supposed to have insurance, and let's say I don't, this is a poor example, but I just want to use it just for a second. If it plays out the way I intend it to in my brain, if I do not have insurance and someone harms themselves in my home, I'm not allowed to say, oh, well, I don't have insurance. In fact, if they sue me, I may become unhoused, but that's my problem for not having insurance. Is that correct?
Yes, but you're not protected by the legislative statutes that granted charitable immunity.
And do you disagree with the previous panel that said that we have the legislative right to remove the doctrine of charitable immunity if there is a claim of sexual assault when the person was a minor?
There's no question but that the legislature has the right at all times to remove the doctrine of charitable immunity prospectively, but not retroactively. There's no question, I don't think that anyone would have, that this legislature is restricted from saying we are going to remove the doctrine of charitable immunity. The Supreme Court has said over and over, it's your doctrine and it's your statute.
But we don't have the right to remove it retrospectively.
No, I would
In your
contend,
opinion.
I would contend, Madam Chair, that no, you do not.
Very interesting. Well, I would contend that we do. Okay. Mr. Shudley, could you provide, please, at least one or two of these Maryland Supreme Court cases that you have referred to a few times? Thank you.
How should I provide them?
Well, if you send an email to the main email address on the website for the committee, we'll get it.
We will be happy to send the cases. We will be happy to send both the language, the cases, and the discussion of them. Yes, ma'am.
Thank you so much. All right. Members, do we have any other questions? All righty. Seeing none, thank you for your testimony.
Thank you, Madam Chair. Thank you to the committee.
Thank you.
Thank you.
Okay, members, that, I believe, concludes our testimony for House Bill 722. I just need to double check. Was David Lorenz ever online? No. Okay, just wanted to double check and give him an opportunity. We're going to move now to House Bill 570, Delegate Grammer. And Delegate Grammer, we have online Mr. Blevins. Okay, great.
I'll get started when you're ready.
Yep, whenever you're ready. Thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 570. House Bill 570 attempts to normalize foster care placements between adjacent jurisdictions. Kaya Ward, a youth in the care of the foster system and living in a hotel, Thank you, Madam Chair. Kaya Ward, a youth in the care of the foster system and living in a hotel, committed suicide by overdosing Benadryl. One of the many things we learned about this case is that there were nearly 300 children in the foster system housed in hotels, often supervised by untrained providers. One of the many questions we should ask, one is, why are there 300 children waiting for placement? If you're a member of the foster care community, you would ask more specifically, why are there 300 children waiting for placements while there are available host families? I am joined by Bill Blevins, who is a friend, constituent, and is also a member of the foster care community in Baltimore County. He has pointed out a major problem that leads to children languishing in the system, such as the nearly 300 children residing in hotels. We have available foster children, we have available family placements in adjacent jurisdictions, and yet we have jurisdictions that will not allow placements in adjacent jurisdictions. House Bill 570 attempts to reconcile this problem. It does so by standardizing licensure rules for cross-jurisdictional placements and clarifying that cross-jurisdictional placements cannot be denied solely based on the jurisdiction. The bill also requires quarterly reporting on available foster children and available foster families to the General Assembly. If we have children seeking homes and homes seeking children, we should not have to resort to stopgap solutions arbitrarily. I hope everyone can ask Mr. Blevins to clarify as to why these cross-jurisdictional placements are denied. With that, I'd be happy to take questions, and I'd ask for a favorable report on House Bill 570.
Thank you. And Mr. Blevins, whenever you're ready.
Good evening. I appreciate you all bearing with us. I know it's getting late. Good evening, Madam Chair and members of the committee. My name is Bill Blevins. I'm the president of the Baltimore City Resource Parents Association. I'm the vice president of the Maryland Resource Parents Association. I'm here in support of HB 570. My wife and I live in Baltimore County. 7 years ago, we chose to foster in Baltimore City because that's where the need was great. Families should continue to have the ability to serve where the children are needed the most, where the children have need the most. HB 570 allows prospective foster parents to voluntarily apply for licensures in adjacent counties and prevents denial solely because they live across a county or city line. Does not lower standards, does not expand licensing statewide, is limited to adjacent jurisdictions, and remains voluntarily. Last year, the COMAR was changed to require foster parents to be licensed in the county where they reside. That removed prior flexibility. HB 570 restores that. Baltimore City currently has approximately 1,400 youth in foster care, kinship care. The next largest jurisdiction, Baltimore County, has about 600. Under the prior policy, about 20% of foster parents serving Baltimore City youth lived outside the city, including myself, my wife. The system already relied on adjacent county homes safely and successfully. This bill helps keep kids out of hotels and hospital overstays while that recruitment work continues that Baltimore City and the other jurisdictions are now working on. HB 570 does not mandate that a county or city place children outside its jurisdiction. If there are available homes within a child's own community, counties can and should use them. The bill simply removes the barrier when local capacity does not exist, which is why Baltimore City is already placing children in adjacent county licensed homes. This does not create an undue burden on casework. They already travel across jurisdictions for kinship placements, for supervision and those type things. I look forward to answering any questions you may have about the bill.
Thank you. Members, do we have any questions? Delegate Erica?
Thank you, Madam Chair. Thank you for being here, Mr. Blevins. Can you explain to us why we changed that? So it was fine until last year, and then we shifted it, and then we lost a child in a hotel. Can you explain why that would happen?
So great question. I reached out to DSS, and they want the foster homes to be in the communities where the children are from. We do too. Absolutely. We want that. They're just not there, right? So they don't have the homes. They changed it because of that. We reached out and we told them, hey, you just lost 20% of your homes in Baltimore City. I don't have the data because that's pretty locked key for the other counties. But 20% of the foster homes in Baltimore City reside outside the city. They're not going retroactively going back, but going forward, that's 20% that you're not going to get now. And that was the only reason we were given. And they said, and I kind of called it out, they said, well, it's okay. We'll take a child from the city and we can place them in a county home, a licensed county home. And I said, well, then why can't a county home be licensed for the city, right? We didn't really get an answer.
So if they get placed in like a group home, then they will move them out of the county, but not an actual foster home?
It doesn't have to be a group home to be placed in a jurisdiction, outside the city. So if the city has a child, they don't have room, they can place the child in a county licensed home, right? So each jurisdiction does their own licensing. Again, we live in Baltimore County. We went to the city because we knew they had a lot more kids and needed a lot more help than Baltimore County. Baltimore County had a 6-month waiting list to get into a training class when we first started. Baltimore City was like, come tomorrow, right? And we'll license you tomorrow, right? We'll give you classes tomorrow. So the need's there. And again, this is all voluntary. This isn't forcing them to do anything. It's just, if I live in an adjacent county, and really for Baltimore City, it's Anne Arundel, it's Baltimore County. I'm allowed to be licensed in a jurisdiction that's neighboring.
Wow, I really appreciate you sharing the story with us and sharing what's going on, and thanks for being here.
Yeah, appreciate it.
Thank you. Delegate Woods?
Thank you so much for the bill and testimony. My question is, how much of this has to do with the trauma and drama and impact on the child? Specifically when it means children leaving out of neighborhoods, out of familiarity with friends, being put in new schools mid-school year and stuff like that.
100%.
And then being able to, and if possible, because I'm familiar with this where I currently work, the concerns of the impact on the child when the child is, it's one thing to be taken out of your home and now you're taken away from everything that's familiar to you. Then there's the cost aspect of, who's transporting them back and forth if that's the case. So if someone can address that, I'd appreciate it.
Bill, you want to start?
Yeah, I can start that. 100% agree wholeheartedly. Keep the child in the community, keep them around their neighbors and their friends and their school. There aren't homes. There aren't homes in the community right now. Again, I'm the vice president of MRPA. DHS didn't know there were open homes just waiting in other counties. Well, in the city, unfortunately, they didn't have homes. They were all full, right? Especially with teens and the struggle they're going through with there. We want them to be in the community. We want them to be around. There's just not foster homes. And look, DHS, DSS, they're pushing that, right? They're doing a recruiting effort, and we're fully behind that. We don't want them in a hotel. We don't want them going out of care because there's not a home. We don't want them going AWOL because there's not a home. We want them in a home with a foster family that can provide a roof over their head, square meals, make sure they're going to school. And most foster parents, they have no problems traveling to and from and providing all of the necessary needs for that child in care. They have no problem doing that.
That's the hole we're trying to close, is when there's not a home in a jurisdiction, shouldn't that child be placed in a home that's close? The irony is, in Baltimore County, I live in Essex, every part of the city is closer to me than Catonsville is. So while optimally we'd keep a child proximate to their community, it isn't necessarily a bad thing to be placed in a loving home that might be 20 or 25 minutes away.
And I hear what you're saying, and I appreciate what you're saying. But my concern is, and the question inevitably, I certainly agree, we want a child to be in a loving and receiving home. But even some of the children who go to loving, receiving homes are so heavily impacted a lot of time because of the trauma and the drama that they experience, that to go to a place completely unfamiliar, even with loving, supportive, compassionate caretakers. I'm just trying to understand if, in fact, that has to do with why this was changed because of the impact that it has on the child. I agree with everything you're saying, that, anywhere we can place a child where they're in a secure environment and can receive the supportive services. But I know in the jurisdiction that I currently work in, there are so many things. We used to be able to do that, and they too stopped it because it was different counties practice differently. The availability of services and getting the child to appropriate services to meet their needs. We got to the place where they said, well, you have to have a memorandum of understanding, and then we got a memorandum of understanding, and then that even fell out dealing with the other jurisdictions. So I'm just wanting to see how we make this happen, but bypass those very real hurdles, including jurisdictional challenges.
Yeah, and I found myself reading regulation regarding foster care placements. It's quite broad, but that lived experience is the experience of Mr. Blevins, and a lot of those traumas, he's taken on that responsibility with several foster care children. So, Bill, did you want to close with anything?
Yeah, Ms. Woods, I would add 100%. Right now, we're full. All of the homes in Baltimore City, and this is where maybe the sirens aren't going off enough. All foster homes in Baltimore City are full. They are actively going outside currently and placing children in county licensed homes because there just aren't homes. They don't have enough foster parents. So again, we want this. We're helping with the recruiting efforts, but right now and it really baffled me when they brought this out. Like, you literally just lost 20% of the homes when you already are maxed out and don't have enough homes. And it baffled me, and that they didn't have an answer. And that's why I'm like, well, okay, can we, Dr. Robin, can we work something out where, again, place them in the closest home, but the closest home is in the county now. Why not allow? So a good example is Parkville. Parkville kind of splits the city and county. I might live right outside the city and be closer than somebody they'll place a child with because they're in the city on the other side, right? Just because now they have to place them in the city when I'm right next door, right? Why not allow that cross licensure right there and put the child in a home because there's not enough homes.
I think, again, we should think about how we address the jurisdictional challenges. That's going to be a big part of this, addressing the jurisdictional challenges and the fact that different jurisdictions have different requirements.
Yeah,
Wouldn't you agree?
I would agree. Thank you.
I had to make it a question.
And I appreciate your experiences, too. Thank you.
Delegate Valentine?
Thank you, Madam Chair, and thank you, Delegate, for bringing the bill. I just want to clarify very quickly. So this process had already been in place of being able to foster individuals in another jurisdiction. Is that correct?
Bill?
You say no?
That's correct. In Baltimore City, you used to have to be adjacent county. Then they changed their policy. You had to be 10 miles a range, and now they changed the Comar, and now it's there. They went back and forth because when they don't have the homes, they just changed the policy. Now they put it in Comar, and they're stuck.
How recent was this change? When did this change occur?
This Comar change was December 12th of 24.
24. So this leads to my last question for the delegate. I'm looking that DHS is going to need all this additional staff to revert back to a policy that they already had. Why would they need additional staff when they were just doing this last year?
It doesn't make sense, but honestly, that's part of why I need the help of the committee to circle this square and figure out how we can normalize this as opposed to changing the rules every year.
Thank you, Madam Chair.
Members, do we have any final questions? Seeing none, that concludes our testimony for House Bill 570. Thank you. And includes our bill hearings for the day. Have a good evening.